last thing. There we go. Okay. Once again, folks, sorry for the late start. We needed to get all our inmates up. So this is a final plea calendar. For those of you who are defendants in the courtroom, this is the last day in which you can enter a plea if that's what you want to do, and have the ability to withdraw that plea if the sentence you receive is more serious than the one your lawyer asked for. So I'm going to hear from the lawyers about how we're doing, whether we're trial ready, et cetera, and see if these cases are resolving. And if they're not, we'll get on the record what the state's offer is, and that the defendant is knowingly saying no thank you to that offer. And then we'll get the case on a trial calendar. So our first defendant is the first two positions, and that is Mr. Davis. Ms. Feely, you represent him. And who is sitting in for Mr. Shapiro this morning? You are, Ms. Willingham. All right, great. Can we bring Mr. Davis out? Is there an announcement before we do that?
There is, and I don't expect to do this. I know it's not a great way to start the calendar, but Mr. Shapiro has been on trial, and he did give me an offer late last night that I haven't relayed to Mr. Davis, and I appreciate his efforts and all for getting it to us late, but we would just simply request that because it does involve significant serve time.
Sure.
That if this is workable, that we would be allowed to request a plea date, another final plea date before the trial calendar.
Sure. Understandable, reasonable. It's hard for a defendant to digest a large number on short notice. And just looking at these charges, I could understand why it might be a large number. Do you want a chance to talk with Mr. Davis before we bring him out so that he doesn't hear this number and say, lady, what?
Yes.
Okay, so why don't we hold on Mr. Davis? Are there any other clients of yours where you've got the same request? So this poor deputy is now going to get Mr. Davis, like, oh, false alarm, send him back.
The position is with Mr. Bonnie. I don't have an offer. It is a murder case though. So we can kind of go back and forth in just the same request if it's workable, if we get to request a final plea date.
Okay.
Mr. Bonnie's busy as well.
Yeah, so I've heard. He's wearing a dashing blazer today. So I didn't see the pants, but okay. You got pants that match that. Is the offer for I don't know anything about this case. Is the offer life in this case? Okay, so we can bring Mr. Simpson out. I mean, that's not going to be a shocker. We'll go in order, but if Mr. Abadi were to have said, hey, the offer is 15 years, then I'd want you to have time to work with him on that a little today. Okay.
Judge, me and my student have to cover, and Judge Ingram, for a quick motion to suppress. Can I be back in 20 minutes?
In when?
Right now, I'm supposed to cover.
No, I know you need to go. I didn't hear when you'd be back. That's fine. Now that we know that the offer is life, one of the other ADAs could cover it if we get to Mr. Simpson. Unless you need to be here for it, I'm happy to slide it to the back. Okay. All right. Good luck in 7E. Yikes. Okay. Well, let's turn then to Mr. Furlow. Any reason we can't do Mr. Furlow?
I don't believe he's here, Judge.
Oh. What? Okay, any idea why he's not here?
Mr. Furlow has, I know, Cobb and Cab, at least, he still has outstanding matters there. I believe he's loaned out to one of those places for that court date.
Okay, so it does say loan out, but sometimes to me that just signals that's where he's being housed, like some of your other clients that maybe you can learn. I think Ms. Bumpus is going to be here today. She can tell you how she gets back there. But that's not Mr. Furlow. Mr. Furlow is actually taking care of business in Cobb.
He's taking care of business, however, this will be a plea. People and I worked it out yesterday. I already know that it will be a plea based on previous conversations with Mr. Furlow. So if I can just get with Ms. Nelson to get a date, we should be able to take care of this one.
So great, thank you. Would you want Mr. Furlow here? So we should do a production order, or should we figure out a way to get him on a screen?
I think it'd probably be best if you were here.
Okay. So we will either pull him back if we loaned him or borrow him and handle it that way. All right. So Mr. Furlow is a plea. Does he not have co-defendants?
He does.
Is that Raven Young?
And Belcher is the other one.
Okay.
One is on afternoon calendar.
I think Ms. Young may be, I think she's represented by Ms. Mignot now, and Ms. Mignot is in trial. So I don't know if Ms. Young is showing up, but I just want to make sure that was all if I was remembering correctly, it's the same case. But you're obviously focused on Mr. Furlow. It's a plea. We need a production order and a date for a plea. Okay.
Thank you, Judge.
You bet. Okay, how about Charles Burkott Dukes?
That is mine, and number 5 is the co-defendant, and they are both on Zoom, and Mr. Burkett Dukes is the one that was shot and has significant medical issues that he wants to make the court aware of that we've dealt with before, but he just is not able to travel. And this was the only way he could appear. He is also out of state.
Okay, let's get him. There he is. That's Mr. Burkott Dukes. And where is, and who represents Mr. Gruyan Paniagua?
That would be me, Your Honor. Good morning, Madeline Pavon-Suriel.
Good morning.
Good morning. My client is on Zoom as well.
All right, I need him to start his video. And Mr. Burkott, can you mute your phone right now, please? There's some background noise. Thank you. There's Mr. Gruyan. Let's add him. Okay, I think we've got everyone. Ms. Pavon-Suriel, where is your client?
My client is in Orlando, Kissimmee, Florida.
Okay. And Ms. Feely, Mr. Burkott is where? I think you said that. All right. We had someone else from Colorado yesterday. All right. Mr. Peoples, there's no Mr. Jordan here today. So if I see Jordan, it's Peoples. All right. So let me explain what we're doing. Mr. Gruyan, can you hear me? It looks a little frozen.
Yes, I can.
You can hear me. Great. And Mr. Burkott, can you hear me? You can just raise your hand. Great. All right. Let me explain what we're doing today. I'm going to hear from your lawyers whether you've got all the discovery and this case is ready to go to trial. And if it's going to resolve today, that's great. If it's not, I'm going to have the prosecutor, Mr. Peoples, put on the record what the offer is. You're going to tell me that you're not interested in that. And then we'll set a trial date. I think you're already on a trial calendar for July, 1 month from 2 days ago. So about 30 days from now, you all will need to be here, not in Colorado, not in Kissimmee, but in Atlanta, Georgia for the trial if the case hasn't been worked out. But why don't I start with you, Ms. Feely? Any reasons this case couldn't go to trial, apart from Mr. Burkott's medical condition, which we can talk about offline, why this could not go to trial in June?
Nothing. The only issue that I wanted to pull up and make sure is my link is expired. I do think that link contained what appeared to be full discovery. So I would just ask Mr. Krause to resend the download link.
Can you turn your microphone on, please? Thanks. All right. So Mr. Peoples, you can resend. I don't know if you have to regenerate a link, but if you can get that evidence.com link.
I will do that, Your Honor. And I think Attorney Suriel is going to need the exact same thing as well. We were in brief communication, so I'll be working on that today.
Okay.
I didn't know Attorney Feely needed as well, but.
Great. So send to one what you send to the other.
Yes, Your Honor.
All right. Ms. Pavon-Suriel, how are you doing with discovery? Same issue, that it's an expired link?
No, Your Honor. Actually, I just have several links that I'm unable to access. I have accessed some of the links, but I filed a notice for discovery deficiency and a motion to compel discovery yesterday. I'm missing some critical things like the defendant's booking photo. I don't have any defendant statements. I don't have interview videos. I don't have lab results of evidence that was seized at the scene.
That's just me.
Hey, Mr. Runes, you need to stay on mute. All right. So how long have you been on the case?
I've been on the case since February, Your Honor. The first time I got any type of discovery was April the 4th, and all that's indicated in my motion. But on April the 4th, I received partial discovery. When I contacted ADA Jordan, after that, I received more discovery on May the 18th. And I have since tried to contact him about some of the links not working and that type of thing. But with the transition of Mr. Jordan, I haven't been able to narrow down, exactly what I need. And, we just our offer was just communicated to us yesterday. So it's been a little challenging with the DA's office transition to get a hold of everything.
Okay. I'm just pulling up the case now. Gosh, there's another defendant. Oh, he's a fugitive. Okay.
But he does have retained counsel, Your Honor. I did go online and notice that Mr. Logan does have Mr. Apt is retained counsel.
Yep. So in February, on Valentine's Day, a scheduling order was entered, and discovery was due to you by early March. And are you saying you reached out then? Because it's just late in the game to be getting this discovery deficiency. This is something that you should have. I want to be clear. I'm not saying that the state did a great job of getting you materials, but it's a two-way street. And so if we're on into April and you're not getting what you're entitled to, then that's when the discovery deficiency notice should be filed. So I'm aware of it, and I can lean on the state to say, hey, you need to provide this, or apparently you're just not going to use it. And so here we are. Trial is about a month away, and I'm only hearing from you for the first time. I don't have much of what I'm entitled to. Any reason you waited until June 7th to file the motion to compel?
Well, as I mentioned, Your Honor, the first discovery was late. I didn't receive it. It was due in early March, and I didn't receive it until early April when I reached out. Then again, I reached out to the office to get additional discovery, and I received it May 18th. And that discovery also had issues. So I wouldn't file a discovery deficiency with the court until I've exhausted all my avenues with the DA in terms of just getting me the information. My goal is not to delay the court proceedings, is to obtain the information my client needs. So that's why it's June 7th before I'm like, okay, I'm definitely not getting all the information that I need to properly defend my client. So we have court tomorrow. Let's file this motion because I've exhausted every avenue.
Okay. In the future,
I can't keep asking to stay.
Exactly my point. And they had a deadline, and when they missed the deadline, that's when it's time to reach out to me. So next time, let's do it that way. That's the point of the discovery deadline. Ms. Feely, I know you said you have a link that doesn't work now. Are you in a similar situation with Ms. Pavon-Suriel where you actually don't know what you don't have because you haven't had a chance to look into it?
I didn't flag anything on my first round of going through the discovery. That was a few months ago now, but I don't remember seeing anything that, I don't think my client gave a statement, for instance.
Okay.
So I didn't flag that as something that was missing.
Mr. Peoples, Ms. Pavon-Suriel has suggested that client gave a statement, that they're scientific reports in an armed robbery case. What is she speculating that that's out there, but doesn't know because she hasn't received it? Or is she latched onto something that she's of course entitled to and doesn't have?
So, Your Honor, as I inherited these cases, as I go through them, I can't specifically tell you which ones I've got 100 of them rolling around in my mind, but I will look at the files themselves today and be able to give you a definitive answer. I know that Attorney Jordan has done his best, and I think that, knowing his past work, I'm sure this was just an oversight. But I will work today to fix any holes in discovery.
Okay. Let me look at one other thing. So it's Sandy Springs PD. I don't know if that raises your hopes or lowers your hopes about getting discovery you don't have. But just so you know, it's Sandy Springs PD. So here's what we're going to do. And I don't want this to happen again in this case, other than Mr. Apt, who is going to be working on a different timeline because his client is a fugitive right now. We will reset this for a final plea calendar in the near future. Mr. Peoples, you will, by the end of this week, well, it's Thursday, by early next week, have pushed out new links to these two lawyers. Ms. Feely, if your link doesn't work, email me, Ms. Nelson, and Mr. Peoples. Hey, this link doesn't work. Ms. Pavon-Suriel, same thing. Don't wait. You're going to get these links, and if you can't access what's in there, you're welcome to reach out to Mr. Peoples to say, how do I do it? But I don't want to have our next final plea be something where you're telling me you don't have something. I need to know that before then, so that I can set a deadline for Mr. Peoples to say, if it's not to the defense by date X, then you're not going to use it. If it's exculpatory, you still need to go get it. But if it's inculpatory, that's just a piece of evidence you're not going to be able to use should this be a case that goes to trial. If this case is resolving at final plea, I need your clients to be here and not be virtual, unless there's a medical reason why Mr. Burkott can't travel. I'm not hearing that Mr. Gruan has any medical reasons, and I appreciate he's at home or at work in Florida and shouldn't come here if it's just a hearing where we say hi to each other. But if we're resolving these cases, or at least one of the defendants, that defendant needs to be here for the next final plea. I will get a date from Ms. Nelson. We'll put that out there, but I will make a note in red on my calendar that discovery will be resent by you won't be in trial next week. Are you going to be second chairing?
No, Your Honor, not until the 27th, but I can make myself available, whatever the court needs.
No, I don't need you to come to court. What's happening on the 27th?
I'm sitting second on a. Oh, nothing, Your Honor, nothing in here. You asked if I was sitting second. I'm sitting second somewhere else.
Okay, that's okay. All right, so the 13th, June 13th, by June 13th, let's get those discovery links out again.
Understood.
And we will reset this for another final plea, a last final plea. Ms. Feely, anything else you want to get on my radar in connection with Mr. Burkott Duke's case?
No, I think his medical issues, the court's aware of. So.
Well, we'll talk about him not in this setting. He's going to need to be here, obviously, if there's a trial, and unless his resolution is dismissal or misdemeanor probation, he'll need to be here. So I want to make sure we're scheduling this in a way that is conducive to him getting here, assuming he can get here.
Understood. Thank you.
Okay. All right. Ms. Pavon-Suriel, anything else I need to know about?
Well, Your Honor, I think that there may be the opportunity to file motions in this case. So if it please the court, I would like a motions date. You
had a motions date. You had a motions date on the scheduling order. It had a motions date, which was why you were supposed to bring to my attention through a discovery deficiency notice before the motions date. Hey, I think my client gave a statement. I can't file a motion to suppress it because I don't have that statement. So what I'm going to give you is a deadline of June 19th to file any evidentiary motions. That means if you don't get discovery by June 13th, you're letting me know so we can work through that. And we'll figure out if there are motions that need to be heard before trial.
Sounds good, Your Honor.
And what we're going to do is keep both these defendants are on the July, the July 6th trial calendar. I'm going to keep them on the trial calendar, not for trial. That will be your new final plea date. So you already have a calendar out there, and you will need to be here if you're resolving the case. So that's July 6th will be when we have our final plea date. The one caveat to that would be if Ms. Pavon-Suriel files an evidentiary motion that looks like it would materially influence whether Mr. Grullon gets a different offer or whatnot, we might have to move it a little bit, but put on your calendars. You'll get notice anyway if we haven't published it, it will be published. Has the July calendar already been published? Yes. All right. So you've already gotten it. It's on your calendar. It should be. So we'll see everyone again on July 6th. Just know I will not be calling you all out for trial. That'll be the new final plea date. So June 19th for any motions to be filed, other than motions in limine, which we would handle on the eve of trial. And then the new final plea date is July 6th. All right, Ms. Feely, anything else?
No, Your Honor. Thank you.
Ms. Pavon-Suriel.
No, Your Honor, that concludes my business.
All right, you and your client are excused, and Mr. Burkott, you're free to go as well.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. All right. Next up is Francisco Arias. I am not seeing him here. Ms. Nelson, did you hear anything from Mr. Ghazi, or should we be seeing both Mr. Ghazi and his client right now?
Let me double check, Judge.
Okay. There's nothing in the docket since the scheduling order. Have you had any contact with Mr. Ghazi, Mr. Peoples?
I spoke to him very briefly yesterday when I stepped out. And I believe that we would have come to something, but I can't recall if it was him or another attorney who was saying they had filed a leave, but I don't recall if it's him or not.
Okay, he has not. There's the last thing filed in this case was the scheduling order in March. More importantly, his client is not here. So he'll have the rest of the morning. Otherwise, it'll be a bench warrant for Mr. Arias.
Understood, Your Honor. And at the break, I'll reach out to his office again.
Okay. Dondre Frazier. Oh, I have notes about that. This is a plea. He is in Tennessee, and
Mr. Wright is I think he's starting trial.
right. He's picking a jury today with Judge Richardson. So this is your case, and you agree it's a plea. So we just need to set a date and figure out a way to Zoom Mr. Frazier in.
Yes.
Okay. All right, Kenneth Simpson. Ms. Feely, we'll bring Mr. Simpson out, and one of the prosecutors can play the role of Mr. Abate in his plum suit.
email. Resend it today.
Also, we don't-
Yeah, that is helpful.
Good morning, Mr. Simpson.
Good morning, young man. How you doing?
I'm all right. Let me make sure. We have an update on Mr. Arias. We'll do that in a minute. Ms. Rivers, are you ready?
Yes, I am. Good morning.
Good morning. All right, we're here on 22 SC 185510, State versus Kenneth Simpson. Mr. Simpson is represented by Ms. Feely, who is here standing with him. Mr. Simpson, today is your final plea date, which is the last day that you could enter a plea, if you were interested in entering a plea, and withdraw that plea if the sentence I gave you, bless you, was more severe than the sentence your lawyer asked for. Your situation is a little complicated because you're charged with murder. Unless the state is going to reduce the charges, your lawyer cannot ask for less than life because I can't sentence you to less than life. I think that's what the state is offering right now. But we're going to go through this process because I need to make sure you're ready, your lawyer's ready, your case is on my next trial calendar, your first trial calendar, which is about a month away. So I need to make sure we are on a good glide path to being able to go forward on that calendar. Ms. Feely, do you have all the discovery that you're aware of existing in Mr. Simpson's case?
I believe so. And the only thing that we would ask for is Mr. Body, again, I know he's very busy, but we didn't get it till last week. And
He's now behind you, so speak nicely of him.
yeah, so I'm diligently going through it, and my intern actually is going through some video footage that I think we may need a motion a motion for immunity. And I know it's not timely, but we would just ask for an extension if it turns out that we need one.
Sure, and immunity is immunity is immunity. I mean, it has to be heard before trial anyway. And if it's predicated on video you only recently received, then there we are. So your office, your team is reviewing that now, and you will let Mr. Abate and me know promptly if you think that your review of that supports an immunity motion.
Yes, and otherwise we will be ready.
Okay. If you file that, it will probably mean that Mr. Simpson's case comes off the July trial calendar. It's not a penalty. It's just the reality of when could we schedule that. And we've got a judge who's helping with some motions like that as well, that might make it happen sooner. But either way, I don't know that we could get the immunity hearing in plus a ruling before that July calendar, just so there are no surprises.
Understood.
Okay, but much better that you let everyone know now than on July 5th. Oh, hey, immunity motion. And then Mr. Abate's been getting everyone lined up for that trial and we can't go forward.
I'll let you know as soon as.
What is a reasonable deadline?
The two videos, one is 50 minutes, one is 58 minutes.
5:0 and 5:8?
Right.
Okay.
They're less than an hour each. So I expect we have unfortunately something on Friday, but I expect to be able to have something early next week if I'm not trying Mr. Dill.
Okay. Are they just two different angles of surveillance footage, or it's actually two consecutive hours of footage?
The one is outside the apartment complex or the house, and then one is inside that shows a view of like the kitchen area.
Okay. All right. And I know you maybe haven't watched it yet. I appreciate that it might be 50 minutes long. From my limited experience, something happens real quickly. And so even though it's 50 minutes long, wouldn't you expect that it's actually like 2 minutes or less that you're watching? Or this was like for 45 minutes, people are grappling?
So the outside one I flipped through, I think it is very compact, the relevant portion. The 50-minute one, I also kind of flipped through and it does seem like there's action in it.
Various episodes. Okay. All right. So you may well be in trial next week. I want you to be focused on Mr. Dill. His needs are more pressing than Mr. Simpson's right now. Unless you know something about Mr. Dill's case, I don't know.
Unfortunately, I did not.
Okay. All right. Then why don't we say, looking at the calendar, like the 21st of June, that's a week from 2 weeks from yesterday. So 2 Wednesdays from now. All right. Because that way, if you file it, everyone can know, don't get Mr. Simpson's case ready for trial. We'll get a date for immunity. 21 June. Okay. Anything else on behalf of Mr. Simpson?
No, yeah.
All right. Mr. Abate, my understanding is that the state's offer, if Mr. Simpson wants to avoid the vagaries of an immunity hearing and ultimately trial, is life at this time. Is that correct?
It is, obviously the state's open to a counter offer that's less than life.
But right now, there isn't a plan to reduce charges. So if Mr. Simpson said, I'm ready to plead, he'd be pleading to the indictment.
That's correct, John.
Okay. So
There is outstanding ballistics evidence, which I'm sure you expected. The GBI, I've given them 30 days for the last 2 consecutive 30 days to try to get it tested. So we're gonna have to, use the private lab again. It should be done prior to the 21st is my hope, if I can get it in this week.
okay.
And I apologize, the discovery was turned over later than expected. We've had some turnover with our legal assistant. So I actually did it myself and was able to get it to Miss Feely last week while we were in trial. So I apologize.
I appreciate you taking over that responsibility as well. May your legal staff be replenished soon. Is this a case, Mr. Abate, that you think the ballistics evidence is central, or obviously you're entitled to it and the defense is entitled to it, but it's something that would sway either the outcome of an immunity hearing or ultimately a trial?
I don't think it's central. It's obviously something that both sides would like to complete the story for a trial.
Sure.
As it pertains to the immunity motion, there's no evidence that there was any other shooters than the defendant. So I don't think it's going to make a huge difference as it pertains to immunity.
Okay. Your understanding is there's only one gun involved in the situation, that if there's an immunity motion, Mr. Simpson is going to be attaching himself to that situation. It's not some other guy did it. It's, I did it in self-defense. Okay. Ms. Feely, do you have a similar view on the importance or centrality of the ballistics evidence? That won't cause you to have to file another motion if it trickles in a little late.
I would be shocked.
Okay. All right. Unless it says that it was a 30-06 round. Like, well, there's no rifle in the room. Okay. All right. So Mr. Simpson, I'm assuming you're not interested in pleading to the indictment as charged for a life sentence. Is that correct?
Yes, sir.
Okay. So here's what's going to change after today. It may be that your lawyer and you come up with a counter proposal. It sounds like there was a complicated situation going on inside that house. And Mr. Abate's had a chance to look at that video, and he may agree that it was a little complicated. And so your lawyer may offer a way to structure this where it's not life, it's something less. And Mr. Abate may say, great, we'll do that. We'll reduce a charge and we're going to recommend this number. I will take that plea. What changes after today is your ability to say, no, thank you, if you don't like the sentence that you get. So I'm going to give you a hypothetical. What often happens is that murder is reduced to voluntary manslaughter, that it was a shooting in sort of a fit of passion. You were arguing with someone and it escalated. And so it doesn't justify it, but it lowers the culpability a little bit. So voluntary manslaughter is 1 to 20. And it may be that what you all negotiate is 15. And so the recommendation to me is 15. I may look at it and watch the video because you all asked me to do that. And maybe I learn a little bit more about you. And I might say, I'm going to still give you 20 because voluntary is 1 to 20. That's going to be your sentence. You don't get to say, oh, whoa, I said 15. Otherwise, I want a trial. Today, you could do that. You could back out of a plea. But after today, you are able to enter a plea at any time. That's your absolute right. And maybe your lawyer gets the state to restructure things so that a plea is something other than life. I'll still have the ability to sentence you within whatever the statutory range is. You will not have the ability to say, well, if it's not 15, then I want my trial. You understand that?
Yes, sir. You're
Great.
honest and fair. I believe in you.
Okay, well, thank you. So I will see you, Mr. Simpson, either on July 6th when we call the trial calendar. That won't actually be when your trial starts. It would start a few days later, but you'd be back here. We'd make sure everyone is really, really ready to go. Or because Ms. Feely decides to file that immunity motion, you will get in front of a judge, either me or a colleague of mine, so that Ms. Feely can argue that forget about murder. Mr. Simpson shouldn't be charged with anything because he was absolutely justified in what he did.
Yes, sir.
And some judge is going to need to watch that video, hear from witnesses, maybe hear from you. That's a decision you and Ms. Feely will make. And then that judge will decide, yeah, you have a self-defense argument, but this wasn't sufficiently justified that the state is barred from prosecuting. Okay, any questions?
No, sir.
Ms. Feely, anything else?
There you are.
Mr. Body? All right, thank you.
Have a good day.
And that completes my business till 1, out of you.
Yes, sir.
Thank you very much.
Sorry, we didn't consolidate everything to the morning, but we'll see you at 1.
Maybe I'll change my food.
No, it's beautiful. The crowd loves it. All right, that gets us to Elijah Sharp.
He's here, Judge.
Hey, Mr. Sharp, good morning. I'm doing all right. Why don't you come sit with Ms. Wood, please? All right, we are going to get on the record. In your case, it's 23 SC, 185621. Ms. Wood, are there any discovery issues or other procedural issues with Mr. Sharp's case?
No, Your Honor.
Okay, he is on our July trial calendar. Mr. Sharp, I'm going to ask Mr. Peoples in just a moment. What is it, Mr.? It's yours.
88 Willingham.
Okay, I started looking down at the charges. It says Jordan on it, but the charges don't seem like Jordan charges. All right. I'm going to ask Ms. Willingham what the state's recommendation is, and then I'm going to hear from your lawyer and ultimately from you what we're going to do today. Ms. Willingham, if Mr. Sharp wanted to resolve his case today with a plea, what would the state's offer be?
Your Honor, the state's offer was going to be to null price counts 1 and 6, and for a sentence of 5 years to serve 6 months. And in our formal offer, the state was open to that 6 months being done on the weekends.
Okay, and by that, did you mean over, if the sentencing were today, over the next 6 months, every weekend in custody, or was it actually 180 days of weekends, which is 90 weekends?
Over the next 6 months, every weekend.
Okay, got it. Mr. Sharp, do you understand what the state's offer is today to dismiss some counts? More importantly, the recommendation is that you serve some time in custody and then you spend more time on probation. You understand that recommendation?
Yes, Your Honor.
Okay. Ms. Wood, have you and Mr. Sharp had a chance to talk about that?
We did, Judge.
Okay. Mr. Sharp, is that, and well, here's what would happen today if you entered a plea. Your lawyer would make her own recommendation. It may be that the way it's negotiated, she'd need to agree with the state's recommendation. If I were to sentence you to anything more than what your lawyer recommended, you would be able to withdraw your plea if that's what you wanted to do. If I sentenced at or below what your lawyer asked for, then you stick with your plea because you got what you asked for. After today, you can still enter a plea, and the state's offer may change. It may get worse for you. It may get better because they learn more about the case, but this is their offer as of today. And when you leave here today, if you don't enter a plea, like I said, you could enter a plea later on, but what changes is whatever sentence I give you is the sentence that you have. You would not be able to step back from it if you didn't like the sentence that you got. Do you understand what changes?
Yes, Your Honor.
Okay. Given all that and your understanding of all that, do you want to move forward with a plea in your case, or will I see you on July 6th when we call the trial calendar?
You'll see me on July 6th.
Okay, let me check one thing. Ms. Wood, anything you want to add to this situation before Mr. Sharp goes?
Judge, the only thing, he had asked me to raise the issue of his ankle monitor. I understand that we're a month out from the next trial date, the court may not be inclined to modify a bond, but I did want to raise that on his behalf.
Sure, fair request. Mr. Sharp, if we don't resolve your case either by way of a plea or a trial on that July calendar, we'll talk about what to do with the ankle monitor. But for the next 28 days, I'm going to have you keep that on. And let me look at what exactly your bond has changed a bunch of times. You've been able to travel. How long have you had the ankle monitor on?
7 months.
7 months. One time you were not allowed to travel, and then one time you did get to travel. Why do you need to travel so much?
He had to travel, ADA Weiner and I modified the bond in the spring because he had to attend the birth of his child in Chicago.
Okay. Good trip?
Yeah, great trip.
Good. You've had a complicated bond history. Just trying to find your bond. So you used to have to stay away from Rambling Road, but now you can be there because that's your own house.
Nah, Rambling Drive is where the incident occurred. And that's where I stayed at. It occurred at my house.
Right. And are you back there?
No.
You don't live there anymore? I've got you in an apartment on Piedmont. Is that correct?
Yeah.
Okay. All right, well, I can't find your bond. I know there's one there because there've been like 19 motions to modify it. Keep complying with it. Stay at that address on Piedmont. Don't leave the state unless you get permission. I will see you in 28 days-ish, whatever the math is, for the call of the trial calendar. Unless before then, Ms. Wood and Ms. Willingham work something out, and then let's get you in here and take care of that. Ms. Wood, please remember to bring up the ankle monitor. That'll be 8 months or 9 months by the time we get to July. And unless the state is able to bring forward concerns on the part of, it's an ag stalking charge, so I want to be thoughtful about how we handle this. But if there have been no issues for the alleged victim in this case, then it may be time to address the ankle monitor. Okay. Ms. Willingham, anything else for the state?
Nothing further, Your Honor.
All right. We'll see you in early July, Mr. Sharp.
Thank you, Your Honor.
You're welcome. Samantha Harley. I saw Ms.
Morning, Judge.
Kim. There's Ms. Kim. Hey, Ms. Kim, how are you?
Good, how are you?
I am well. How is your client?
Wish I knew. I called her mom and not heard from her or her daughter. Is she in the courtroom? Samantha Harley, are you in the courtroom?
I took care of that for you. There is no Ms. Harley here. This says Ms. Hall on it.
It is. It's going to be ADA Hall, Your Honor. I was going to ask to hold for her report, but if Ms. Harley's not here, I have no problem asking for a bench warrant.
Okay. That's what I'll do, especially given the nature of the charges. And I appreciate Ms. Kim sharing with me. She's trying to find her client too. Maybe we can all collaborate on tracking down Ms. Harley. Ms. Kim, is your primary point of contact for Ms. Harley her mother? That's how you usually find her, or that's your backup?
That's how I usually find her. She's
Okay.
the one who usually hired me and when her daughter was in custody, but it seems like mom's changed her phone number or something.
Okay.
ADA Hall has reached out to me. I know she's in various courtrooms. I'm just waiting to hear from her and hopefully at least we can solidify a deal once I find my client.
Sure. So what we'll do, if you track Ms. Harley down and there was a pretty good reason as to why she wasn't here, reach out to Ms. Nelson and we can do a walk-in and manage it that way and maybe lift the bench warrant. But I'll ask Ms. Willingham to let Ms. Hall or someone know that we ought to do a bench warrant for Ms. Harley.
Thank you, Judge.
All right. Thank you. Good seeing you. You're free to go.
Oh, Judge, do I need to appear in July for the calendar call or no? If We can't find her.
No, if she's still in bench warrant status, you don't need to be here for that. You should just check with Ms. Nelson sort of on the eve of that calendar.
Okay, great. Thank you.
You're welcome. Thank you. Let's go back, Mr. Peoples. Mr. Arias is in custody. He is at Augusta Medical. And Mr. Ghazi didn't file anything, but he did reach out to Ms. Nelson last week. Ms. Nelson was on leave, but he sent an email saying, could we continue this? So please don't do a bench warrant for Mr. Arias, but please do talk with Mr. Ghazi. I don't know how long Mr. Arias is going to be in custody, but looking at what these charges are, if he is going to be in DOC custody for a while, this seems like an easy one to resolve, and he can appear via Zoom and we can handle the plea that way.
Correct, Your Honor.
Great. Okay. Moving along. Mr. Rumley.
Because I believe he's on Zoom.
Okay,
And if I may, I need to, after the call, if I could step out and call him and then come back and give you my announcement on this one.
okay. All right, so are you,
me.
yeah, are you Mr. Rumley?
Yes.
Okay, we've got a tough connection for you, but what I'm gonna have, Ms. Wood's gonna give you a call. Ms. Wood, do you have a good phone number for him?
Yes, Judge.
All right, she's gonna give you a call, and then she's gonna come back in here and let me know what's going on. I'm not quite sure where you are and why you aren't here. But I'll let Ms. Wood talk to you a little bit about that and see if I end up being okay that you are driving around wherever you are. Okay?
Thank you, Judge.
Yep. We'll come back to Mr. Rumley. Tony Miles. Hold on one second. I'm trying to, I guess it's just coming through slowly. I muted him a while ago. Okay. All right. You are here for Mr. Miles. Great.
We're asking for another final plea date. This is our first final plea. And the main reason we're asking for another final plea is we received an offer last week from the state. I had a chance to discuss it with my client and we're prepared to go to trial. However, I'm in the process of looking for an expert witness. So I'm going to need time to secure an expert witness and have that expert witness look at the medical records. So we're asking for another final plea so I can get that done.
So probably no to that, because what I'm hearing you say is you are going to go to trial and the expert doesn't have anything to do with final plea. The expert would be someone you would rely on at trial.
Correct, but I'm not ready for trial because I have not hired him.
Okay, well, fortunately for you, trial's not tomorrow. Trial for Mr. Miles is a month away.
Correct, Judge. However, I'm assuming the expert's going to need time.
Are there a lot of medical records in this case?
Depends on what you call a lot, but no, my responsibility.
Okay, I would think not either. I'm just looking at what the charges are. So there might be some, but every case is different. Have you identified an expert yet?
No, Judge. We just got an offer last week and we just decided to go to trial.
Okay, well, why don't we do this? Let's get on the record what the offer is and your client's rejection of that offer. And then we can talk about timelines, because the next date would be to get Mr. Miles in here on July 6th for the call of the calendar. I'm hearing you say that's too soon, but we're going to need to lock in a date after that. Mr. Miles has the luxury of being on bond, and I'm not going to extend this too far out. An expert I don't know how long you've had the medical records, but unless you just got the medical records, that is something you could have been exploring before you got the offer from the state, unless you had been led to believe that this was a easily work-outable case.
Judge, it's a money issue.
Okay, got it. Okay. Well, let's get you and Mr. Miles up at the podium, please. One second. Let's see what's that here. All right, Ms. Rivers, you ready?
Yes, I'm ready.
Great. Mr. Miles, this is 23 SC 185753. And I've been listening to your lawyer about his thoughts about what he needs to do next. Let me find out from him if he, do you have, let's get your name on the record as well.
Andre Sailors, Sailers, Senior.
Is a colleague of yours, Mr. Granville, or have you replaced him?
No idea who Mr. Granville is.
Okay, well, me neither. You didn't look like Mr. Granville. You look like Mr. Sailors to me. I didn't want to get that wrong. Let's see what the docket says.
That was his previous attorney, according to my client.
Okay. When did you enter the case?
Judge, unfortunately, I do not have my file. I came from another court last night and didn't have a chance to go to my office, so I do not know.
Okay.
My client can enlighten me. When did you guys hire me?
I don't know.
You remember when you guys hired me? February.
Okay, I see I granted in February the motion to let Mr. Granville withdraw. So I'm going to ask you to file, do we have entry of appearance forms here or
Think so?
are they just waiver of arraignments? We don't obviously need to do that.
I'm sure I filed an entry of appearance, but I don't.
Didn't. I'm looking.
It may not be in the system, but I sure I
Well, if you filed it, it would be in the system and it's not.
presumably.
That's where we are. But I take it back. It is in the system. You filed it, so there was an overlap. This is why the system is showing it the wrong way. On the 9th of February, you filed your entry, but Granville didn't withdraw until after that. So we'll fix it internally. It needs to not publish with Granville. Is Mr. Lewis here? Did he get brought over again? Good. Okay. If they can take you, that's great. All right. Mr. Sailors, my mix up here. Do you have all the discovery in this case?
I do, Judge.
So you're good with discovery. There are medical records. In your perspective, not a lot, but enough. And more importantly, you want an expert to review those records.
Correct.
Okay. How much time do you need to retain the expert and have that process occur?
I would ask for 60 days.
Okay. Is there anything about the expert process that you think would you had asked that I reset this to another final plea, and my thought was, this is the day for final plea. Maybe we set it on a different trial calendar. Is there anything that you foresee coming out of the experts' review that would change your view and Mr. Miles's view about going to trial?
Well, Judge, we've made a counter offer to the state. We have not heard back on our counter offer. I really don't think the state is going to accept our counter offer.
Sure.
So if the court is inclined to move this to a trial calendar, pre-trial calendar, another final plea, whatever the court's pleasure, we'll be ready.
You just need time.
Exactly.
Okay. All right. Well, let's get on the record. Do you know what the state's offer is?
I do, Your Honor. Give me 1 second to let me pull it back up. Yes, Your Honor, the state's offer in this case was to reduce count 1 to sexual battery under OCGA 16-6-22.1 with 5 years probation, and count 2 would be non-pressed.
Okay, so the state's recommendation is straight probation, reducing 1 count and dismissing the other. And we're going to delay trial by a month. Your counter offer, you don't need to, I don't need to be in the middle of negotiations, but I was expecting to hear 10-2, and then maybe your counter offer was Mr. Miles is established, this happened a long time ago, and our counter offer is probation, but probation is already the offer.
Well, Judge, first of all, it's probation with sex offender conditions.
Okay.
That's totally different from straight probation.
Okay,
Secondly, is my client didn't do this.
then he
So-
shouldn't plead.
Exactly.
Okay,
So we're prepared to go to trial. Now, the offer we did make was simple battery. I don't think it's going to be accepted, but that's the counter offer we made.
got it. Okay. That'll need to go back and forth, and we've got good lawyers on both sides to have it go back and forth. Mr. Miles, it's my understanding that you are not interested in entering a plea to sexual battery felony at this time. Is that correct?
Right.
Okay. You will be free in the future to enter a plea, whether it's to the charges as brought or reduced charges all the way down to a misdemeanor. The only thing that changes after today is that you wouldn't be able to withdraw your plea if the sentence I gave you was different from what Mr. Saylor's asked for. But if you and he are able to convince the state to reduce it to a misdemeanor, they're going to be asking for probation anyway, if they're asking for probation as a felony. So I don't know that that's a big change for you, but I need you to understand and share with me that you understand that after today, you remain free to enter a plea if that is what you decide after you consult with your lawyer is in your best interest. You just don't get to withdraw it if you don't like the sentence that I give you. Understand?
I understand, Your Honor.
Good. I figured you did. What I will do is talk with Ms. Nelson, my litigation manager, and likely Mr. Saylor's, well, we'll do 2 things. 1, we're gonna get Mr. Granville's name out of the system, so your name shows up. But 2, we'll likely bump this case to the August trial calendar. And let me give you that date now, so there are no surprises. We're calling the trial calendar on August 16th. It's a 2-week calendar, so trials are the week of the 21st and the 28th. But August 16th is the call of the calendar. So that is more than 60 days from today. And I will expect both sides to be ready if the case has not already been resolved. Ms. Willingham, anything else from the state?
Nothing further, Your Honor.
Mr. Saylors, again, I apologize for my mix-up as to what's in the system about who's in charge of Mr. Miles's defense, but beyond that, anything else from the defense?
What time on August 16th?
It will be 9 a.m. That's how we typically do it. The calendar hasn't been published yet, but it'll be published and you'll get notice, and Mr. Miles will get notice.
And what date did you say with the trial calendar, Judge?
The 21st and the 28th, so 2 different weeks of trial, which gives us some flexibility. If you've got a conflict one of those 2 weeks, we'll get you the other week.
Thank you, Judge. That completes my business.
Okay, Mr. Miles, thank you for being here. You've been on bond for a long time. That bond still applies. If there are conditions of that bond that are proving to be particularly onerous, let Mr. Sailors know, because he can file a motion to modify. And if it strikes me as a pretty minor modification, we may even be able to do it without having a full-blown hearing. I didn't realize, I just saw your booking number now, that whatever allegedly happened, it was 3 years ago. So I know you're anxious to move on. We've got a lawyer who can help you do that. But that August date will be closure, whatever closure looks like. I'm not going to be interested in budging it. So we'll try to make something happen by then. You just stay in touch with Mr. Sailors, because he'll be working with the prosecutor.
Thank you, Jan.
All right.
Thank you, Judge.
You're welcome.
Can you fill this out and then I'll get it to the court? I know, but that's, they have done constitutional.
Were you able to connect with Mr. Rumley?
I've sent him some messages. I asked him to log off. I don't know if he's using the same phone that I'm texting for this.
Okay, I can tell him in just a second. Let me figure out who's next. Is Quentin Oliver here?
I believe.
Oh, that's Mr. Wright's other case. And he's also in custody. Mr. Wright's on a roll here. And it sounds like this will be a plea.
It's something that I think we're gonna work out, I believe.
I think it's something that we can definitely resolve.
Okay.
I told him, Attorney Wright, just to give me a call when he's out of trial.
Okay. All right. Give me 1 second on that. Okay, so Ms. Brown, did Ms. Brown get brought up?
Yes.
Great.
This is a plea, Judge. I just need to speak with her briefly, but it'll resolve today.
Do we need Mr. Abadi back? He seemed to think he wasn't here till 1.
It's me.
It's you. Of course it is. All right. We'll do that in a second. Then why don't we'll do the other things on the calendar. Tobias Johnson. And that's also your case.
This is mine, Judge. I got an offer from Mr. Shapiro last night. If I could just briefly talk to him and then we can bring it out.
Okay, why don't we do that? If I go back, what about Mr. Davis? Did you talk with Mr.
I
Davis?
have not, there not enough deputies right this second, but as soon as there are. I will-
Okay, well, if I get off the bench, there are plenty of deputies. So, pardon me? Okay, but before anyone goes, I don't know that I'll have anything to do other than I'll go get the calendar. We have Mr. Lewis. That's Ms. Bumpus. And those are pleas from yesterday. So you need to talk to Mr. Davis. Mr. Furlow isn't here, but that's a plea. Mr. Rumley needs to get off this call, talk to you. Ms. Brown is a plea, and you need to talk to Mr. Johnson. So I will go away for a few minutes and then come back. We'll do some of those pleas. And hey, Mr. Rumley, can you hear me? Ooh, he's not in the car anymore. Excellent. If you can, you're on mute. Can you unmute? He's yelling at us. We're good. No one's going anywhere. He's got someone with him. I'm gonna send him a chat. Should I have him call you or does he have your number?
He does. I've been texting.
I unmuted it.
There you go. Excellent. Hey, Ms. Wood needs to talk to you. She's gonna give you a call or do you want him to call you?
I'll call her.
All right. Are you near the phone she normally calls? Because she couldn't reach you when you were doing your driving thing.
Yeah, my phone was broken, but yeah, she has my number. I got that phone.
Okay, but if that phone's broken, how's she gonna call you?
No, it's not broke. I'm saying I got it now.
Okay, great. She's gonna give you a call and then get you back on this. So you should drop off this call. She's gonna talk with you and then you can hop back on, all right?
All right.
All right, see ya.
See you.
There we go. Do you want to let Deputy Gordon know when you're ready, or do you want me to just come back out in 10 minutes and say, let's do something?
I'd like to let Deputy Gordon know when we're ready, Judge.
Okay.
And Your Honor, I believe that concludes my business until the afternoon.
So you don't have the Lewis pleas. That's Ms. Willingham. Don't look so unexcited. And yep. Okay. So we'll see you. You don't have the Rumley cases? Wow. Okay.
Judge, just a quick question for you.
You're testifying?
On the record.
Yeah, of course. Yeah, of course.
Thank you.
Yeah. And it may even be, you don't know exactly when it is. It could be that we just,
It was on for next week.
right. No, I mean, we don't know right now, but you may learn, I'm just making this up. It's a Thursday. It could be that because we need to do your case that same week, we just pause on it because it's Montgomery. It's not San Francisco. So you're gonna drive and you're gonna come back. Okay. All right. So I heard. All right.
I'll be after the 16th.
All right. Good. I'm glad to hear that.
Okay,
Ms.
thank you.
Bumpus, are we ready on Mr. Lewis?
We're ready, and we're gonna do, it's negotiable.
Okay, it's okay.
Do we have enough people that we could do Mr. Lewis also? Great. I'm gonna go get that calendar. Don't go anywhere. Let's bring Mr. Lewis out. Let's knock it out.
You taking a level of
application.
Yeah,
Oh,
no, I'm saying, if you just accept responsibility, it looks better.
Yeah.
Then you didn't get moved, well, you tried.
Yeah.
I mean, because I'm saying, if they come move me tomorrow, great. If they don't, they come, at least you tried.
Yeah, okay, thank you.
And he agreed. But you know, this is really a sad case. It is, because he's really the victim. I'll take it off. He had mental illness, but this young lady is you gotta look her up. She has an episode of For My Man. You know that?
I know what show you're talking about.
Yes, this young lady, I've known her since a child. And she got him to drink. She got out of prison. You gotta look up the For My Man. Yes, and so that triggered his mental health. And then she just left.
So yeah,
Promise you'd be back.
I had a feeling you keep your word.
So, I mean, no, he's not. Yep, not there. All right.
Let me know when you're ready, Ms. Willingham.
Have you heard from her?
Just a couple days ago, not like Monday.
Okay.
First thing,
All right.
No, I'm not. I thought I had.
False alarm.
Then again, she
Sorry.
keeps strange hours, so.
Mhm.
Now I'm ready. And Judge, when we get to the fact section, because there are multiple cases, I'm gonna have to toggle a little bit. So it might be a
Okay.
little slower there, but
Not a problem. We'll work through it. Oh. Okay, Ms. Rivers, are you ready for a plea?
Yes, I am.
Great. This is from yesterday's trial calendar call. We have Mr. Lewis here, and he is positions 8, 9, and 10. Are we moving forward on all three cases?
yes, Your Honor.
Okay.
Yes, Your Honor.
So it's 22 SC 182-696, 697, and 698. They are consecutively numbered indictments. Mr. Lewis is in court with his lawyer, Ms. Bumpus, and Ms. Willingham is here as well. Mr. Lewis, in just a moment, Ms. Willingham's going to put you under oath. Once you're under oath, she's going to ask you a bunch of questions, most of which I'm sure Ms. Bumpus has already talked to you about, but it's about your rights and how you are giving up certain rights by entering a plea instead of going to trial. You'll need to answer those questions. If you don't understand the question, just let Ms. Bumpus or me know, and we'll explain it in a different way. And at any point, if you need to have a conversation with Ms. Bumpus or you've got a question for me, just do the timeout and we'll work through it. This is not meant to be complicated. It is not meant to be tricky in any way. So if someone uses words or phrases and they're not clicking for you, just say, wait a minute, I don't follow what you mean by that. Lawyers have a bad habit of sometimes throwing around bigger words than are necessary. And that's not impressive. It's just sort of what they are trained to do. So if you need something rephrased, will you let me know that?
Absolutely, Your Honor.
Excellent. Then we're in a good space. When you're ready, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matters currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Please state your name, your age, and your date of birth.
Willie Lewis, 35, 9/22/87.
Are you now under the influence of any medicine, drugs, or alcohol?
Just my prescribed medication.
And does anything about that medicine inhibit your ability to understand today's proceedings?
No.
Mr. Lewis, how often do you take the medication?
Nightly.
Did you get it last night?
Yes, Your Honor.
Great. And when you take that medication, is it designed to help you sleep or is it designed to address other things?
Mostly, well, it's a mood stabilizer. Initially, I kind of didn't really see the purpose in it. So I thought what I was experiencing was something else. But later on, I saw how it affected my mood. And it generally keeps me in, it generally does what they said it does.
Great. You take it at night. When you wake up in the morning, do you find that you're extra drowsy
Yes.
or hazy?
Yes, a lot, often. And that's why I've been contemplating getting adjusted by the physician. However, half time in jail is just not so bad. So.
Okay. The part that's important for today is making sure that if there are any of those hazy effects, you're not feeling them right now. Do you feel like you understand where you are and what we're doing this morning?
Yes, Your Honor.
Great. If that changes, will you let me know?
Absolutely.
Great.
Your Honor.
Can you read and write in the English language?
Yes, ma'am.
How far did you go in school?
I currently am in possession of an associate's in arts degree and currently enrolled in Georgia State University.
Have you had the opportunity to review the documents that charge you in these cases?
I'm aware, I have the police reports. I'm aware of what's being alleged.
Well, and more specifically, I want to make sure, and this is what Ms. Willingham was getting at, that Ms. Bumpus has talked to you about the formal charges. So the police may have arrested you for I don't know what they may, hey, I'm arresting you for assault and battery, but you've been indicted for some specific things, aggravated assault, family violence, battery. And we need to be sure, all of us, all four of us, that you and Ms. Bumpus have had a discussion about what the charges are.
So yeah, for the yes, I've been my lawyer has informed me of the charges.
Great.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, yes, ma'am.
The negotiation in these cases as to indictment ending in 2692, count one would be 8 years to serve 2 years.
I'm sorry, I don't have an indictment that ends in that. We have 696, 697, and 698.
Okay, so that is 696.
Okay,
All right, as to indictment ending in 2696, count one, 8 years to serve 2 years. Count two, 5 years suspended, and that would be consecutive by operation of law. Count three would be non-priced. Count four, serve 12 months. Count five, 5 years to serve 2 years, and that would run concurrent with count one and count four. And then as to indictment ending in 2697, count one, 8 years to serve 2 years.
Yeah.
Count two, 8 years to serve 2 years.
That counts.
Counts 3, 4, and 6 would be non-priced. Count five, serve 12 months. Count seven, 5 years to serve 2 years. All of those counts will run concurrent, and that case would run concurrent with indictment ending in 2696. Lastly, as to indictment ending in 2698, counts 1 and 2, 8 years to serve 2 years. Count three, non-priced. Count four, serve 12 months. Count five, 5 years to serve 2 years. Again, all of those counts will run concurrent, and that case will run concurrent with your other two cases. The special conditions would be if you are, if accepted, you must complete 9 months IRSAT post-release program, complete the family violence intervention program, no weapons, no violent contact with the victim.
Would you mind repeating that last maybe
The special conditions?
3 sentences?
Yes. As to the special conditions, if you were accepted, because that's something that it's a program that you would have to apply to and be accepted into, you would be required to complete the IRSAT post-release program, complete the family violence intervention program, have no weapons or no violent contact with the victim in this case.
Okay, got you.
Got it? Okay.
Mhm.
so I want to make sure I get it.
So that's great.
It's not a requirement, it's not a recommendation or a special condition of probation that Mr. Lewis complete IRSAT. It's actually sometimes it's referred to as aftercare, but you kept saying post-release. So it's that component of IRSAT that one gets after he or she has completed IRSAT and been released.
And Judge, it may be that the way I worded it is incorrectly. I was working with Ms. Collier to make sure this was drafted properly, because he would still need to do the IRSAT in, or the RSAT in custody, which is why we gave a little more time on his sentence. I know that Ms. Bumpus will speak to that when we get to defense.
Okay.
But if he's accepted into the program once released, he will also need to do the post-release program as well.
Got it, which is your reference there, because it's really not a condition of probation to do RSAT. Well, it could be. I'll hear from Ms. Bumpus on this. And I'll need to do a little math. Okay.
Ready for me? Oh, still.
And has your lawyer gone over the mandatory minimums and maximums with you?
Yes, ma'am.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No.
The overall negotiation in this case is a total of 8 years to serve 2 years. Is that what was explained to you?
Yes, ma'am.
Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. Under the general conditions, you will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. And the special conditions would be the ones we just previously discussed. Do you recall those conditions, or would you like me to repeat them?
No violent contact with the victim, and also no weapons and family violence.
Yes, and IRSAT if accepted.
Yep.
Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I've asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offenses to which you are pleading guilty?
Yes, I know.
Yeah.
You need to ask me something.
Yes.
Are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered for the felony offenses and 12 months from the date the sentence is entered for the misdemeanor offenses. Do you understand these time limits?
Yes, ma'am.
Okay. Your Honor, if these cases were to proceed to trial, I'm gonna try and go in order.
So I've looked at the indictments. It looks like they're also in chronological order. So 696 is the oldest from
Yes.
November 21, then we get to Valentine's Day, and then March of 2022.
Yes.
Great.
That is
Okay.
correct. My apologies, Judge.
Second one.
All right, you said you'd be bouncing around.
Okay. On November 20th, 2021, and this is as mentioned, I'm going to go in chronological order. So this is as to indictment ending in 2696. On November 20th, 2021, Officer Sensor was dispatched to 1133 Huff Road Northwest for a 911 hang-up call. The person who placed the 911 call did not provide dispatch with a building and or an apartment number. Upon officers' arrival at the complex, they conducted an investigation using their CAD system, at which time they were able to locate the phone number and they were able to locate the person who made the call. Officers subsequently ended up having to text that number, and they asked for the apartment number. Although they were originally given incorrect digit, they were able to locate that apartment, at which time via text message, they were told to come quickly, that they could not be heard by, that they did not want to be heard by the defendant. And once the officers were able to locate the apartment by placing their ear to a door in which they heard most of the commotion coming from, and they could hear a male yelling, "I'm going to slap you," at which time the officer knocked on the door and advised that it was Atlanta police. They could hear the male yell, "State yourself." And again, the officers yelled, "Atlanta police, please open the door." A male then opened the door and yelled something to the effect, "I do not have anything on me. Get on the," officers responded by telling him to get on the ground and let them see his hands. The male got on the floor and was placed in the handcuffs without further incident. Miss Tiffany Mykesha Gray stated that the defendant suffers from schizophrenia and that he confronted her with a Glock 23 handgun. It's a handgun that he had to do security. He told her that he would kill himself, and subsequently he grabs her and hit her in the head. Gray showed a mirror, which also was, it appears it was broken when officers arrived. After pointing the gun at Gray, according to her, she was hit in the head with the mirror by the defendant as well. And I think I said the address, but just for safe measure, that occurred here in Fulton County. As to indictment ending in 2697, on February 15th, 2022, officers responded to 1133 Huff Road, Northwest Atlanta, Georgia, Fulton County. Upon arrival, they made contact with Tiffany Gray, who stated that she was in a dispute with the father of her child, Mr. Willie Lewis. Miss Gray stated that Mr. Lewis has mental issues and she believes he was having another episode along with being mixed with some drugs, and he had gotten off the streets. Miss Gray stated that she knows when Mr. Lewis is showing signs of harm, of him either on drugs or having a mental episode. She further stated that since he was showing the signs, she knew something was wrong. She told Mr. Lewis to lay down on the couch. She stated that he then lay down for a moment before jumping back up and started having another episode. Mr. Lewis started yelling at Miss Gray, throwing things around the house. Miss Gray stated that once Mr. Lewis started getting more out of control, he started to walk towards her, and she ran into the bedroom where the babysitter, Miss Mira McKeever, and her child, Tiffany Gray. Ms. Gray stated that when she ran into the bedroom, she heard a very loud bang. Ms. Gray stated that she thought it was Mr. Lewis punching something or breaking the television. Ms. Gray stated that when she came out of the room moments later, she saw the front door hanging off the hinges. Ms. Gray stated that after calling maintenance to come repair the door, she noticed that the microwave had a single bullet hole going through the front of the door all the way through the back of the microwave, where the round was lodged into the back. Ms. Gray stated that she did not see Mr. Lewis point the gun at her, but believes that he was trying to shoot her. A single shell casing was recovered from the scene. Lastly, indictment ending in 2698. On March 12th, 2022, while patrolling the area of Huff Road and Ellensworth Boulevard, officers were flagged down by Tiffany Gray, who stated she had just been assaulted. Ms. Gray continued on to state that she had been in an ongoing dispute with Mr. Lewis, who she stated was her significant other, who she lives with. She continued on to state to the police that state that the police had been called 2 previous times today, but both times the suspect fled the scene before police arrived. Ms. Gray stated that this last incident began while she was inside of their joint apartment. Ms. Gray stated that she heard the arrestee outside of the apartment yelling that he was coming in. Ms. Gray stated that the arrestee then entered the apartment and immediately attacked her, striking her in the back of the head repeatedly with a firearm. Ms. Gray stated that she fell to the floor as the assault continued, using her arms and legs to brace herself to keep from lying on her stomach, being as though she was pregnant. Ms. Gray stated she was eventually able to flee the apartment, leading up to where officers were flagged down. Officers observed visible injuries on Ms. Gray's elbows, knees, and head. And Your Honor, the state has had an opportunity to speak with Ms. Gray. She actually was present at the last setting. She is not happy with our decision, as she actually wants the defendant to be out immediately. This was a case that I advised her because there are 3 cases. Although I do recognize there are some mental health issues there, it did not negate that there was a firearm used in each one of these offenses. One in which, fortunately, the microwave got the bullet, but this could have ended very differently. But the state did still take into consideration the defendant's mental health history, the victim's concerns, and that is how we landed on this offer. So she is not happy with our decision, but it's not that it is not enough time,
Right.
but that it is too much time.
It's an atypical, although in your realm, maybe not so atypical. It's not that why is Mr. Lewis not facing 20 years in jail for having repeatedly beaten me with a gun, shot at me with a gun, endangered the fetus in me, et cetera. It's, I need Mr. or want Mr. Lewis back.
Yes.
Okay. All right. Thank you. Complicated situation. Good morning, Ms. Hardy. How are you doing?
Good morning, Your Honor. I'm well.
Can you share with me, please, the criminal history information you have for Mr. Lewis?
Okay, Mr. Lewis has arrest cycles out of Georgia and Washington. No convictions out of Georgia, but felony convictions from Washington. I have a 2009 theft of motor vehicle, also a 2009 robbery, a 2017 burglary of residence, a 2009 probation violation, and that's all I have to report.
Okay. How many cycles in Georgia?
3, beginning in 2006.
Okay. Thank you so much.
No problem.
Ms. Bumpus.
Yes, Ms. X?
Uh,
No, to me. You just asked me a question.
yeah, you said cycles or,
How many times you been arrested in Georgia?
oh, okay, yeah.
When you're ready.
Your Honor, we are here to take a negotiated plea, which I think is more than reasonable and more than fair. The state mentioned that the victim wanted my client to be released, and, not to get too deep into it or to not accept any level of responsibility, but I think the victim, I'm not speaking for the victim, but I think the victim takes that standpoint because they were doing drugs together. And she understands that she introduced him to drugs, and that triggered his mental health. However, my client is here today to take full responsibility for that. And as we talked in the back, I told him that he's a completely different person than the first time when I was with him. And I'm proud of him for, deciding to take his medicine, deciding to be well, because that's a decision that only he can make. And initially, we were going to do this non-negotiated because, of course, he's ready to get out. But when I explained to him kind of the components of what RSAT is and how it can benefit him and how you are, that I thought that it would be best to show that level of responsibility and accountability by agreeing to go to the program. And it wasn't so much that he didn't want to do the program. It's just that we have a few concerns about, is he going to actually go?
Right.
And I told him that it concerns me because I have never actually had a client post-COVID go to RSAT. Everybody has ended up in a sentence modification to being released because they have never been picked up after 8, 9 months, and the program is 8 or 9 months. However, we decided that we would take a try, and maybe he'll get picked up tomorrow, maybe next month, and just see where that goes. And if not, we'll come and see, and see where that goes. However, he did want to try and see if he is accepted and see if he can go, because he's been making strides, and he's not in Fulton, he's in Cobb, but in the Cobb County Jail, to be better and to be well. Like I said, from our first conversation to today, I'm looking at a different person.
Right.
And I just asked that, considering that, because I know this sounds like, why would you accept this? It's a great deal. He recognizes it's a great deal, which is another reason why we decided not to do a non-negotiated, because I told him how that was going to end up for him anyway. And we just ask that you accept that, recommend it between the state and I, to try to get him some help.
Okay. That's my goal as well, is to get Mr. Lewis more locked in on the healthier pattern he's got right now, where he's taking the medication and has the stability. Ideally, that's something that could be maintained outside of a jail setting as well. I've got some questions first. Mr. Lewis, you mentioned Georgia State. What do you study at Georgia State?
Business admin.
Okay. How far did you get with that?
Well, right now I was just starting, so I probably have, that was my first, starting my second year before the incidents.
Okay. I know you have at least one kid. How many kids do you have?
I have 2 and a possible, one in Washington State.
Okay. So excluding Washington kids, how many Georgia kids do you have?
2.
Are they both with Ms. Gray?
Yes, one just had a birthday 2 days ago.
Okay. And is one of the 2 one that was in Ms. Gray's belly in March of last year?
Yes.
Okay. So
And
boys.
I'm sorry, that's the one who you allowed him to.
Right.
Yeah.
Okay. So boys, girls, I don't remember.
One son, one daughter, one of each.
Okay. And Ms. Gray is the custodial parent for them right now?
Yes, that's correct.
Okay. Does she work?
He doesn't know.
You don't know. Okay. All right. So you don't know how it is she is providing for her kids.
It's anyone's guess.
Okay. Does Ms. Gray have other kids that you're aware of?
Yes, her son.
Okay. And did her son live with the 2 of you at that Huff Road address?
Yes, and he was not there during any of the incidents.
How old is he?
He is 11 now.
Okay. So your kids with Ms. Gray, much younger. She's got an 11-year-old son.
Correct.
All right. So I think IRSAT is a great idea. It exists in 2 forms. There is the Department of Corrections IRSAT, and then there is the Department of Community Supervision IRSAT. I can't get Mr. Lewis into either directly. With Department of Corrections, I can recommend it, and then he's evaluated for that. My understanding of Department of Community Supervision, which is probation, their IRSAT, one gets revoked into it, and there's no revocation going on here. You're not on probation in Georgia. So we would be looking at the Department of Corrections IRSAT that Mr. Lewis would go to. What I intend to do, bless you, is recommend Mr. Lewis for RSAT or IRSAT. I'll recommend IRSAT, but what I'll say is, in the alternative, if for whatever reason the Department of Corrections thinks that rather than do a dual diagnosis, mental health concerns and addiction concerns, they're just going to do the addiction piece. RSAT is better than nothing. I think IRSAT is by far the better fit, because it will help you work through some of the mental health challenges you have, along with some of the addiction challenges that may have been introduced into your life. I don't know if that was what was going on in Washington, but clearly it sounds like it was happening here. And so better to get a toolkit to address both those. And we'll see how that plays out. Check one thing here.
And Your Honor, while you're checking that, I just want to let you know, my client asked me to let you know that he did serve in the military as well.
Okay. How long were you in the military?
2 years, 6-month deployment. Went to Talifar, Nimmer, and
with what branch?
Missoula. I was in the Army.
Okay.
Stationed at Fort Lewis in Washington State. That's why I was there. I'm a native here, but
Got it. So your Washington connections were through the military.
correct.
All right. So I've got that you've been in for almost 460 days. Okay. Mr. Lewis, do you have any questions about any of the things we've been talking about?
Not everything's been made clear. I was just wondering if there was maybe anything else that centered around, anger management and things of that nature, couples counseling, that sort of thing.
Well, that's one of the conditions of your probation, that family violence intervention program. Spot on. That is going to address that directly. I can't make Ms. Gray go to it because she's not in front of me, but she may learn about what you're learning and say, well, I want to be there as well. So
I think she's already done it.
good. Okay. Well, hopefully it sticks. You'll be able to reinforce it as you do it. All right. So Mr. Lewis, I do find that there is a factual basis for each of your 3 pleas on 3 different instances and not all that far apart. It's less than a 6-month window we're talking about. You were in a not real healthy spot yourself. And it may be that it was aggravated by things that were going on in your household. But guns, drugs, and mental health, that is a dangerous trifecta. And I share Ms. Willingham's view that we are lucky that it was the microwave that took the hit. And you'll get a chance to say what you want to say in a minute. I don't know how that played out, but it sounds like there were maybe 3 or 4 other people there. Ms. McKeever, obviously Ms. Gray, and maybe a little one rattling around. And there's no remote control of bullets. You pull that trigger and they go in strange places. I recently had a case where it was self-defense, but person A shoots person B who's coming at him. It goes through person B, hits the pavement, and almost kills person C, who is person A's best friend. So he's shooting this guy who's coming at him, and he almost kills his friend. One shot. So you and guns need to not be together again. You already had felony convictions. You now have Georgia felony convictions. Guns are no longer, I appreciate you were military, maybe you were security. Security going forward, it's a baton, it's a baseball bat, it's a bow and arrow. It is not a gun. That's the kind of thing that if you get arrested with a gun and you're still on probation with me, I'm going to send you down the road for a while until you get it crystal clear that it's just too risky for you to be around guns. The meds wear off or something happens, and you're going to see and hear things that aren't really happening that prompt you to do something that you think is protecting yourself. And then when you come to, there's Ms. Gray dead in your arms, and you don't want that. So anyway, I find there's a factual basis. I digressed a little bit for each of these 3 instances. I also find that your pleas are knowing and voluntary. Voluntary means that you're entering these pleas because you, after working closely with Ms. Bumpus, have decided that this is the right way forward for you. Is that correct?
Yes, Your Honor.
And a knowing plea just means you've understood things, and you may not have understood them the first time, but you have spent a lot of time talking with your lawyer. I've watched you ask her questions during this hearing, and she answers. And each time after she's had a chance to explain, you said, now I get it. So I'm going to ask you one final time. Do you feel like you understand what it is we're doing today, and in particular, what you're doing today?
Yes, Your Honor. Although the proceedings have been very different than what I'm used to, I understand.
When you say used to, meaning it's different in Washington?
Oh, yes. Far
Okay.
different.
Well, it's better in Georgia. All right, good. Mr. Lewis, do you authorize someone from my staff to sign each of the 3 indictments on your behalf indicating your guilty pleas?
Yes, Your Honor.
Ms. Bumpus
Yes, Your Honor.
and Ms. Willingham?
Yes, Your Honor.
Mr. Lewis, part of your sentence will be probation. I'm sentencing you pursuant to the Probation Options Management Act. All that means is that while you're on probation, should you have a technical violation, which would mean maybe you miss a meeting, maybe once you test positive for drugs, not a bunch of times, you in probation would sort that out. You don't have to come see me. If you get arrested again, if you violate one of these special conditions of probation, that I'm going to talk about, that comes back to me. And the outcome is usually less good than if you're just working with probation. All right. In terms of sentencing, Mr. Lewis, I don't think you're going to run into what Ms. Bumpus has described, which is the reality for folks who have had their probation revoked and are waiting to go to an RSAT or IRSAT. They do sit in the county jail and wait because the bed space there is limited, in particular for IRSAT. But that's not your sentence. Your sentence is going to be a custodial sentence, as in you will be transported in the very near future to a Department of Corrections facility. So you won't be waiting for that. They'll take you to the diagnostic center, ask you a bunch of questions and look at your history, both your criminal history, but also your mental health history to figure out where's a safe and healthy place for you to be in the Department of Corrections. If the Department of Corrections decides that RSAT or IRSAT is appropriate, there's not the same waiting situation because they have facilities that do just that. There's some wait, but you don't wait here. It may be that you stay at Jackson, which is where you go for your first diagnostic before you go somewhere else. I'm going to need your help again, Ms. Willingham, just because I know you dismissed some counts and I don't want to sentence Mr. Lewis to a dismissed count. So if we start with 696, which are the counts that you dismissed?
3, 4, and I'm sorry.
The family violence battery.
696 is just count 3.
Just count 3, which is the family violence battery?
Yes.
Okay. All right. So on count 1, I'm going to sentence you, you do the math right. So hear me out on all this and then we'll talk about it. I'm sentencing you on count 1 to 7.5 years to serve 2.5 years with the balance. Nope. I'm sentencing you to 2.5 years on count 1. Count 2 has to run consecutive and has to be 5 years. I'm sentencing you to 5 years on that. That's probated. 3 is dismissed. Is 4 cruelty to children in the 3rd degree is a misdemeanor?
Yes.
That's 12 months to serve. And count 5 is 2.5 years to serve. That's concurrent with count 1. In the case ending in 697, which counts were dismissed?
3, 4, and 6.
Is that trespass? 6?
Yes.
Okay. All right. For counts 1 and 2, in the case ending in 697, I'm sentencing you to 2.5 years to serve. Count 3, 4, 5 is 12 months to serve. 6, 7 is 2.5 years to serve. Those will all run concurrently with each other and concurrently with 696. And then in the case ending in 698, what are you dismissing?
Count,
if anything?
3.
Count 3. Okay. Counts 1 and 2 are 2.5 years to serve. Count 4 is 12 months to serve. And count 5 is 2.5 years to serve. Those are all concurrent with each other. And all 3 cases run concurrently. You have 5 years probation in the case ending in 696. Special condition of probation number 1 is no violent contact with Ms. Gray. And I'm just making clear on the record, my thought would be it would be no contact with Ms. Gray, but that's not what she's asked for. My next thought would be you could only have third-party contact with Ms. Gray, so you could see your kids, but you would negotiate that through someone else. But that's not what Ms. Gray is asking for. She wants you still in her life, and I get it. I won't say I understand it, but I see how the dots are connected. You're shaking your head?
No, I just agree with you.
Okay. So the special condition is no violent contact with Ms. Gray. So you can call her and write her while you're in custody. And when you're out, you guys can live together if that's your decision and hers. but it cannot be tumultuous contact. It would be a crime anyway, but just so you know, you lay hands on Ms. Gray, not only is that a new offense, might only be a misdemeanor, it's a violation of a special condition of your probation, which means I could revoke all of your probation. And I say that to be stern, not because I'm mean, but you just need to know there's a real serious tripwire. Same as if you get arrested with a gun. You should expect that a whole bunch of your probation will get revoked. And it will be a special condition of your probation that you complete any aftercare that remains for either RSAT or IRSAT. I will ask that probation assign to you a probation officer who is a mental health probation officer so that he or she is particularly attuned to your needs and knows how to ensure you're taking your medication. And finally, it will be a special condition of your probation that you, did I already say the family violence intervention program? If I didn't, you're going to complete a family violence intervention program. And finally, you will be required as a condition of probation to take any medication that is prescribed. So if a doctor says take X, you keep taking it. If that medicine gives you bad side effects, you and the doctor talk about it, and she'll give you a different medication. Once she prescribes that, that's a condition of your probation. So I'm not saying you got to take something that doesn't work well for you. That just means you work with your doctor and say, you know what, I'm gaining weight, I throw up, whatever the bad things are, let's try something different. Doctor gives you medicine X. That's what you have to take. If you go off your meds, you are breaking a condition of your probation. That is for your safety and the safety of the people around you. Okay? It's not me playing doctor. I'm not saying what medicines. I let the experts do that. I'm saying you better take it. Okay? Any questions about any of that?
No.
Okay, let me explain why I gave you a little more time. Two reasons. One, I think what happened here is really serious and your lawyer got you an amazing deal. But two, in conjunction with that, I want to build in enough time so that the Department of Corrections could consider you for IRSAT. I'm worried that if you went down there with only the bit of time that's left, they'd say, you are a perfect candidate for IRSAT. Look at that. You only have 4 months left. The program is 6 months. We can't give it to you. And then you're going to sit in prison for 4 months and you might parole out a little bit before then, but you're not going to be getting any treatment. And that is not in your best interest. So that's why I extended it. I'm not suddenly thinking, uh-oh, Mr. Lewis is the demon here. I think you've got a great deal. If I were a prosecutor, I might have negotiated something different. Although I'm working with a victim who is saying, I don't want Mr. Lewis to be in any longer. So it's complicated. Ms. Willingham has one of the most complicated prosecution jobs you can get. And so this is where you all ended up. I have the final say, and it is not so much about you and me being upset with you as me wanting to ensure we have the longest on-ramp for you getting that care. Okay?
I agree.
All right. Excellent. Ms. Willingham, you had a lot of moving parts in this one. Did I miss anything?
You did not, Your Honor.
Okay. Ms. Bumpus, did I miss anything? Ms. Tucson, do you need to share anything with Mr. Lewis? She's with probation.
Good morning. Not at the time. He does have, a UPI in the system, so all his dockets and everything will be uploaded, and he will get more instructions upon release from the facility where he will
Great. Okay, so when you are done with the Department of Corrections part of your sentence, whether you're paroled or you serve the whole sentence, you'll be given reporting instructions for parole or probation. And they're under the same roof now, so it's not different places. Okay? Mr. Lewis, I wish you the best. I'm excited for you that you were pursuing more with your education. I appreciate your service in the military. My hope is you figure out a way to stay on point with your medications, because that may well be the difference between you being able to be with your kids and the people you care about and you needing to be somewhere else, so we keep you safe and other people safe. Okay?
Makes sense.
All right. Good luck. Thank you, Ms. Bumpus.
Thank you, Judge. And thank you for allowing me to come today.
You bet. I think it was much better to have you here in person.
And that concludes my business. May I be excused?
Yes, ma'am.
Thank you. Thank you.
All right. Let's do Mr. Davis. Yes?
Yes.
Davis, please. And Ms. Willingham, you have the state's offer for Mr. Davis?
I do. What are we doing with Mr. Davis?
I think we're just getting on the record what the offer is.
Yes.
Oh, we got a sergeant in the room. Stop what we're doing. Everyone stand tall. Ms. Wood, do you want to do Brown plea or Johnson bond hearing first? Or you don't care? I mean, Brown would come first by order on the calendar, but if you've got a preference, I don't know if there are folks here.
I have family for both, so I think, I would like, yeah, they both told me they're.
Okay,
good.
we'll do Ms. Brown's plea and then Mr. Johnson.
Thank you, Judge.
Sure. Hello, Mr. Davis.
Good morning, Your Honor.
Good morning. All right, Ms. Rivers, you ready for a final plea conference?
Yes, I'm ready.
Great. This is position 1 and 2, John Davis. He's got an indictment from 2014 and an indictment from 2023. Mr. Davis, I'm going to hear from your lawyer very briefly to make sure she's got the discovery in your 2 cases. And then I'm going to hear from Ms. Willingham, who is not the prosecutor on your case, but a colleague of. She's going to share with me what the state's offer is. If you were to enter pleas in your cases today, what the state would recommend. Then I'm going to ask you a few questions and I think we'll be all wrapped up for the day. Okay?
Yes, sir.
Great. Ms. Feely, do you have discovery in the 2 cases?
I believe I have complete discovery, yes.
All right. I don't, you may know better than Ms. Willingham. If Mr. Davis ends up going to trial, is it the older case that would likely be the one that is tried?
We haven't specifically talked about that, but that was my.
Okay. I know it's not your decision ultimately. The other charges are much less serious. Okay. All right. Ms. Willingham, if Mr. Davis decided he wanted to work his cases out today by way of entering a plea, what would the state be recommending?
Judge, my apologies. I have the recommendation as to position 1.
That's what would drive this bus by far. So why don't you just share that? I'm assuming that position 2 would fold into that.
That would be my thoughts. As to position 1, the state's recommendation would be counts 1 and 2 would be null pros, and the defendant would enter a plea to count 3 for 5 years probation.
Whoa, sorry, that's not what I had.
Oh, are you, and that's not Tony Miles that you just read?
This is John Davis.
Okay.
Correct?
This is Mr. Davis.
Yes, and this is the information that was sent to me, so I am gonna assume it is correct. If you give me just a moment, I'll double check Odyssey to see if he has notes.
Why don't we do this? Because I don't want Mr. Davis to miss out on an opportunity. Is that do you have any afternoon cases or not?
I do.
Okay. Were you going to be back in the afternoon? Could you have a colleague be back in the
I
afternoon?
can make sure somebody's here.
Why don't you take the time to triple check what Mr. Shapiro's final offer was, because it sounds like that's different from what Ms. Feely was thinking. And based on what I just see on paper here, that might make things move along, but I don't want to have there be miscommunication here. So my thought is we handle Mr. Davis first out at 1, so that you've got the lunch break to work through Mr. Shapiro and a colleague, what the final offer is for final plea.
Yes, Judge.
Why don't we do that? So Mr. Davis, I will see you again. It'll be around 1 o'clock. Before then, Ms. Feely will probably come back to talk to you, say, wait a minute, things are a little different. And we're gonna have the same conversation. You're gonna have all the same rights. You can say, I'm not interested in working it out. I want a trial, or, hey, maybe I am more interested in working it out. I just need to make sure everyone is working off the same information.
Yes, sir.
Okay?
Yes, sir.
I'll see you at 1. So if we could have Ms. Brown, please. Is Mr. Boyd's first name Michael or Micah?
Michael,
Michael? Okay, it's listed.
I believe.
Oh, Micah could be a kid. Okay.
Yes.
Yeah, got it. All right. It's not a typo. It's a different victim. All right. Hey, Ms. Brown, you can come to the podium, please. Ms. Willingham, will you be, because of battery issues right there or at the,
I'm gonna come up, Judge.
okay.
This is the list of questions that we went over that I just didn't have back there, so if you want to follow along. That's right. So that's breakdown on paper.
Let me know when you're ready.
Okay.
You good?
Yes.
Okay. We're going on the record on position 15. It's State versus Brown, 23 SC 185873. Ms. Brown is here in court with her lawyer, Ms. Wood. We have Ms. Willingham for the state, and Ms. Brown. Ms. Wood told me that you are prepared to enter a plea in your case today. Is that correct?
Yes.
Okay. Ms. Willingham's going to put you under oath in just a moment. You're going to then be asked a whole bunch of questions. And I need you to answer them, but I also need you to tell me if at any point you don't understand what we're talking about, or if you've got your own questions about things. This is very much a two-way discussion, but I need to be comfortable that you're following what it is we're discussing. Will you let me know if you're confused or not following anything?
Yes.
Great. Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your name, your age, and your date of birth.
Charles and Brown, 22, and my date of birth is 12/31/2000.
Are you now under the influence of any medicine, drugs, or alcohol?
No.
How far did you go in school?
Did I complete high school?
Can you read and write in the English language?
Yes.
Have you had the opportunity to review the document that charges you in this case?
Yes.
Do you fully understand the nature of the charges pending against you?
Yes.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes.
The state's recommendation in this case is to reduce count 1 to misdemeanor involuntary manslaughter, which is 16-5-3B. And it would be 12 months to serve 6 months, credit for time served. Count 2 would be 10 years probation, and that would run concurrent to count 1. Count 3 would be 5 years probation, consecutive to all other counts by operation of law. And count 4 would be 12 months to serve 6 months. The special conditions would be to complete the federal, state, and local, complete the Georgia federal, state, and local gun safety law program here in Fulton County, have no violent contact with the victim's family in this case, well, with the victim as to the aggravated assault, because that is a different victim from count 1.
So Micah Boyd is what relation to Michael Boyd?
The son.
Okay, but not Ms. Brown's son. Am I remembering now? Michael Boyd was much, much older than Ms. Brown.
Michael,
I mean, Ms.
Yes, Michael Boyd, yes.
Yes, that's correct. So Michael was much, much older than Ms. Brown, and his son maybe was sort of an age peer-ish of Ms. Brown.
Yes, sir.
So no contact with Micah Boyd.
They just want no violent contact. There are, they have younger siblings that Ms. Brown is the mother of. So they have requested that they have no issue with Ms. Brown contacting them in the event that she wants to have have her children to have a relationship with them. They have expressed that they will not reach out on their own accord, but that's why we're asking for no violent contact, because they're okay with that for the sake of communication with their siblings.
So Michael Boyd and Ms. Brown had kids.
Yes.
His sort of second generation of kids. Yes. And they're okay having a relation. Mr. Boyd's older kids are all right, or maybe interested in having a relationship with their second generation siblings.
Yes, sure.
And it may well be Ms. Brown facilitates that, and that's the no violent contact.
Yes. And complete 60 hours of community service. And I believe you stated that you completed high school.
I did not.
You did not complete your GED. And I'm going to go back to, okay. You're pleading guilty today, or you would be pleading guilty today to a misdemeanor involuntary manslaughter, aggravated assault, possession of a firearm during the commission of a felony, and reckless conduct. Is that what was explained to you?
Yes.
Are you now, I'm sorry, have the minimum and maximums been explained to you as well?
Yes.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No.
The negotiation in this, the recommendation in this case overall would be 15 years probation. 15 years to serve 6 months with the balance probated. Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. The special conditions are the ones we just previously went over. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any forced threats or promises which caused you to plead guilty against your will?
No.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No.
Have you understood everything I've asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Did you in fact commit the offenses to which you are pleading guilty?
Yes.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. For the felony offenses, you will have 4 years from the date the sentence is entered, and for misdemeanor offenses, you will have 12 months from the date the sentence is entered. Do you understand these time limits?
Yes.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes.
And for the record, Your Honor, one of the special conditions was the gun safety program. It is a program that I have recommended before in other courtrooms on felony offenses. I have not had any issues with it, so I don't believe that they are actually around a weapon necessarily or touching a weapon. It is just a program to talk about gun safety, which as we get into the facts will make sense as to why it's here. Do you understand if you are found in possession of a firearm, you could be charged with another felony which carries up to 10 years in confinement?
Yes.
It is my understanding you will be requesting first offender from the court. There are benefits and risks to requesting this status. The benefits are that if you do what the court orders you to do and do not violate the terms and conditions of your probation, you will not have a conviction for these offenses. The risks are that if you violate this sentence or your probation, commit a new offense, we will ask you to be brought back into court, ask that you be adjudicated guilty, meaning you will have a conviction, and then the court can re-sentence you up to the maximum sentence. Do you understand this?
Yes.
Knowing all of this, do you still want to be treated as a first offender?
Yes.
Have you ever been convicted of a felony before?
No.
Have you ever used first offender in any other case or any other place?
No.
Your Honor, the facts of this case are one in which the state felt it necessary to reduce this case.
Yeah, it was going to be one of my questions. I'm painfully familiar now with the difference between the two forms of involuntary. But what prompted that? Because it doesn't, when I heard that, then I figured all the other things were going to be misdemeanors, but there are plenty of felonies in the mix. And Ms. Brown, I think, is rightfully pleading to those. Why the change for involuntary?
So specifically as to the involuntary manslaughter, Your Honor, this is a case where, and back on October 31st, the victim in this case, as to the involuntary manslaughter, Michael Boyd and Micah Boyd were having an argument. That argument escalated when Ms. Brown came into it.
As in she joined in the argument?
Yes, and that at the time, it was still a verbal argument. And once that argument escalated, it did not escalate between Ms. Brown and Michael Boyd. It escalated between Ms. Brown and Micah Boyd, at which time Ms. Brown went and retrieved her firearm, and per her statement, she stated that Micah Boyd began advancing towards her. And at that time, she retrieved her firearm and she took the safety off and she pointed that firearm at Micah Boyd. At some point, that altercation kind of alleviated. Micah Boyd heads upstairs. Michael Boyd is still downstairs and he's talking to Ms. Brown, telling her that she needs to put the weapon up. There are children around. Micah Boyd confirms this. He states that he hears his father say this. Ms. Brown then goes to put the gun up, and somewhere in between putting the gun up and taking it apart, the firearm goes off. Michael Boyd is in front of that firearm at that time.
He's not the one putting it away or doing it. Ms. Brown is
the one putting it away.
But it is inadvertently or unintentionally pointed at Miss Michael Boyd.
Yes, at which time she does tell officers that she did not realize that she did not take this or did not put the safety back on, subsequently killing Michael Boyd. Ms. Brown contacted law enforcement. Her and Micah Boyd applied pressure, trying to administer life-saving measures for Michael Boyd. Subsequently, obviously, Michael Boyd unfortunately did not survive this. So the involuntary is being reduced for that purpose, but the aggravated assault, the state does believe is the correct charge. We do believe if we had to proceed to trial, that would be a charge that we could obtain a conviction on. We have spoken with the family in this case. The children which wish to remain silent as to what they would like to see happen. And as I don't know if you recall, but at the bond motion, part of that was because there is an age difference. It did not, from my communications with them, it does not appear that they are remaining silent because they believe Ms. Brown should be in custody, just that they don't necessarily want to give an opinion as to what happened.
It's a difficult situation.
Correct.
I could understand that they'd say, we're going to let the system work this out.
Yes, and Michael Boyd's sister, who has been our primary contact, has stated that she did in fact, and she did not have an opportunity to appear at the bond motion. It was her intent, but she has stated that she actually wants Ms. Brown to get out. She was disappointed in knowing that even though Ms. Brown was given a bond, that her family was unable to make it. So when I expressed to her what the state's final offer would be in this, she was actually very happy that this was the way the case would resolve. The family overall does believe that this was a horrible accident. And they hate that we are even having to be here today, but based on the facts of the case, as well as all of my communications with the family, I do believe this was the best resolution in this matter.
Okay.
And I have reviewed Ms. Brown's criminal history, and per her GCIC, there is none.
All right. Ms. Hardy, good morning. Do you confirm that?
I do confirm that there's no criminal history to report.
Thank you so much. Appreciate it. Ms. Wood.
Thank you, Judge. So I want to start off by saying that we do appreciate Ms. Willingham's willingness to work with us on this case. I believe that this case could have potentially been a little complicated for the state to prove beyond a reasonable doubt at trial. Based on our investigation, there was a history of issues between Mr. Boyd's children that are near in age to Ms. Brown. We confirmed that with outside witnesses. Apparently there was some physical stuff that had happened between them prior to this date in question. I think that's why perhaps the gun was even in, the protecting herself even popped into her head, Judge. No amount of probation or punishment can ever make up for what she's going to have to live with for the rest of her life. Her partner is gone forever because of this tragedy. So no amount of probation period will honestly matter, because she's going to have to process this for forever and mother the children that she shared with the victim.
How many kids is that?
It's 2, Judge, ages 2 and 4.
Okay.
So I do just want to throw that out there, and I only bring that up, and I should have probably raised this before. I had presented to Ms. Willingham just before the plea if she would consider changing the amount of probation from 15 to 10. And just because it was such a late counter, I think it was best that I presented that to the court to consider, although we understand if the court sentences to 15 years probation, she understands. The only other thing with the offer that I had a question about, I've never had the gun safety program be included as a special condition. I was very curious to how that would work for someone who is on felony probation and not allowed to be around guns.
Right.
But I will leave that to the court's discretion. I think this whole incident is going to be enough for her to say, maybe I don't ever want to be near a gun again in my life. But I will leave that to the court's discretion. Judge, she's 22 years old. She's a lifelong resident of Atlanta. She has her sister here in support. Ty is here, has been at previous court appearances as well. She's already done the 6 months, Judge. She's been in 220 days since November 1st of last year. Again, her babies are 2 and 4. She's so eager to get out and get back to them. She has been gainfully employed at Sensational Subs. She also worked at Burger King previously. I don't have any qualms about her being gainfully employed. And she wanted me to share with the court that she was actually working on her GED at Atlanta Tech before this incident. So she's very eager to get back and complete that. And finally, we would just ask the court to consider sentencing her as a first offender. I have so much faith in her, Judge. I'm just eager for her to be able to get out and get her life back in order.
Okay. Ms. Brown, I'm remembering now more about you because we did have the bond hearing. I remember you working at Sensational Subs. You may have told me before, where are your kids right now?
With my mom and my dad.
Okay, that's one, your mom and dad live together?
Right.
So they're with your parents?
Right.
Okay, so they've been caring for them.
Right.
They were living with you and Mr. Boyd until this happened?
Right.
Okay, but your parents are taking care of them. When you get out, where will you live?
With my parents.
Okay, where is that?
At 651 Gills Court, 30354 Atlanta, Georgia.
It's in Atlanta?
Right.
Okay. And your parents are happy to host you until you get your own place?
Right.
Okay. So you've got a safe place to be. You can be with your kids. Do your parents work?
No, not at the moment. My mom is a caregiver to my brother. He's got schizophrenic, so she gets paid from the city.
Does your brother live in that household also?
Right.
Okay. All right. Are you planning on going back to work or school, or what would be, I know you have to process a lot, but when you're released, what's your next step?
There's programs. I'm going to apply for my GED, of course. I'm definitely going to go back to Sensational Subs and see if they would, offer me the job back. And yeah.
Okay. First offender, I know you and Ms. Wood have talked about it a lot. I have to talk to you about it as well. It's primarily an opportunity. It keeps your criminal history clean. You'll be under sentence, but if you successfully complete your sentence, then it all sort of wipes off, not meaning you ever forget about what happened. That doesn't go away. But you won't be a felon while you're under that sentence, which really helps with work. Sensational Subs may be less interested in hiring a convicted felon, someone with no felonies. Certainly helps with school and other things that you may see in your future, which hopefully is very long since you are only 22. But it carries with it a risk. And for you, it's a meaningful risk because of the number of counts you've got and the sentencing ranges that I have. If you mess up while you're on first offender, meaning you get arrested again, say you get found with a gun, the state will come back to me and say, we really misunderstood Ms. Brown and her situation. We would have a revocation hearing, which is like a trial, but there's no jury and the state doesn't have to prove all that much. And if I found that you violated your first offender probation, not only could I revoke your probation, but I could resentence you because you've already pled guilty. And just on the aggravated assault, the pointing the loaded weapon with the safety off at Micah Boyd, I could sentence you up to 20 years on that because you've already pled guilty to it. Now, I'm not saying that's what I would do, but I am letting you know, I'm broadcasting very clearly that if you get arrested in 6 months, in a year, while you're on probation, and you got a gun on you, I will revoke your first offender and you'll go to prison for a long time because you will have clearly not learned anything from this process. That's the downside of first offender. If you're pretty confident that you are going to not repeat this, you're going to stay out of trouble, you need it because it will help you move forward in the direction you want to. But it has that risk to it. If you're not convinced that you're going to stay out of trouble, then you may want to think twice about it. Do you feel like you understand the risk as well as the benefits of first offender?
Yes.
Do you want to be sentenced as a first offender?
Yes.
Ms. Willingham, does the state have a perspective on first offender treatment for Ms. Brown?
Your Honor, we've spoken with the family about it. The state has no objection to it.
Okay, I will sentence you as a first offender, Ms. Brown. Do you authorize my staff to sign the indictment indicating your guilty plea? Normally you would sign it in person. It's not a trick question, but we pass around less paper these days. And so if you say yes, then someone will sign on your behalf saying, yes, I've pled guilty.
Okay.
Is that okay?
Yes.
All right, Ms. Wood
Yes, Judge.
and Ms. Willingham.
Yes, Your Honor.
All right. Ms. Brown, I find there is a factual basis for your plea. This is a tragic situation. It doesn't sound like, other than maybe defending yourself from Micah Boyd, you intended anything bad to happen here. But guns are guns. And I don't know that there's a safe way to have guns. The gun advocates will say, of course there are, and nothing bad ever happens. But the reality is people die every day from accidental situations with guns. If you don't have a gun in your house, no one can get shot. It's that simple. But you will carry that with you, as Ms. Wood mentioned, for the rest of your life. You watched, I assume, someone you love dearly die in your arms or on the floor in front of you. That's not erasable. And I'm sorry you went through that. I'm particularly sorry for Mr. Boyd's family. He's not here for you. He's not here for them. It sounds like he had many kids and those who loved him and cared for him, and he is forever gone. We can't unwind that. But what you can do is learn from that and chart a different course for you and your two little kids. And I hope you do that. Is there anything you want to add to this situation? You don't have to say anything, but you have a right to be heard if there's something you want to say.
I just want to say thank you. I appreciate the offer. Thank you for giving me a second chance. And I just want everybody to know that I didn't mean for this to happen.
Okay. I think people know that. And you should thank the prosecutor as well, because I'm going to sentence you the way I think is right. But the prosecutor had to get out of the way first and not be saying, hey, she needs to go to prison for 10 years because there's a dead person and there's someone else who had a gun pointed at him. But I think this is the right way forward. And I think if we had been hearing different things from Mr. Boyd's family, we'd need to think about it in a different way. But like I said, it sounds like this was a tragic, tragic accident. Could have been avoided if there was no gun in the house, but you legally had a gun at that time. It will be illegal. It will be a crime for you to have a gun as long as you are under sentence. You need to understand that. Okay.
Yes.
All right. I find there's a factual basis for your plea. I also find that your plea is knowing and voluntary. That means you've understood all the things we've talked about and no one has forced you to enter this plea. Do you agree with that?
Yes.
I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you are on probation, which you will be for a while, if you have a small violation, meaning just like you miss a meeting or something like that, you in probation will work through that. But if it's a more significant violation, you get arrested again, something like that, that comes to me and we'll work through the consequences, which could include losing your first offender status. I am going to sentence you on counts 1 and let me get your indictment back up here so I say the right counts. Counts 1 and 4 to 6 months to serve. Count 2 will be 5 years to serve. That will be consecutive to count 1. Count 3, did I say serve, but on probation. Count 3 will be 5 years to serve on probation, consecutive to count 2. So it is a total sentence of 10 years.
Ask, Dawn.
I have no idea who Ms. Green is, but is that anyone you thought would be talking about this case? Okay. So it's a total sentence of 10 and a half years to serve 6 months. My math says you've already served 6 months, so you should get out today or tomorrow. If you are still here on the weekend, reach out to Ms. Wood and we'll fix that. And then you'll be on probation for 10 years. It's a long time, but this was a serious situation. Special condition of probation number 1, no violent contact with any of Mr. Boyd, as in Michael Boyd's family members, his kids or other relatives of his. Number 2, get your GED. And number 3, 120 hours of community service. I'm not going to require the gun safety class. I understand the intent behind it, but I don't want you looking at guns, around guns, thinking about guns. The safest way you're going to be approaching guns is you're not touching them and you're not in a household with them, nor are your kids. That would be best, I believe. And that is the sentence that I think is appropriate. Ms. Willingham, anything else in Ms. Brown's case?
Nothing further from the state, Your Honor.
Ms. Wood, anything else?
No, Your Honor, thank you so much.
You're very welcome. Ms. Brown, I have a question unrelated to this case, other than it's where you've been staying. And then we need you to talk with Ms. Tucson, who's with probation. She's going to talk to you through the screen right there. Were you ever housed at Union City, or were you always at the Atlanta City Detention Center?
Both.
Both.
I was housed at Union City most of the time.
How do you compare the two? Neither is good, but if you had to be at one, which one was safer, cleaner? It's jail, so it's not a happy place, but which was less bad?
Atlanta Detention.
Why is that?
It's cleaner. The officers are great. I mean,
It's not the same. I thought they moved the same staff.
it is, but they've changed a lot. They've been recruiting a lot of officers now. We have a microwave, TV. It's more comfortable as, as it can get, I guess. But
Okay.
That's really it.
Good to hear, since that's where you are, but that's where female inmates will be housed. And you're one of the first who maybe was at both, and it was good to hear that contrast. If I didn't say it, I think I did, but if I didn't, you do need to get your GED. GED, 120 hours community service, no violent contact with the Boyd family. And that's it. Thank you, everyone.
Does she need a report date?
Oh, right, don't leave. Ms. Tucson.
Hello.
Hi.
Hi, Miss Brown, Miss Wood, so kindly, she sent me over your address already, via email. So I do have that here, and your phone number. So it looks like that is in Fulton County.
Yes.
So you're gonna report. I will call you and confirm that the address with you, but it's at 276 Memorial Drive in Atlanta. It's not too far from the courthouse. And you're gonna report June 27th at 8 a.m.
Okay.
Thank you, Ms. Tucson.
No problem.
Thank you, Judge.
You bet. Let's bring Mr. Johnson out.
Judge, if I may, can I step out for just 1 second?
Ms. Nelson, we're going to need to start the 1 o'clock calendar at 1:30. I'll say that again when we wrap up, but this has gone a little bit later, and I won't be able to start till 1:30.
Okay, Judge.
I know for the lawyers here, that's easy to tell, but like Mr. Florio may be showing up, but we just let him know it's 1:30. All right. Last thing for this morning is to work through Mr. Johnson's situation. He is here at the podium. Are you already back?
Yes.
Okay, that was
Person
fast.
didn't answer.
Okay, great. This is position 16 on our final plea calendar, 22 SC 185423. And Mr. Johnson is charged with aggravated child molestation and child molestation. You are on our July trial calendar. Today is final plea date, so we're going to cover a few things and we're going to talk about bond. Okay. Mr. Johnson, I'm going to hear from, do you have what Mr. Shapiro's
For the
offer is for Mr. Johnson?
Yes.
And what is that?
life to serve 25 years, the balance on probation as to count one, as to count 2, 20 years to serve 19 with the balance on probation.
Okay. And we learned that that's how you have to structure count two. Mr. Johnson, if you were to enter a plea today, the state would be recommending that you serve 25 years in custody, followed by a lifetime on probation. Do you understand what that recommendation would be?
Yes.
Okay. Are you interested in entering a plea today, or do you want your case to move to the trial calendar that it's on in about a month?
Move to the trial calendar.
Okay, we'll do that. The one thing that'll change after today is that if you do decide to enter a plea, maybe the state comes up with a different offer. Even if they don't, you can always enter a plea, and it's what we call a blind plea. Your lawyer would argue for A, and the state would argue for B. After today, if you do that, and I accept your plea, you would not be able to withdraw that plea if the sentence I gave you was more severe than what your lawyer asked for. So just to use real numbers, if Ms. Wood said, Judge, I think a fair sentence for Mr. Johnson is 10 years. And the prosecutor, who's Mr. Shapiro, that's who'd be here for the plea, would say, no, we think it should be 15 years. And I said, I'm going to go with 13. And I sentenced you to 13. 13 is more than 10, but that would be your sentence. You could not withdraw your plea. Today, if I were to sentence you to more than what Ms. Wood asked for, you could withdraw your plea. Say, Judge, I was willing to accept X, like my lawyer argued for, but not more than that. So no, thank you. I'd rather go to trial. So that's what changes after today is you don't get to withdraw your plea if you even decide to plea. You understand that?
Yeah.
Okay. Then let me ask Ms. Wood one more question, and then we'll talk about bond. Ms. Wood, do you have the discovery you think you're entitled to be prepared for trial in July?
Yes, Judge.
Great, then we're ready for trial. We'll keep the case on the trial calendar. And now we're going to talk about bond. Ms. Wood?
Thank you, Judge. Mr. Johnson has been in custody 265 days so far. He does have a $50,000 bond set currently. He and his family are unable to make that at this time. We're asking the court to consider reducing it or cutting it in half. So he believes he might be able to make a $25,000 bond on this case. He does have family support. His wife and his brother are both here in court today, Judge. He is 31 years old. He's a lifelong resident of Georgia. As you can see, he does have family here. He doesn't have any children. He's an Alpharetta High School graduate. He is battling through some pretty serious health issues, namely cancer. And before that, he was battling some other health issues. So he does receive services from the government, Judge. I don't believe, and Ms. Willingham can correct me, I don't believe there's any felony convictions on his record. So we just want to let the court know about that. And he can live away from the incident location. So that is not an issue. He has no issue with a stay away, an ankle monitor, or any other type of bond conditions the court would see fit.
I'm just looking at the bond. So the bond said stay out of Sandy Springs. So you'd be living not in Sandy Springs.
That's correct.
Okay. Okay. Anything else, Ms. Wood?
No, Your Honor.
Other than the passage of time, which has demonstrated Mr. Johnson's inability to make the bond, has anything else changed?
I don't believe so, Judge.
Okay. Thank you. Ms. Willingham.
Your Honor, Ms. Woods would be correct in that the defendant has no prior conviction. However, the victim in this case is a 4-year-old little girl. The allegations are that she was digitally penetrated by the defendant. Her medical records show signs of injuries. And again, we recognize that the defendant has no criminal history, but based on the nature of this, like that's all I can provide it, the state would ask that it remain at the current bond that it set. I believe that $50,000 is sufficient. And granted, I recognize the defendant has remained in custody during this time, but it does not appear from defense's argument that much else has changed. So the state would ask that it remain as it is.
Okay. Mr. Johnson, what city is the house in where you'd be living?
In Atlanta.
And Judge, I do have that address, if the court needs it.
Okay, I'll get it in a sec. And Ms. Willingham, you don't have any information, I know you're doing this secondhand, that the state would not be ready for trial on this July calendar.
I do not, Your Honor.
Okay, it's not the victim, alleged victim is in pocket, et cetera, as best you can tell.
Per my records, yes, let me do one more double check in the notes section, just to make sure. Yes, it actually looks like, we last communicated with the victim back just a few days ago. It looks like we last spoke with the victim. I do not have a date, but I do see where our victim advocate reached out to the victim on June 5th, and she just texted me back and said that she did speak with the victim's mother. So I would anticipate that was sometime this week, specifically either yesterday and she spoke with her on Tuesday as well.
Okay.
And she is also opposed to a reduction of bond.
All right. Mr. Johnson, let me ask this, and you share only what you're comfortable sharing. Ms. Wood mentioned that you're working through some medical issues. Is there care that you could receive if you were not in custody that you're not receiving now? Or I understand you want to get out. That's a separate issue. Who wouldn't? But I'm going to make it real simple. If what you needed was to get stitches in your finger and the jail is saying, we don't do stitches. Well, I need stitches and the doctor's saying I need to get stitches. That's different from I need to be taking this medication and I'm getting the medication. I'd rather be home with my wife and my dad, but I am at least getting some medical care. What are you comfortable sharing with me on that front?
Well, just technically, basically what current situation, I mean, it'd be better if I get a lot of medical attention on the street than actually in here.
Okay. You think you could get better, more focused medical attention?
Yes.
You call it on the street, meaning not in jail.
Yeah, not in jail.
Right.
Correct.
Not like some random doctor on the street, but being able to go to the hospital or a doctor's office at your pace rather than the pace of being in custody.
Yes, that's correct.
Okay. All right. So two things. One, I'm going to leave things as they are until the trial calendar. If we don't reach your case, I will reduce your bond because your lawyer is saying she's ready to go. So if for whatever reason your case doesn't resolve by way of a plea or some other case goes forward or the state says they're not ready, I will reduce the bond. The second thing is I will invite Ms. Wood, should she choose to, after she talks with you, to put together something. It could be presented in camera, maybe filed under seal, that helps me better understand the medical situation. So that if there's information I should have that speaks strongly to the point of you need to be out to get medical care that is life-saving, then that would be another reason to be thinking about this differently. But what I'm hearing right now is the best way to ensure that we can get this case tried, have you there, et cetera, is to maintain the status quo. The reality is you have a bond. It sounds like it's one you can't make. It doesn't sound like it. You obviously can't because you're still in. And so I will, all Ms. Wood needs to do is remind me, which I'm sure you will remind her, that if we don't try your case on this July trial calendar, then I will reduce your bond. Obviously, the state will get to chime in about how much and other conditions. I'm looking at the conditions that Judge Farmer set, and they strike me as pretty darn reasonable conditions. The dollar amount apparently was it was outside the financial reach of your family. Okay.
Okay.
All right, Ms. Wood, anything else?
No, Your Honor, thank you.
Ms. Willingham?
Nothing further, Your Honor.
So we're going to take a break. We are going to reconvene at 1:30, not at 1. And Ms. Willingham, if you could either you come back for Mr. Davis or equip someone to play Mr. Shapiro in the Davis case. So we'll know, is it really 5P? Is it workoutable?
That's what we're working on now, Judge. If I do not appear in person, I will definitely log on Zoom, but I
Great.
will handle it.
Fantastic. I mean, it's just as long as someone says, I'm here for Mr. Shapiro, and hopefully you'll be able to connect with him. He'll have to get a lunch break soon too. We'll
Yes,
sort
they
that
are
out.
getting ready to go on lunch break, so I plan to confirm then.
Great.
Thank you.
You're welcome. So, Ms. Tucson, Ms. Rivers, Ms. Hardy, we'll be back at 1:30. I know the calendar is published for 1, but I thought this calendar would be over or like 11, and it's a little after 12 now. So I'll be back at 1:30 to do our afternoon half.
Thank you, Your Honor.
Thank you.
Okie dokie, thank you.
on break until 1:30.
Well, they told us that it was going to start at 1.
They want you to be early. They want you to be on time.
So do I just stay here?
So, yeah.
And when they come back, it'll come on?
And it should.
Okay.
It should pop up
Yeah.
when they.
I just thought it would be smart to get it
Yeah,
done.
that's probably what that is they're like, well, tell
Okay.
everybody 1 o'clock and make sure they're here.
Okay.
They don't want to wait.
Yeah. Okay. Thanks so much.
They pretty much won't wait.
I know.
So, yeah, I'd say that's what that is.
Hey, Linda.
Hey, Juanita, how are you?
Okay, are you headed to Nashville?
Well, you know, the case, Jay's case, they're having a trial, they're having a hearing for the man that was involved. And it was supposed to have been at 9 o'clock this morning, and they put it off until 1 o'clock. And now I've gone on and they're saying they're on break until 1:30. And what I'm planning to do, I'm already packed and ready to go. And as soon as this hearing is over, I'm going to go to Nashville.
Okay.
And I'll probably, you know, I might get there 7, I don't know what time. It just depends on when this hearing is over.
Okay.
But I thought it would be good for me to go to Nashville and be with Linda because, you know, these hearings are kind of upsetting.
Yes, I'm sure. Sure. Well, I've missed talking with you, and we said we're going to talk, and we don't.
I know. And last night I was texting you from Jazz, and I thought, I just wish you would come and we would just start doing some things together.
I will be there. I will be there. I'm trying to adjust to my new life. And but I will be there. I plan to go next week, hopefully.
I don't know whether you want to go next week because Ben Freeberg is there.
Well, I kind of like him.
Oh, okay. Well, I'm not planning on going.
Okay.
One time Randy and I were there, and there was only his mother and his father and Randy and I. And I couldn't leave.
So that says a lot right there.
Well, but that was a long time ago.
Okay.
That was a long time ago. But he's
how are
just
you feeling and what's going on?
well, I've been just running all week. And I'm feeling good. My cough seems to be coming back.
Oh, no.
Well, you know, I didn't smoke any weed from the time I had pneumonia until I got back from my trip, my hiking trip. And I've been smoking again now for about a month. And that's when my cough came back. So I'm going to go to Linda's this weekend. I'm not going to take any smoke, and I'm going to see if my cough is better. And if it is, I'm going to have to stop smoking.
That's what it sounds like.
But, you know, a lot of people, there's a lot of allergies going on, and I don't really know what it is.
Yeah, there is a lot in the air, and that's why I'm not out places, and you know, I'm only out when I have to be. You know, I feel like as I get older, I'm getting a little more delicate, and I do miss smoking. I will say that I really do. But I had this tea that I got from my hairdresser. I'm gonna get some more. It was out of this world. I went, oh my God. It made me feel like when I first had the experience with marijuana.
All right. Well, maybe you can get some for me. I'd like to try it out.
Okay, I'll ask her. I will. So now tell me about the hearing, the trial. What's going on?
Well, you know, about 3 weeks ago, they had the trial with the woman. And this man's last name, I think, is I can't even remember his name. Anyway, they will call him up, and he's trying to get a plea bargain because he wants to get out of jail. And they'll ask him all of the circumstances of what happened that evening with Jay.
Linda?
Yes.
Hey, it's Dawn. You're on speaker, and so everyone in the court can hear you.
Oh,
can you please mute yourself so that your conversation's private?
Oh, okay. Well, tell me, it's saying here that they're on break until 1:30.
Right, but you don't want anyone walking in the courtroom as you're having
Oh,
conversation.
all right. So I'll mute it and I'll stay here. And when it comes on, I'll unmute it.
Right. Well, you should mute it because if anything happens as the court is proceeding, if you don't mute it, the judge will mute you automatically. No one wants to hear the background.
All right. I'll keep it muted. And I'm sorry. Thank you so much for telling me.
Yeah. No worries.
Okay. Love you.
Love you. Bye.
Bye-bye.
I thought this thing was at 1 o'clock. Okay, well, I guess maybe something like last time happened. I don't see you.
Catherine, is that you?
Oh, I'm not muted. Hello, yes.
Yeah, can you mute, please?
And now mute. What about now? Can you hear me? Is it good?
Yes, we can hear you.
But
you have to mute.
But I have muted. I have put down here, it says mute.
Click on it.
I did.
It should say unmute. Lulu, you're good. You're unmuted now. It's where you want to be.
Well, she was just.
We're on break till 1:30.
I got out.
We ought to be able to hear.
Isn't this weird? They're talking.
Is your sound turned up?
It's down, it's up.
Click on that in the right-hand corner. Let's see if that does anything.
Let's see.
Here.
Just be patient, everyone. The judge is not back on the bench yet.
Okay. So what happened?
He didn't answer, so I left him a message as if, I said he didn't answer, so I left him a message as if I'm inquiring on the property.
Oh, okay.
Tricked me. I'm gonna see what it tells me as far as how to get
Yeah,
there.
I'm curious. Because I don't think that's safe for her.
Let me see what directions he gives me.
Okay. Are they there? Okay, so mute yourself back. We should be able to hear something. Okay. Why can't we hear? Let's see.
Okay, I'm sorry, we're starting late. 1:30 was our reset time, but it is past 1:30, and I apologize for keeping people waiting for our afternoon final plea calendar. Our morning one ran a little bit late. I had to shift a few things around. Ms. Rivers, are you able to hear us?
Yes, Judge, I am.
Fantastic. Okay. So for our final plea calendar, we will be working through whether these cases are ready for trial, if we're resolving them today, or if there's something else going on. Our first two positions are Mr. Florio's. I think I saw him just emerge. How are you, sir?
Good afternoon. It's good to see you, sir.
Same. You represent Mr. Bethea?
I do, Judge. Both cases should be negotiated pleas for your consideration this afternoon. There's just one minor detail on the second case that I needed to speak with the state, but absent that, he signed all the documents.
Fantastic. So we'll get through the calendar and then we can take Mr. Bethea's pleas. You'll have a chance to speak with Mr. Peoples. I don't know if you two have met. He took over Mr. Jordan's docket.
Yes, sir. We were able to speak and meet, and he's been very, very helpful.
Well, that's a good start. All right.
Yes, sir.
Good. Okay. We will take care of those. That gets us to position 3, which is Ms. Young. Is Ms. Young here? Hey, Ms. Young, how you doing? I'm all right. Your lawyer is in trial in another jurisdiction, and I was hoping she would have reached out to you. I'm glad you're here. It's always good to reconnect with you, but she asked that we reset this so that it doesn't collide with a time when she has to be in another courtroom. Let me see if there is already a reset date, and if there's not, you'll get one in the mail. But have you spoken with Ms. Mignot before? Well, let me give you her information so you can reach out to her. We probably wouldn't have sorted things out today if she had been here, because you would have been meeting her for the first time. Do you have something to write down with, or I'm happy to write? You do? Someone's got something? Great. Okay. So let's write down 2 things. Your next court date, and you'll get something in the mail, is August 15th. August 15th, 2:00 here, August 15th. Before then, you'll want to connect with Ms. Mignot. That's spelled Mignott. First name, Marcia. And she's been appointed to represent you. She's going to stay with you. So you've got a lawyer now. This is a case, Mr. Peoples, that Mr. Jordan had represented. This defendant in this case has been represented to me, and I think Ms. Young has been in courtroom to hear it. Her connection to the case, Mr. Jordan described as very work-outable, but Ms. Young has been needing a conflict defender throughout, and that didn't go anywhere. Ms. Mignot has been appointed to represent Ms. Young. It's not binding you to anything. I'm just letting you know the way it was represented to me and to the conflict defender's office initially.
Understood, Your Honor. I believe I've had a few conversations with Attorney Jordan, and I think it's something we can work towards.
Okay. And here's the other piece. You will want, Ms. Young, Ms. Mignot's phone number, 770-621-5499. Did your personal secretary get all that? Okay. And the email address is Marcia, Marsha, @ and then the way you spell her last name, Mignot, law, that's all one word, .com. Okay, so what's the date you need to be back here? 2:00. You'll get something in the mail. Are you, it's the wrong screen. Still living in McDonough? Okay, you'll get something there, but Ms. Mignot and you will be talking before then, I hope. So you should reach out to her, leave a message, give her a good way to contact you, whether that's your friend's phone or you've got your own phone, so that you guys can start talking about the case, okay? Any questions? Any questions from your personal assistant?
She wants to know about the curfew.
What about the curfew?
Is it still in effect?
Well, it's not her curfew, right? It's your curfew?
Yeah.
Okay, let me look. I mean, the answer is yes, unless, that would be a good thing to talk to Ms. Mignot about. It would be, I've been on bond for, it looks like 3 years now, and dang, why do I still have a curfew? I show up for court every time, and could we modify that? She could call Mr. Peoples, and I bet without you having to come back to court, we could modify it. So your bond, said you have to stay away, actually lists a co-defendant, I think, as the victim, but stay away from the co-defendants. No Family Dollar stores. Yeah, curfew. Huh, look at that. So talk to Ms. Mignot about that. That's an easy fix, I suspect, if she talks with Mr. Peoples, because it sounds like now for 2.5 years, you've had no problems, and we ought to be able to dial that back. I can't do that without your lawyer here. Okay. Any other good questions from your sidekick? No? All right. You're free to go. You're welcome. Next is Mr. Tuitt. Did I pronounce that correctly, Mr. Melnick?
Yes, good afternoon. Judge, there's still outstanding evidence that I need to get from the state. There are ballistics from a firearm that was found on the scene of this incident, as well as DNA and fingerprints that have not yet come back from the GBI. So we're not really ready to do final pleas today.
Okay. Let me. That's what I was looking for. So Mr. Tuitt is on the July trial calendar. It's about a month out. You're shaking your head. So tell me what evidentiary motions would flow from, let's say that it's your client, I'm making it up, your client's DNA on the gun.
Or the victim's DNA on the gun, is what I'm more suspecting.
Okay, so it's not so much that there'd be motions, as there would be a different factual posture for the case. Okay. Mr. Abate, what's your understanding? I know ballistics you can often outsource and get pretty quickly. I haven't heard about outsourcing DNA.
I put in a call with the GBI today. It's a possibility to outsource the DNA. It's very expensive, so I'm gonna see if the GBI can somehow work in the ability to do some sort of expedite for DNA.
Okay, well, before you outsource it, I guess, huddle with Mr. Melnick, because if he wouldn't, he seems to be asking for a continuance, or at least not opposing one, so that all the evidence is available to both sides. I wouldn't want that to cause GBI to say, oh, it's not urgent anymore. But I'd love to save everyone in this room who is a Georgia taxpayer some money, rather than outsourcing it. But you agree that DNA, fingerprints, and ballistics are fingerprints still outstanding? Maybe.
It's not fingerprints, touch DNA. So it's all DNA.
Okay, got it. So DNA and ballistics.
Yes.
All right. Mr. Melnick, no pending motions. Not at this time.
Not eligible for immunity, so that would really be the only sort of.
Okay. So it's not an immunity situation. It could well be a self-defense situation. It could well be, look whose DNA was on the firearm. You're certainly entitled to that. The state's going to want that, because if it breaks in the opposite direction that you're forecasting, that might change how you and Mr. Tuitt talk about next steps. So it doesn't seem like final plea is appropriate at this time. What if we preserve your client's final plea rights? We'll keep it on the July calendar, but it's now on my radar that this is one that will probably have to roll to the next trial calendar. But if GBI next week says, hey, here are all the results, then unless you're going to hire an expert, then you would have the tools you need to either work on Mr. Abate to change his view of the case, or to work with your client to maybe help him reshape his perspective.
That's fine with me, Judge.
Okay. Mr. Abate, does that work for you?
Yes, Your Honor.
Is there other discovery that you're missing, Mr. Melnick? It sounds like you've got a bunch because you were able to know these pieces were missing, but from what you've got, do you feel like there's anything else missing?
No, Judge, I think I've got everything else. It's not a real, other than these pieces of evidence, there's not a lot to this case.
Okay. Do you want me to tell Mr. Tuitt what we just talked about, or you're fine?
I want to speak with him anyway.
Okay, so we'll keep him up. You'll talk to him, but he doesn't need any judge time.
That's correct.
Okay.
I also have an outstanding bond motion in this case that I'd like to put on.
Oh, in Mr. Tuitt's case. Okay, is that something that we gave the state notice for not for today? So reach out to Ms. Nelson and we'll get it calendared. All right.
Yes.
Okay, Donald Young. Is he in custody?
He's right here. You're
He's right here. Okay, it just says outsourced to Cobb County. Did he get out recently?
Yes, you're right. Last time we were in court, he got a $5,000 bond and was able to bond out.
Okay. Well, Mr. Young, why don't you come sit with Ms. Sarfarazi and we'll work through the final plea. Who's handling this for the state?
ADA Willingham on behalf of ADA Shapiro.
Great. There you are. Okay, let's get on the record with position 5. It's 22 SC 185516, State versus Donald Young. Mr. Young is here in court with his lawyer. So this says status hearing on the calendar, but it's also final plea. I don't want to get us out ahead of where we should be. What was your understanding, Ms. Sarfarazi, of what we're doing?
I was understanding this was more of a status. We just got an offer from Mr. Shapiro last night. I have gone over it with Mr. Young. We're not where we need to be with that yet. But I haven't had a chance to talk with ADA Shapiro because my understanding he's in trial. So I haven't been able to talk with him since receiving the offer. Additionally, Your Honor, ADA Shapiro indicates to me that there was some Grady imaging at some point, and I haven't received that yet. So
Grady.
There is some Grady imaging that had been taken at the hospital of the victim.
Okay.
He said that he was waiting to receive the Grady imaging before he would offer me, we try to get an offer beforehand, but before he would give me an offer, he wanted to get that first, and we haven't received whatever that is.
Okay. So Grady imaging, meaning like an X-ray or an MRI, some type of investigative work. I don't want to use that term because it's doctors, but they did some work. You don't have the results of that.
Some type of medical testing was done. I don't know the extent of it because all he said was Grady imaging. So
Okay.
I'm not sure exactly what it is, but that's where we are at so far.
Okay. My thought then is that we preserve Mr. Young's final plea rights, keep his case on the July trial calendar. Ms. Willingham, if you will just make a note for Mr. Shapiro that he needs to let us know what's going on with these Grady images. If he doesn't have them yet, he can't hand them over, but someone needs to get them. Of course, you might be able to get them with a subpoena or something with my assistance as well, Ms. Sarfarazi. It sounds like that's the outstanding piece of discovery. You want to talk with Mr. Shapiro more, which I understand. Is there other discovery you feel like you're missing?
To my knowledge, that's everything that is in the case. We do have everything else to my knowledge.
Okay. All right, so we'll work on getting the missing Grady records to the state if they don't have them, to you once they get them, preserve Mr. Young's final plea rights, and anything else that I need on my radar from the defense side?
No, Your Honor. Would you like the plea offer that was offered last night on the record?
No, because I'm preserving Mr. Young's final plea rights.
Okay.
This is the case where the child is in St. Louis.
Yes, Your Honor.
I'm remembering now. So we just had this bond hearing. This is the one where you all had agreed to a bond, but I said, I need to learn more about the case.
Correct.
You educated me. I signed this bond. Mr. Young has made the bond. Mr. Young, I think you are able to have video and telephonic contact with 7?
Supervised
Right,
yeah.
correct. But you're not going to St. Louis. This is all remote contact with an aunt or a grandmother or someone who is on with, is it your son?
Yes, it's his son.
Okay, all right. And you're living in Hampton?
Yes.
Okay, all right. Then keep complying with those conditions of bond. You'll be able to stay where you are. I will see you again for the July trial calendar. Before then, hopefully Ms. Sarfarazi gets these Grady records and she and the prosecutor can keep talking. If it's going to be a plea, we can take that at any point. And I'll keep your final plea rights open through that trial calendar, which means you'd be able to enter a plea. And if I sentence you to more than you asked for through your lawyer, you could withdraw that plea. After your final plea rights expire, you can still enter a guilty plea, but you roll with the sentence that you get. Okay?
Okay.
Any questions about anything?
No, sir.
Ms. Willingham, anything from the state on Mr. Young's case?
No, Your Honor.
All right. Thank you for filling in for Mr. Shapiro, and thank you, Ms. Sarfarazi.
Thank you, Your Honor.
Thank you.
Yes, ma'am.
Not as to Mr. Young, but that would conclude my business as to this afternoon final plea. But I know that we had a case
John
that
Davis. Yes. Okay. Tell me, Ms. Feely, what's happened with John Davis?
As long as Ms. Willingham has, is confident she has a correct offer to put on the record, we'd be ready
To go forward with a plea?
well, it depends on what the plea offer is.
Oh, okay. So tell me, we'll get Mr. Davis out here. What did you learn over the lunch break, Ms. Willingham, as to what the state's offer is for Mr. Davis?
So the offer that I presented as to that first count is, or as to the first position is correct. I do not know whether that offer, Mr. Peoples would need to, it's my understanding from Mr. Peoples that that offer would also be, it could rope in his second case as well. I just got that update now. But the probated offer that I presented as to position 1 is correct.
So what I'm hearing, and we'll confirm this on the record with your client here, Ms. Feely, is that the state would recommend a term of 5 years probation across both cases.
And that he would very much like to take, but I just handed Mr. Peoples what I received from Mr. Shapiro, which is different.
Okay.
I spoke with Mr. Shapiro, and he does recognize that the offer that Ms. Feely may have received is not the most updated offer, but he stated that the offer he provided me as to position 1 was correct.
Okay. So Ms. Willingham, if Mr. Davis wants to go forward with this, would Mr. Peoples, who's here in court, be able to handle the plea on both cases, or would you have to be involved?
I can send it to Mr. Peoples if he's comfortable doing it.
Why don't we do this? Why don't you all communicate via email or secret DA channel and let me know? I'm just trying to free you up. Mr. Peoples is here for a few other cases. And so my thought was we'll do Mr. Davis's plea after we clear out the courtroom a little bit more, because there may be some quick touches And the plea will just take a little bit longer. And so if Mr. Peoples could do that, then you're good to go. Why don't you guys communicate? And if he lets you know that he's all right taking the plea on both cases, you just disappear in a good way.
Thank you, Honor.
All right. All right, let's get to Mr. Abate's other case, which I think is the next 545, the next 4 positions. It's Mr. Lemons. Is his lawyer here?
I'm here, Judge.
There you are. Fantastic. Okay, let me put you right there, and I will remove Ms. Willingham. How about Mr. Regis?
Good afternoon, Your Honor. I am present.
Hello, sir. Good to see you. And Ms. Feely, you represent Mr. Ryder?
Yes, sir.
Great. Mr. Robinson is in a transitional state. Unless Mr. Luemba is here, in theory, he was representing Mr. Robinson. He has, despite my repeated request, declined to file an entry of appearance. And so we may be lining up another lawyer for Mr. Robinson. But my suggestion is that for Mr. Lemons, Mr. Hardy, and Mr. Ryder, we do the final plea together, unless the defense attorneys tell me, nope, that's a bad idea and we should do them separately. And I will definitely take a lead from you 3. Hearing.
I prefer that they be handled together. I had a chance to talk to Mr. Abate earlier today, and there's still some other things to discuss. So I prefer they be done together, if that means it's a day different than today.
Oh, well, no. We're gonna, the 3 lawyers I've got here, we're gonna process this case some and figure out what's next. It may be that then there is a lag because Mr. Robinson will need to catch up through his counsel, assuming Mr. Abate's preference is let's keep all 4 together. He may say there's a Bruton issue and I couldn't try Robinson with the other 3 anyway. I feel blessed to have you and Mr. Regis here. And so I want to use that opportunity to at least get an update from the 3 of you, including Ms. Feely, as to where we are with discovery and motions and whatnot. And so we will do that. What I'd like to do, Deputy Gordon, if you're all right with it, is bring out Lemons, Hardy, and Ryder. Can we do that, or is that too many people? We may need to shoo a few people away from the defense counsel table. Lemons, Ryder, Hardy, please. What that noise was. And I would like in the future to be as accurate as I can be, Ms. Cabrera de Moore. What is your preferred last name?
Cabrera, Judge.
All right, so just the first half is okay. There's
Yes,
not
sir.
a Mr. or Ms. de Moore who's going to come after me saying, why do you keep
Nope.
cutting me off?
No, you're fine, Judge.
Okay, great. Thank you, Cabrera it is.
Thank you.
Him here?
No, he's gonna sit there.
Mr. Regis, where else have you been today? I'm always fascinated to hear your itinerary. All Fulton?
All Fulton today.
Well, lucky you. Mr. Abate, do you mind sitting up? I know you like that front row, but if you sit, you can sit right between. Mr. Hiles doesn't even have to leave. All right. Ms. Rivers, if we could get on the record, please. This is positions 6, 7, and 8 from our final plea calendar. It's 22 SC 185545. We have Mr. Lemons, who should be sitting in front of the camera. You, Mr. Lemons?
Yes, sir.
Fantastic. Your lawyer, Ms. Cabrera, is right there on the screen. You see her?
Yes, sir.
Great. She sees you. We have Mr. Hardy, who is seated with his lawyer, Mr. Regis. Hey, Mr. Hardy. And we should have Mr. Ryder. Mr. Ryder is in the blue outfit, and he is seated with Ms. Feely, his lawyer. Gentlemen, we're going to talk a little bit about where we are in this case. You all have been sitting around for a while, and I am, as you are, I am sure, anxious to move the case along. You each have lawyers, you have good lawyers, and they are lawyers who are going to stay on your case. And I'm going to hear from each of them as to where they think they are in the process. Yes, we've got discovery. We think something's missing. We filed motions. We are going to file motions. There are no motions to file. We're ready for trial, whatever the answer is, so I can keep moving this forward and we get a final resolution, whether that means your charges are dismissed, you plead to something, or you go to trial and a jury decides what happened in this case. That's the three likely outcomes here. And I'm going to just go in the order you appear on the calendar. That signifies only how the calendar got put together, which means I'm going to start with Mr. Lemons and Ms. Cabrera. So Ms. Cabrera, where are you in the discovery process with Mr. Abate?
So Mr. Abate sent me he sent me a link this morning for discovery. I know a great deal about the case, but that's predominantly because I've been able to speak to my client about it. I do not know what may be in the link that Mr. Abate has sent, so I need to review that. Definitely don't want to take the case off of its trajectory or out of its dates. I just want an opportunity to review what he sent me this morning.
Sure. And what he sent you would be supplemental discovery, or it's really the first meaningful batch of discovery?
It's the first meaningful batch. I checked to see if anything else was sent before, and he may have, but I definitely don't have it.
Okay.
But I'm familiar with the case because Mr. Lemons has kind of filled me in and given me an idea. But I do need to see what was sent to me.
Sure. From your discussions with Mr. Lemons, is it your sense that you might have evidentiary motions, suppress a statement, suppress ID, or that's not the nature of the way Mr. Lemons and law enforcement interacted?
I wanted to see if there's a statement that appears with what Mr. Abate has sent to me. If so, there may be a motion in relation to that. But I can't, from what Mr. Lemons has told me, nothing beyond that.
Okay. How much time would you like to be able to go through discovery to let me, Mr. Abate, and Ms. Nelson, my litigation manager, know if you're going to have any evidentiary motions?
No more than 2 weeks.
Okay.
I can start to read things this weekend.
Okay. Sounds like a great weekend project. All right.
Have a motion, Judge. She'll file a Jackson Deno.
Okay. There is a statement from Mr. Lemons.
Yes.
Okay. Great. We'll talk about deadlines in just a minute. I just wanted to get your input on that. Anything else, Ms. Cabrera, that you want to put on my radar in terms of how we schedule this?
I am specially set, I think September 25th. I don't have any other special sets at all, but I know I'm specially set September 25th. I think that's a Monday.
Okay. Well, we'll obviously have to stay away from that date, but it sounds like you will dive into the discovery. You'll stay well connected with Mr. Lemons, and we'll set, before we leave today, a deadline for filing evidentiary motions, not motions in limine, but suppress this, suppress that, so that then we can get a hearing date. And ideally, it'll be the same for all the defendants who are similarly situated if there's more than one defendant who gave a statement. Mr. Abate, anything else you think I ought to know or Ms. Cabrera ought to know in terms of the state's case against Mr. Lemons and prepping that for trial?
No, Your Honor.
Okay, great. Thank you. Please stay on, Ms. Cabrera, and let's turn to Mr. Hardy and his lawyer, Mr. Regis.
I request that link as well. I just checked. I don't know that I've seen it, but I certainly would request it.
All right.
As it would be my expectation that this case would be going to trial. I don't know about any motions as I stand here right now, but I do expect a trial in this case, Your Honor.
Okay. Ms. Cabrera indicated that she thinks that within about 2 weeks, and my thought was to set a deadline of 2 Fridays from now, so 2 weeks plus a couple days, as a deadline to file evidentiary motions. Would that work for you as well?
Yes, Your Honor.
Okay, great. So we'll make sure you get the same link. You'll go through discovery, you'll confer with Mr. Hardy, and any motions that would require an evidentiary hearing, you'll have filed by that date. And I'll get an email out to everyone memorializing this because it'll help me remember. Mr. Abate, same question, but now vis-a-vis Mr. Hardy. Any preparation information we should have?
No, Your Honor, and I think some of the issues are when opting into discovery is not, when a motion isn't filed, that's usually the thing that alerts the legal assistants to serve the discovery. So I know that wasn't done, at least for Mr. Hardy, so I will get him, Mr. Regis, the link today, but that's
Okay.
the issue.
Great.
I apologize. I'll confirm that as well.
Thank you. Okay, and I know you typically do that, but this was one, I don't, you've been assigned cases through a couple different ways as we've been coordinating with GPDC. If you file an opt-in, that'd be great. I'm hearing you orally on the record, opting in discovery.
That's correct.
Great. So Mr. Abate will get that link to you. Do you recall, just offhand, whether Mr. Hardy would be in the same situation of there's a likely Jackson Deno?
I don't believe there's a Jackson Deno that would be required for Mr. Hardy, and then Mr. Regis should have the link here in about 10 seconds.
Okay, great. Well, you have some waiting for you when you get back to the office.
Based on my conversations, I don't expect the Jackson to know.
Okay, great. You'll still have that same deadline and we'll see what lands.
Thank you, Your Honor.
Great. And now let's turn to Mr. Ryder and Ms. Feely. Ms. Feely, your discovery situation.
I got the infamous Dropbox link last week. I've done a cursory review. I don't note anything major missing. And the June 23rd motion state, I think would work as well.
Okay. Excellent. And Mr. Abate, anything about Mr. Ryder's situation that is different, unique, special?
No, Your Honor, and I'm sure Ms. Feely will probably file a Jackson Deno motion from Mr. Ryder.
Okay. Bruton, do you foresee any issues, not a binding answer, but you seem to be dialed in enough already that you know who's made statements. Is there anything that we would need to navigate in advance just in terms of lining up a trial for 4 people versus it would have to be 2 or 1?
My intent would be to try them all together. You could say there are Bruton issues, but I think they fall under exceptions that would make it to where it's not a Bruton issue.
Okay.
A co-conspirator statement or something
Sure.
along those lines.
And we'll litigate it if it gets flagged, but you don't, sometimes you have a case where you say, I'm gonna have to use statement A against defendant B. So I
don't have that.
State would be moving to sever in order to use the statement.
I don't intend to do that.
Okay.
It is a possibility. There's a defendant who makes statements about several of the co-defendants, and I believe that can come in through the co-conspirator exception. But if it doesn't, we may be in that position. It's Mr. Lemons, maybe that individual.
Okay, well, we'll work through that process if and when it arises. Excellent. So I'm gonna circle all the way back around. Ms. Cabrera, anything else before I thank you for being here and let you go?
Nothing else, Your Honor. That's all.
All right, great. Mr. Regis, same question.
Nothing wrong.
All right, thank you for being here. And Ms. Feely, you're all set.
Thank you.
All right, gentlemen, we will see you again. Maybe all 3 of you, if everyone files motions, it all depends what's in discovery. It may be a subset. It's sounding like it might just be 2 of you to work through some of the pretrial motions. And then we'll have one last conversation before trial. But my goal is to get you all in front of a jury, if that is your desire, sometime late this summer, not when Ms. Cabrera has that specially set trial somewhere else. And when Mr. Regis is in Fulton County and not one of his other counties he has to be in. Okay. Thanks, everyone.
Thank you, Ron.
Thank you.
Yes, sir.
Mr. Robinson not coming up.
He is. He's going to stand right there in the doorway. Your case, Mr. Hiles, just has one defendant?
Yes, Your Honor.
It's not like you.
It's not.
Hey, Mr. Robinson, I'm Judge McBurney. How you doing? I've been receiving all your motions, so they aren't just falling into dark space. I've also been working hard to get a lawyer appointed to represent you. And I think we've about closed that loop. So I didn't want you to think, wait a minute, these co-defendants are coming in and talking with the judge and they've got lawyers. The goal is to keep you moving in sync with the three co-defendants, but I can't do that. And you can't do that till we get a lawyer to represent you. That lawyer will review the things that you filed and may adopt them, may explain to you why that wasn't the right thing to file, but we'll need to work through all those things and have a conversation about them. But I am hopeful that within the next week or so, I will have locked in a lawyer who will be appointed to represent you. And that person will get discovery from the prosecutor. The other lawyers just recently got discovery, and we'll give that your lawyer and you a chance to catch up to the other three, and we'll keep moving forward. So that's not me telling you don't file anything else. You may have other motions that you want to file, and until you've got a lawyer representing you, you're free to do that. Once you've got a lawyer, he or she is the one who should file motions, and you'll want to run them through that person. Okay? Any questions? It's a great question. We got to get you that lawyer first. And in talking with the people who are trying to staff these things, I've been told that it ought to be in the next week or so. And I will impress upon that lawyer the importance of going out to see you. Are you at being held in Cobb? You're in Fulton. What's the orange outfit? Oh, all right. Well, then it should be easy to meet with you. But that lawyer will meet with you, and then he or she can talk to you about next court date. What it probably would be to work through the motions that you filed. That's what I was explaining to the other gentleman, that the next time we're together will probably be for motions, suppress a statement, or I think you filed a demurrer. We'd work through stuff like that, assuming you and your attorney still want to go forward with some of the things you filed. But step one is to get that lawyer with you so you can say, this is what the case is about. The lawyer can say, let me show you the discovery, and then you guys will chart a course forward. But the goal, I told your co-defendants this, is to get you in court either to take a plea or have a trial where a jury will decide by late summer, early fall. You've been sitting around because we've had trouble getting a lawyer for you, and that is not your fault. There's not a real good reason for it other than that it's complicated these days to do that. You've been doing a great job filing things, but I want to get a lawyer sitting by your side who can help read through those and say, this is a great idea. Maybe we won't do that one. Okay. Thanks for your time. All right, Brian Arnold is Feely.
He's in custody and that'll be a plea.
Plea, okay. This is the co-defendant to Ms. Craig. This is the Woodall case. In fact, I think I see one of the Woodalls on the screen. Yep, okay.
So I believe the sister as well as is the widow's on the call as well.
Okay, great. We will work through that one this afternoon. Mr. Brinkley is next.
Good afternoon, Judge.
How are you?
I'm doing well. How are you?
I'm well.
Good. He is in custody, and we have a negotiated plea with a transfer of disposition to juvenile court for your consideration.
I've done those before, so that's where, and this is why you're here. Ms. Singleton is here because I sign an order that doesn't look like a final disposition. It says basically, this is what's happening, juvenile court, make it so. Is that kind of what happens?
So we don't have a transfer order, Judge. I think that might be what you're referring to. That would be under a different subsection of the code. What we're looking at is 1511-560. I think you're talking about 1511-560E. What we're talking about is 1511-560F, which would be an actual plea here in Superior Court in front of Your Honor, but disposition only would then be transferred down to juvenile court. So Your Honor would not sentence him. He would be essentially sentenced in juvenile court.
But don't we talk about what the likely disposition is going to be? It's not my order, or it's like, we'll see what happens in juvenile court.
Disposition to juvenile court. So I will be representing him as well in juvenile court when it goes down there.
Sure.
And I'll negotiate with the ADA in that courtroom, and that judge in juvenile court.
Okay.
Will make that determination.
Got it. I've done this before as well. I didn't know E versus F. I just thought that in the order I signed, and maybe in this one it did, not in this case, but in the other one, there were intimations in the order of like, we think this is probably how it should sort out in juvenile court. It didn't bind the juvenile court judge in any way, but it memorialized. I think it was more protective for the state. We're willing to let it be resolved as in disposition in juvenile court, but everyone is agreeing that I'm making it up, would involve community service or this or that. I don't require that here, but I won't be offering up a sentence. It will be, I accept your plea. I find you delinquent or guilty.
So it would be a guilty plea, Judge. It is, and the code calls it a conviction. It would be a conviction of essentially a lesser included. The one thing that I am still researching and talking to some colleagues a little bit about is that we would ask the court, and I think Mr. Hiles is okay with this, to accept the plea under first offender. The only thing that I'm still trying to figure out is whether once disposition is transferred to juvenile court, whether Mr. Brinkley, if he were to mess up on probation, would still be subject to the max on the charge here in front of you, or whether he would then only be subject to the max in juvenile court. So
I think it is in juvenile court, and I was looking at that at the same time as people I've talked to, and the last sentence of subsection F of 1511-560 is, upon such a transfer by the Superior Court, jurisdiction shall vest in the juvenile court, and jurisdiction of the Superior Court shall terminate. So
that's rough.
Yeah. So I think Mr. Hiles is right on that. I would agree with that.
Okay. And I don't need to make that final ruling. The statute says what the statute says. So it's not like me saying, no, this is what it is. I mean, you all would, whoever didn't like that determination, if for some reason I had to make it, could challenge it, but I don't think we need to go there. My hope is Mr. Brinkley's never faced with that dilemma. Okay. All right. So it is a plea-ish event.
Yes.
Got it. Okay, great. Thank you. Azaria Dyson. Hey, Ms. Dyson.
This is a case that she was in Rockdale for a period of time. We do have a misdemeanor offer from the state, but she's on first offender probation in Rockdale. So I'm trying to sort out what that would look like. And I also believe she's factually innocent. So I think at this time, even with the misdemeanor offer, we'd like to move it to a trial calendar.
Okay, let's get all that on the record. So Ms. Dyson, if you come on up, you can come up to the podium, please. Just give me 1 second. 560. Okay. Ms. Rivers, you ready?
Ready.
Great. So this is position 12 on our final plea calendar, State versus Azaria Dyson. Ms. Dyson is here with her lawyer, Ms. Feely, and Mr. Peoples is handling the case for the state. Ms. Dyson, as I understand it, it may be that you would ultimately accept and enter into a plea with a misdemeanor outcome, but you and Ms. Feely want to make sure that that would not cause your Rockdale situation to blow up and a revocation or who knows what would happen there. Is that a fair statement?
Yes, sir.
Okay. Ms. Feely, you have all the discovery in the case?
I need to go just back through and double check, but I believe I have everything I need to prepare.
Okay. Enough to be ready for trial if that's where this ends up?
Yes.
Okay. And Ms. Dyson is on our July trial calendar, so it's about a month away. So between now and then, we'll need to sort out these loose ends if that's how it's going to play out. Mr. Peoples, what is the state's offer in this case? It sounds like it's reducing aggravated assault to a misdemeanor.
That's correct, Your Honor. The state's offer would be to reduce the sole count of aggravated assault to simple assault under OCGA 16-5-20. And the sentencing offer would be 12 months of probation and completion of an anger management course.
All right. Ms. Dyson, what was the charge or charges in Rockdale that you took first offender on?
I took the first offender on the aggravated assault, but they also kept my cruelty to children to the 3rd degree charge as well. So I'm on probation for both of those.
Is that one case or 2 cases?
I think it's, all in one, but I do have 3 years for the aggravated assault first offenders. And then after that's over, I have 12 months consecutive for the cruelty to children misdemeanor.
Got it. So all one case, first offender, and that's out of Rockdale.
Yes.
Okay, got it. And Ms. Feely, you will work with, does Rockdale have public defenders?
Yes.
So you'll work with your counterpart there to get a sense of what an impact of a misdemeanor plea to what was originally an aggravated assault would have in Rockdale.
That's right.
Okay. For now, Ms. Dyson, you are declining the state's offer and would like me to move your case to a trial calendar?
Yes, sir.
Okay, got it. Well, I will do that. The only thing that will change after today is that if you decide to enter a plea, you will not be able to withdraw that plea if I sentence you to something more than Ms. Feely asks for. If the state keeps open this misdemeanor option, there's not a whole lot I could do differently than what Ms. Feely would ask for. And I'm typically, but not always, guided by what the two sides say. If they're in agreement on something, they know more about the case than I do. And so I am influenced by that. But I am free to come up with something different, and you'd be obligated to comply with that sentence. Do you understand?
Yes, sir.
Okay. Mr. Peoples, anything you were going to add?
Just briefly, Your Honor, I would say that the state will leave the offer open.
Okay, I appreciate that. So I should have added that the offer today is not necessarily the offer tomorrow. The state is free to say, this was your chance today, but now we got to do more work and spend time with the alleged victim. And but Mr. Peoples is saying he's going to leave that offer open. I know Ms. Feely will be working on your case and talking to you more about it. My request, Ms. Feely, is that if you do sort something out, let Ms. Nelson know, because we'll have a busy day on the 6th of July. And if we could take this plea earlier, we should do that. If it's going to be a plea, it may be that it needs to be a trial. And then the 6th is the right day to see everyone again. Okay. Anything else on behalf of Ms. Dyson?
Yeah.
Okay. Ms. Dyson, you're out on bond. Make sure you continue to comply with the conditions of that bond. All right.
Yes, sir.
Mr. Peoples, anything else? Thank you all. All right, 2 left, and then we'll start taking these pleas. Xavier, is it pronounced Frison?
I think it's Bryson, Judge.
Frison. All right. Should we bring him out? Is there something we need to talk about first?
No, he can be brought out, Judge, but I do need to show him some things afterwards. But he's good to go for now.
Okay. And then the last is Mr. Dunning. Mr. Dunning shouldn't have been brought over.
Judge, I think he might have been brought over.
Oh, okay.
I do have an update from Dr. Schwenke on his
You
case.
still have Rumley on here.
Oh, right. Is that the, from this morning?
Yes.
He's very patient until now. He must be just that random one of the, I guess the iPhone. All right, we won't forget you, Brumley.
Yeah, that'll be a quick announcement, Judge.
Okay. All right. Tell me how to pronounce your last name again.
Fryson.
Fryson. Hello, Mr. Fryson. We're going to talk a little bit about your case. Today is what we call final plea date. If you were going to resolve your case by way of a plea, but wanted the ability to withdraw your plea if you didn't like the sentence you got, this would be the day to do that. But given your charges, there's usually not, that doesn't really fit in unless the state was willing to reduce charges and offer you something where you wouldn't have a life sentence. Let me start by asking the prosecutor, Mr. Abate, is the state offering something other than you can plead to the indictment and it's life?
Right.
Okay, so we don't really need to work through that. Ms. Wood, you said there were a few things you wanted to get on the record. Did it concern discovery or?
Oh, no, I apologize, Judge. I don't have anything for the record. I believe we have everything except ballistics.
Okay,
The
usual.
Yes, and I just needed to speak with Mr. Fryson.
Oh, that's right. You were going to show him something.
Yes.
I'm sorry. So, Mr. Fryson, here's what's next. I didn't print this one out. Your case is on our August trial calendar. So a couple months from now, I expect the state to be ready and Ms. Wood to be ready. We're missing one piece of evidence, and that is the ballistics examination of what? Is it shell casings? Is it projectiles found in the deceased?
It's both. But I mean, as I know the next question would be, is it central? I would say no, it's just on video. The defendant is shooting and killing the victim on very high definition video surveillance from the Arnold apartment complex. So we're gonna have to dot our I's and cross our T's.
Okay.
It's clear we shoot those directions.
Ms. Wood, you don't need to admit to any of that, but would you agree that the ballistics evidence isn't going to be the crux of the case?
I would agree, Judge.
Okay, all right. Well, the state will press on with that. I guess your job would be to check with Mr. Abate as that August date approaches, because he may say, we're just not going to have it. And that'll be doubt if you want to inject it. But if you think it's important, then you may need to take ownership of it and say, we're going to use public defender funds to use a private expert to do the ballistics work.
Understood, Judge.
Great. Okay. Mr. Fryson, do you have any questions of me? All right. Ms. Wood is going to come back and talk to you because there's some things she needed. I don't know if it's video or paperwork, but something related to your case she's going to talk to you about. So you're going to stay up here for a little bit so she can connect with you. All right. Thank you.
Thank you, Judge.
Complete evidence, not being confused.
Yes, sir. Thank you. So let me get Mr. Dunning's case up on the screen. So I'm in the loop. Ms. Sellers, is that why you're here?
Yes, Your Honor.
Okay, thank you for being here. All right, so I don't have anything appropriately so. There's nothing in the docket. Tell me what's going on with Mr. Dunning.
Judge, the motion was filed while it was in pre-indictment.
Oh, okay.
So, wait, is Ms. Sellers here?
She is. She's behind you.
I sent her an email right before court started. So I'm trying to get my hands on that order from the pre-indictment attorney. I actually reached out to Dr. Schwenke and she responded this morning and said that while he is in the restoration unit, he's not fully restored at this time.
So you are trying to find the order that it would have been Judge Drake probably signed saying there should be an evaluation?
Well, no, I was looking for the findings.
Oh, not the order, but the results of the evaluation.
Correct.
Right. So that would be Ms. Green from court administration could help with that. Zarina Green, because I don't think Ms. Sellers would have it. It ought not to go to her unless it was shared by the defense. Because typically the initial evaluations go to court and to defense attorney. And I don't know that it would have gone to me. Ms. Green's real good at saying, it was Drake who ordered it, but now it's been indicted. so get it to McBurney.
Okay.
But Zarina with an H on the end, .green, she has a little database and she'd be able to say, Jay Dunning, we don't have anything yet.
Okay.
But if Dr. Schwenke, that is the person who did the evaluation, or that is someone with the restoration pod?
That is someone with the restoration.
Okay,
pod.
so that's not someone who could say, here's the report.
Right, correct. But that is the status update from her. So I will loop Ms. Patterson in. I know Ms. Patterson had been speaking with Mr. Dunning as well. I think she had a bit of a different opinion than the doctor. So it may be that we need to.
But I thought the doctor said not yet restored.
That is what the doctor.
Oh, okay, because usually when there's a difference of opinion,
The other way around.
yeah, exactly. Someone says, hey, this person's ready to go. And you say, trust me, this person is not ready to
And
go.
Judge, the only reason that I share that with you is Mr. Dunning's mother is here in court as well. And from my conversations with Mr. Dunning and his mother, I think Ms. Patterson may be onto something.
Okay,
So we'll explore what our recourse is for that.
got it. Okay, Ms. Sellers.
I will say that I looked through my emails after we talked this afternoon, Ms. Woods. And so I did see that I had requested, the evaluation, the last evaluation that was completed, which was December of 22 of last year. And it did find that he was not competent, and that he would need to be in inpatient treatment to be restored. But at this time, we do need an updated evaluation, because DDHDD has 90 days, and they're supposed to give us an updated evaluation. But what may be holding it is there has been a special plea, filed a special plea, maybe an order from the court, where we're consenting that he is now not competent and needs to be committed to DDHDD for competency restoration, even though they are restoring him at this time.
Okay. I see Mr. Poole from your office filed on the 27th of December, a special plea of incompetence. Mentions the name of the doctor, Dr. Dominic, who interviewed Mr. Dunning. And according to Mr. Poole, Dr. Dominic said not competent. We'll see where that goes. It's tricky in CP land. This is another reason to have a competency docket where it's one judge, Ms. Sellers from the state, and someone from the PD's office who is keeping track of all that. Let me see if I can get the report also. And so I'll reach out to Ms. Green, and then we just need to figure out next steps. I don't know that you could file something that says, nope, we've concluded everything is good to go. I don't want to order a second evaluation if we don't need to. Did the doctor whose name you mentioned say, hey, but it's a matter of weeks, or it could be months and months?
She didn't give me a timeline. She said that he really is trying, whatever that means.
Okay.
But I can try to get a better timeline if that would be.
Well, I just want to figure out what our next step is. I want to keep Mr. Dunning on a calendar so that we're staying focused on his case. So inquiry would be next. Is it 30 days out or is it 60 days out? It's enough time for you and Ms. Patterson to have thought about it more, maybe for this doctor at the jail to have provided a little more substance in terms of here's a timeline. And then Ms. Sellers may be weighing in with actually, we need to make this official and there needs to be an order and a DBHDD assessment. I know there is some what goes on. I don't know how much of it is a DBHDD component if it's a Grady evaluation. I think that's what would trigger the order from a judge saying, now it's a DBHDD supervision thing where they have then that 90 days to say not, is, restorable, whatever their answers are. And we could see where that goes. I don't want Mr. Dunning to get stuck on the endless on-ramp to getting to Georgia Regional, unless that's necessary. And it sounds like from your interactions and Ms. Patterson's, that wouldn't be the consensus.
Correct, Judge.
Okay. 1 month, 2 months?
I would ask for 1 month.
Okay. Ms. Sellers, how do you get notice to be here?
Mr. Peoples and
Okay.
trial attorneys, and then sometimes from case intake, I do receive the folks who have been deemed incompetent to stand trial, and so I'm tracking and keeping that list. And this Green also sends that list of the unindicted cases, so his case is unindicted, not initially.
Got it. Okay, well, it's now very much indicted. So, all right, we'll further notice it about 30 days out for inquiry. And I will reach out to Ms. Green to see if we can get the eval.
Thank you, Judge.
Do you want Mr. Dunning to come to the door or you're good?
I will speak to him in the back, so
Okay.
that's fine, Judge.
All right. So to recap, we'll take Mr. Bethea's pleas. We will take Mr. Arnold's plea. We will take the 560F plea of Mr. Brinkley. And we've got the gentleman still on the call. Oh, we'll take Mr. Davis's pleas.
Yes, I have some conditions I need to go over with him before, but it sounds like I'll have plenty of time for that.
You will. What I'd love to do is handle Mr. Rumley first, because he's from this morning. Thanks for being here. Yes, ma'am. So, Mr. Peoples, we're shifting gears to positions 11 and 12 from this morning. Okay, and Mr. Rumley, can you make yourself visible again, please? So I didn't mean just for like a split second.
Yeah. Can you see?
Man, you have some of the worst connections.
Yeah, I'm in the wrong area right now.
Yeah, what happened to that phone that was working so well?
Hold on.
All right.
Can you see me?
Yeah, all right, stand still, don't move around. You moving makes the phone freak out. All right, Ms. Wood,
Yes, Judge.
this is just a final plea hearing, is that correct?
Correct, no plea.
Okay, great. Ms. Rivers, let's take this down. It's positions 11 and 12 from this morning. It's 23 SC 185-690 and 23 SC 185-698. Mr. Rumley is appearing virtually. His lawyer, Ms. Wood, is here in court. Mr. Rumley, are you waiving your right to be in court so that we can interact with you on the phone?
Yes, sir.
Okay. What is the state's offer, Mr. Peoples? If Mr. Rumley did want to resolve his cases today, what would the state be recommending?
Yes, Your Honor, on 23 SC 185-698.
Could turn his microphone on, please?
We can get you a handheld if you like being where you were.
No, I'm not on tour yet, Your Honor.
Okay.
In 23 SC 185-698, the state's offer would be count 1, 5 years to serve, 6 months, the balance probated, and count 2, 5 years suspended consecutive to count 1, and counts 3 and 4 would be null pros. And in 23 SC 185-596, it will be count 1, 5 years to serve, 6 months, the balance probated. The same with count 2. Count 3 would be to serve 6 months, and count 4 would be null pros, Your Honor. The cases would run concurrent to each other, and all counts with the, yes, Your Honor, and the special conditions would be no violent contact with the victim, completed GED if applicable, completion of a family violence intervention program, and completion of 60 hours of community service, no weapons, no drugs, and no alcohol.
Okay, the second case number you gave is different from what I have. I have 185690. There's 698 and 690.
You're correct, Your Honor. I think it was just a typo.
Okay, just want to make sure you weren't looking at different possible counts.
You're right, Your Honor.
Okay, 11 and 12, 6th grade. All right, so my understanding, if I distill all that, is it's 6 months to serve followed by 4.5 years of probation.
Correct, Your Honor.
Okay, and then there's 5 years suspended after that, but the meat and potatoes of it is 6 months to serve. Ms. Wood, would that involve Mr. Rumley going back into custody, or he, before he got out, served at least 6 months?
I believe he did over 6 months, Judge.
Okay.
10 months.
Okay, that's more than 6. So that would do it. So Mr. Rumley, what the state is offering to resolve your 2 cases is in effect 4.5 years of probation. Do you understand what the state is offering?
Yeah, I don't want it though, because
You don't have to say cuz. Hold on. You don't need to give me the cuz. You just need to say, I don't want it. That's all I needed to hear. And you don't have to take it. That's not what today is about. I just needed you to hear what the offer was, which is basically probation. It's not more jail time, it's probation. And you're telling me no, thank you. And you are entitled to say no, thank you. And Ms. Wood had hinted that you would be saying no, thank you. I just need you to understand that if you change your mind in a month or in 2 weeks and say, wait a minute, I think I want to do that. 2 things. Number one, the state may say, oh, that was the offer for June 8th. Our offer now is 11 months, which would mean you'd have to do another month in jail. They may keep the offer open. They may not. You don't control that. Number 2, if they do keep that offer open and you say, you know what, I think I don't want to go to trial. It's too risky. They may believe my girlfriend or boyfriend or whoever it was in there. I don't want to go to trial. I'll take probation. I might disagree and say it should be something different. Today, you could withdraw your plea if you got more than what your lawyer asked for. But after today, if you enter a plea, you'll be able to argue for whatever you want, but you will be living with whatever sentence I impose. Do you understand that? Okay, good. Ms. Wood, anything you want to add about Mr. Rumley's 2 cases?
No, Your Honor.
Mr. Rumley, you are on our July 6th trial calendar, so I will see you in person, not over one of your many phones, in a car, in your apartment, but here in court, courtroom 8D on July 6th, and we'll figure out what's going to happen from there. And by that time, Mr. Peoples, you'll need to have figured out which of the 2 cases you want to go forward on first.
Yes, Your Honor. These would be Attorney Willingham's cases, but I will alert her. And additionally, if the defendant is rejecting the plea, then the state would withdraw it at this time.
Okay, got it. Mr. Rumley, any questions about anything?
These cases, right?
We'll talk, Mr. Rumley.
Why I can't take this plea.
So hold on, man. I am not unhappy that you're not taking the plea. You are presumed innocent. And so one reason not to take a plea is I didn't do it. Another might be, hey, I'm on probation in Texas, and if I plead, they're going to revoke me for 1,000 years. You don't need to justify why you're not taking them. I just need to make sure you're making an informed decision, and you are. You're a smart guy. You tell me you understand the consequences. You've got a great lawyer. She's going to continue to advocate for you. And I'll either see you on July 6th and we'll figure out when are we going to trial, or before then, maybe something else has come up and you're able to work the case out. I'm here either way. That's my day job. Okay.
All right.
All right. So I will see you at the latest July 6th here in court.
All right. Appreciate it.
Okay. Ms. Wood, thank you.
Thank you, Judge. Bye, Mr. Rumley.
Bye.
All right. Is there a way we can, we'll start with Mr. Bethea because he's up first chronologically anyway. But Ms. Wood, did you need to talk with someone back there? And can we do Mr. Bethea's plea while Ms. Wood talks to someone, or we don't have enough folks?
We don't have enough.
Okay. Well, let's take Mr. Bethea's pleas and then we'll figure out what we're going to do next. And I'm happy you guys can sort of jockey over it, but if doing Mr. Brinkley after that would free up more people. I don't know if Ms. Singleton was staying around for that. She may have already left.
Judge, what would you like me to do with the plea paperwork in both of these cases?
Hand it all to me.
Yes, sir. May I approach?
You may.
Thank you, sir.
Thank you. All right, Mr. Peoples, are you ready?
Yes, Your Honor.
Great. Well, let's get on the record then. This is positions 1 and 2 from this afternoon's final plea calendar, State versus Kendrick Bethea. Am I pronouncing your name correctly?
Yes, sir.
All right, Mr. Bethea, I'm Judge McBurney. Your lawyer, Mr. Florio, is standing by your side, and he tells me that you're prepared to enter pleas in both your cases. Is that right?
Yes, sir.
Okay. In a moment, Mr. Peoples is going to put you under oath. After that, you're going to answer a whole bunch of questions about your rights as a criminal defendant and the fact that you're giving up a lot of those rights in order to plead guilty. If you have any questions while we're working through all this, it's real important that you let your lawyer or me know so that one or both of us can answer those questions. Will you do that?
Yes, sir.
Okay. I'm actually going to ask the first question, and you're not under oath yet, but I'm needing to know. You're wearing a red outfit, which says to me that you are being borrowed from a state DOC facility. Is that correct?
Yes, sir, I am.
Are you under sentence for a case? Did you get revoked on something? What are you doing in DOC custody?
Judge, Mr. Bethea was revoked. He was on first offender felony probation in the Superior Court of Fayette County. He was taken into custody on September 22nd of 2021 for a probation revocation. These two cases, along with another case in Clayton County, triggered a violation of probation in Fayette County. He was revoked, Judge, for 2 years to serve in the state penitentiary. He's on loan from the state prison system to resolve these cases. And this plea does contemplate him having been in custody since September 22nd of 2021.
Okay, that's helpful to know. Is there a reason we didn't do this virtually?
Judge, so this case, both of these cases started in non-complex. We were scheduled. I have no idea.
Why did I hear that?
Judge, I truly have no idea. I've reached out to multiple people and asked why they all of a sudden became complex. We were on multiple calendars in the non-complex division. The issue was that DOC would never log in for court dates.
Oh.
And so ultimately what happened is that there was a production order done. I don't recall which judge did it. I don't recall. I think it was Judge Borski, but I could be wrong. So there was ultimately a production order done to bring him up here just so that we could plea out a non-complex. And then somehow
he's been stuck here.
Somehow the cases were transferred up here to your honor. We were scheduled to plea in non-complex back, I want to say in February. And a production order was done and the cases were transferred to the honorable court.
I think the reason why is that the lead charge in the newer case, or the case with the newer indictment number, is not one that oversight on our part in empowering non-complex to handle cases. I don't think they're authorized to handle fleeing and attempting to elude. And once that moved, everything else goes with it. Yeah, so that was it. Because I just got another one where I looked at like, how is this here? And there's a specific, all the felonies that are delegated to non-complex are spelled out in a standing order, literally each one. And we don't have any from Title 40 and we need to because, but anyway, here we are. I digress. When you're ready, Mr. Peoples.
Thank you, Your Honor. Mr. Bethea.
Yes, sir.
You raise your right hand. Solemnly swear the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you. You can log in. We state your true, correct, and legal name.
Kendrick Kenny Bethea.
Can you spell it for the record?
KENDRICK DRICK KENNY BETHEA.
Thank you. Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you?
28 years old.
And what is the highest level of education that you've completed?
I have attended college.
Okay. Are you able to read, write, and fully understand the English language?
Yes, sir.
You understand that you're charged with the following offenses in 21 SC 178364, count 1, possession of MDMA, count 2, count 1, possession of MDMA, which carries a sentence range of 1 to 3 years, count 2, possession of marijuana with intent to distribute, which carries a sentence range of 1 to 10 years, possession of a firearm during the commission of a felony, which carries a sentence of 5 years consecutive, reckless driving, which is a misdemeanor, which carries a sentence range of 1 day to up to 12 months. Count 5, possession of a firearm by a first offender probationer, which carries a sentence of 1 to 5 years. And in 22 SC 180612, count 1, fleeing and attempting to elude, which carries a sentence range of 1 year. Count 2, misdemeanor obstruction of a law enforcement officer, which carries a sentence range of 1 day to up to 12 months. Count 3, a hit and run, which carries a sentence range of 1 day to up to 12 months. And speeding, which carries a sentence range of 1 day to up to 12 months. Do you understand all of those charges?
Yes, sir, I do.
Can you give us the sentencing range again for count 1 of the second indictment?
Yes, Your Honor. Fleeing and attempting to elude.
Yeah, you said 1 and then you paused and then you moved on. I think it's 1 to 5. I'm gonna look it up, but
I believe so, Your Honor.
if you had it at your thumb tips, one's hitting their phone, I'm hitting a book.
Perfect.
Yeah.
I'm just double checking. But I believe it is 1 to 5.
It was 1 to 5 at the time the crime was committed. I know that they've redone the fleeing and eluding statute, but I believe it's still 1 to 5, Judge.
Okay.
In any event, it's.
Because it's old. It's 3 years ago.
Yes, sir.
Okay.
In any event, Your Honor, the state's agreeing to reduce it to the misdemeanor offense of misdemeanor fleeing and eluding.
Oh, I didn't know that.
That is
Okay.
correct, Your Honor. I was just going through the.
You were as charged what the minimum and maximum are. Okay.
Correct.
Got it.
But it is 1 to 5, Your Honor.
Okay.
You understand that you have the right to either plead guilty or not guilty to these charges?
Yes, sir.
You understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in these indictments, including any potential defenses?
Yes, sir, I have.
Are you satisfied? Do you need any more time to speak with your attorney?
No, sir.
Are you satisfied with their services?
Yes, sir.
Counsel, do you waive formal reading of these indictments?
Yes, sir, we do.
Do you waive any and all defects in the indictments, including any with respect to your client's name?
Yes, sir, we do.
Mr. Bethea, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court will be, Your Honor, in 21 SC 178364. The state would be null prosing counts 2, 3, and 4. And the sentence recommendation will be 5 to serve 2. The balance probated, a weapons forfeiture, and completion of alcohol and drug evaluation and treatment. And in 22 SC 180612, the state is asking to reduce count 1 to misdemeanor, fleeing or attempting to elude. And we're asking for 12 months of probation to run concurrent with the case ending in 364. The special conditions being a completion of a driver improvement course and restitution to the victim of the hit and run, which I'll name during the time of the factual basis.
Okay.
And also, I believe count 3 hit and run was going to be null pros by the state.
That's correct, Your Honor.
Okay.
Do you understand everything that I've just said?
Yes, sir, I do.
You understand, however, that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes, sir.
You understand that if the court decides to order a sentence that differs from the negotiated plea, that you have a right to withdraw your plea of guilty.
Yes, sir.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts.
Yes, sir.
You understand that if you are placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence.
Yes, sir.
You understand that you are not allowed to possess nor use a firearm while on probation.
Yes, sir.
Are you a citizen of the United States?
Yes, I am.
You understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today.
Yes, sir.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand all those rights?
Yes, sir, I do.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charges as laid out to the court in counts in the indictment ending in 364, count 1, possession of MDMA?
Guilty.
And count 5, possession of a firearm by a first offender probationer?
Guilty.
And in the indictment ending in 612, count 1, misdemeanor fleeing and attempting to elude?
Guilty.
And count 2, obstruction of law enforcement officer?
Guilty.
And count 4, speeding?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
You understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, sir.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes, sir.
You understand that you have only 12 months from today for a misdemeanor charge and 4 years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes, sir.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea.
Yes, sir.
You understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself.
Yes, sir.
Your Honor, if this had proceeded to trial, the state would have expected to prove beyond a reasonable doubt that in the indictment ending in 364, on March 14th of 2020, law enforcement was dispatched to 2135 Godby Road, Godby, in reference to a domestic call. An apartment resident told officers that a Black male and Black female had been arguing over keys in the parking lot when the Black male entered into a silver vehicle and began driving around the apartment parking lot. Officers heard screeching tires and observed a vehicle driving at a high rate of speed through the parking lot and struck the curb. Officers followed the vehicle onto Godby Road and observed it changing lanes several times without signaling. And officers stopped the car and made contact with the individual who was identified as Mr. Kendrick Bethea, who was driving. And they observed an unlabeled pill bottle in plain sight in the vehicle's passenger seat. They also found a Black handgun under the driver's seat. Mr. Bethea told officers that the pill bottle contained ecstasy, and they also determined that Mr. Bethea was currently on probation for a felony. He was arrested and charged accordingly. And in indictment ending in 612, one moment, Your Honor. On May 20th of 2020, law enforcement was operating a LiDAR speed detection at the intersection of Majestic Place, located within the city limits of Union City in Fulton County. They were operating the speed detection device, and the device, law enforcement was sitting in their marked patrol car, monitoring traffic traveling west on State Route 14 in the direction of Majestic Place. They observed a vehicle traveling west on State Route 14, traveling at a high rate of speed in the number 1 travel lane. The vehicle was observed to be a light gray Toyota, and law enforcement activated their emergency lights and sirens. They observed the vehicle driving begin to slow, and they began closing in on the violator of the vehicle, at which time traffic began to move. The vehicle began to switch into the number 2 travel lane, and the driver suddenly accelerated and made a left turn from the right side lane, and the driver turned across the intersection of the other traffic in a reckless manner, and law enforcement recognized the driver was attempting to flee from the traffic stop. They observed the driver had taken the turn too fast, and at a later time, the driver of that vehicle struck the right front bumper and headlight of a silver Lexus owned by Mr. Keith Sims. Keith, common spelling, Sims, S-I-M-S. Counsel, do you stipulate there's a factual basis for the plea in both of these indictments?
Yes, sir, we do.
Thank you. And that's all from the state, Your Honor. Additionally, Your Honor, the state has attempted to reach out to Mr. Sims and had not received another call back. We would ask, I had asked in full candor to the court, I had asked for a stipulation on the restitution figure for Mr. Sims. I know that likely the deductible is either between $500 or $1,000, but I will leave it open for 30 days.
And the restitution is for damage to the car, not that Mr. Sims was injured. As far as you know, he's okay, but
Correct.
the headlight, right fender, whatever part it was, damaged.
That's correct, Your Honor.
Okay. Thank you. Ms. Hardy, good afternoon. Could you share with me what criminal history information you have on Mr. Bethea?
The defendant has 8 arrest cycles in Georgia beginning in 2013, a 2015 felony conviction for theft by taking where they received the first offender act, but they were convicted in 2021. And then there was a probation violation in 2021 and nothing further to report.
So what, you've got one conviction. It was a first offender, but that got revoked and he was resentenced.
Yes, sir.
Okay, great. Thank you so much.
No problem.
Mr. Florio.
Judge, the case that Ms. Hardy just referenced is the case that he's currently serving his sentence on. He was revoked for 2 years to serve in the state penitentiary.
And then out of what county was that? You told me.
Fayette
County. Okay.
Yes, Judge, it's the contemplation of the parties that he be given credit back to September 22nd, 2021 on the case ending in 364, the 522. And so statutorily, I think it's prescribed that he gives credit pursuant to 171011. But independent of 171011, it is the parties' agreement and negotiation that he get credit back to September 22nd, 2021. I'd ask that specifically be included in Your Honor's sentence, because I know if it's not, DOC is not going to compute it as such. Independent of that, Judge, in relation to case 612, that's the misdemeanor case. We're asking that upon the completion of special conditions that probation terminate. I thought we'd agreed on $500 restitution, but if the state's not comfortable with that, then I understand leaving restitution open for 30 to 60 days, whatever their pleasure is, that's fine. Just so that the court knows if we had to have a restitution hearing for some reason, we anticipate he will be back in the state prison system in the next 30 to 60 days.
Okay.
Independent of that, Judge, we would just ask that you accept the terms and conditions of the negotiated plea as presented to the honorable court.
Got it. Okay. Mr. Bethea, anything you want to add?
No, sir.
What is your driver's license status right now?
I believe it's suspended.
And why is it suspended?
I would think because of the case that just came, really a letter came to my house and my father told me something about a fine and they said my license was suspended. So
okay, as far as you know, it's suspended.
Right.
Okay. So one of the conditions of your probation is going to be that you take a driver improvement course. If that involves driving, make sure you've got your license back before you do it. Okay. I don't mean to create a catch-22 for you. Okay. All right, Mr. Bethea, I find there is a factual basis for both of your pleas in March of 2020, long time ago. Sounds like you were driving unsafely and then you had some stuff in your car that you didn't want the police to find, but they found it. Apparently you didn't stay in all that long because fast forward a couple months and there you were driving again. Was it the same car or a different car?
The same car. The car is in my name.
Okay. And you smashed into Mr. Sims. What we heard about happened. I'm glad no one got hurt. How was your car?
Some damage done to it. I'm still working on it.
Still working on it.
I still have a car though.
You still have it. All right. Oh, it's a classic now. All right. Mr. Bethea, I have two plea of guilty forms that you and Mr. Florio went over where you put your initials next to a bunch of statements, a lot of which we covered here in court. I need to make sure that your signature on page 4 of both those forms is something you put on there.
Yes, sir.
All right, Mr. Florio, you signed both these as well after explaining the contents to your client?
I did, Your Honor.
All right, I'll make those part of the record. Mr. Bethea, I also find that your pleas are knowing and voluntary. Voluntary means no one's forcing you to enter these pleas, but you've decided of your own free will, this is how you want to move forward. Is that correct?
Yes, sir.
I'm sentencing you under the Probation Options Management Act, which means that while you are on probation, which you will be for a little while, if you have a minor or a technical violation, you and probation will sort that out. But if it's more serious, you get arrested again, or you violate one of the special conditions that I'm about to share with you, then that will come back to me and we'll figure out what we're going to do. Do you authorize someone on my staff, Mr. Bethea, to sign both your indictments as an indication that you've pled guilty in both cases?
Yes, sir.
Mr. Florio, can we sign for you?
Yes, sir.
And Mr. Peoples?
Yes, sir.
I'll do that. In 21 SC 178364, I'm sentencing you on count 1 to 2 years to serve, count 2, 5 years to
Judge, counts 2, 3, and 4 are null prompts.
That's right. Look at that. So I'm sentencing you on count 1 to 2 years to serve, and on count 5 to 3 years to serve, consecutive to count 1, but I'm probating those 3 years. So it's a total sentence of 5 years to serve 2. You will get credit from September 22nd, 2021. So you don't have much time left on this case. Special condition of probation number 1 is that you forfeit the gun that was seized from that gray car that you still, is it gray or silver?
It's actually powder blue, but everybody thinks it's gray.
I probably call it gray. Yeah, so your gray car, the gun seized from that will be forfeited to the state. You will need to take a driver improvement course, assuming you have appropriate license status to do that. You will also need to submit to a drug and alcohol abuse evaluation. That's where an expert meets with you, talks with you, and if that expert recommends any treatment, go to AA meetings, whatever it might be, that will become a condition of your probation as well.
Okay.
And I'm gonna leave restitution alone. If we need to revisit that, we can always have a hearing and I can amend the sentence. In 22 SC 180612, I am sentencing you to 12 months to serve on counts 1, which has been reduced to a misdemeanor, 2 and 4. Those will all run concurrently with each other and will run concurrently with your sentence in the case ending in 364. So the net effect of all that is 5 years to serve 2, credit from 9/22/21, and 3 years of probation with those conditions that I mentioned. Did I miss anything, Mr. Peoples, that the state had asked for?
I do not believe so, Your Honor.
Mr. Florio, anything else? I structured it a little bit differently. I think it has the same net effect, which is what you two negotiated.
It sounds good to us. Thank you, Your Honor.
Any questions, Mr. Bethea, about any of that?
No, sir.
All right, Ms. Tucson, Mr. Bethea is going to go back into state custody. Do you need to share anything with him about probation?
Was only the second case, the 612 misdemeanor, and then the other one, the 364 is felony?
Yes, ma'am. And the 612 is jail custody only.
Okay, yeah, because it doesn't show him on active probation at the moment. Mr. Bethea, where will you be living
Where would I be living?
when you get released from custody? Is it Fayette
Yeah.
County?
Fulton County.
In Fulton, do you know where probation is in Fulton County?
I believe it's on Memorial Drive.
It is. It's around the corner from the courthouse. You will need to report there when you are released from custody.
Yes, ma'am.
Don't forget to do that. You'll be advised of that when you are released from
don't
custody.
give me information.
But the quickest way to get a new warrant, which you don't want, would be to not show up for that reporting date.
Yes,
Okay.
sir.
Anything else, Ms. Tucson?
That should be it. Thank you.
All right. Thank you, Mr. Florio. Good seeing you.
Good to see you, Your Honor. That concludes my list.
You may.
Thank you, sir.
And Mr. Bethea, we'll get you back to DOC custody as quickly as we can. We don't need to keep you here any longer.
Thank you so much, sir.
All right.
Thank you.
Standing up. What do you guys want to do next?
I'm ready on Mr. Brinkley ordinance.
I'm ready.
Okay, let's do that. And then if we could do Mr. Arnold after that. I know the Woodalls have been on the call for a while. So we'll do Mr. Brinkley and then Mr. Arnold. And then is Davis the only thing left?
Yes, and I just need to briefly speak with him.
Okay, great.
May I approach the paperwork?
Yes, ma'am. Paperwork.
Judge, when you were saying the quickest way to get a new warrant was not to appear for that, I was thinking the second quickest way is to drive yourself there.
That's true.
I didn't say anything, but I actually had it when I was in the solicitor's office. We had a defendant, got out, supposed to go to misdemeanor probation. And they watched him drive himself there for a charge that he just pled to of driving on a suspended license. And immediately violated it because he drove himself.
Is everything all right back there? Okay, it doesn't seem like the right direction.
No, I heard.
You tell me.
We just let you know. I'm just gonna step outside.
Oh, yeah, you're right.
This kid's
I don't know about that, because she's also said some things, so I don't know if maybe less bad for Eppinger or for John. We did. That poor case. But soon, like I said, it's all gonna fit down in except for him. Who's his deputy? Yeah. Someone's unhappy. I hope it's not Mr. Davis.
I think it's the guys that were, I think they feel that, the comments about a potential Bruton problem, they feel that he was outed and someone might have been speaking on them, so it's a.
I was sort of surprised that that was the answer that was, I just thought I'd hear, hey, there may be, as opposed to, and this guy said things about other people.
Yeah.
I mean, I guess that gets you down to 3 defendants, but.
Yeah. Hopefully it's because it's severed, not because something happened to him.
Judge, I put on that paper, and we can put this on the record when he comes out. I put on that paperwork that we were gonna use first offender. I think we're not, and I'll explain that on the record as well.
Okay.
You can pull your mask down if you want and just make sure you speak loudly and clearly into the microphone, okay?
All right, Ms. Rivers, you ready?
I'm ready.
Great. This is position 11 from our final plea calendar, 23 SC 185727, State versus Mr. Brinkley. How you doing, Mr. Brinkley?
Good.
Good. I'm Judge McBurney, and your lawyer tells me that you are ready to enter a plea in your case. Is that right?
Yes, sir.
The way this is going to work in the big picture is that we're just going to talk about, did you do it or not? And then I accept your plea. What the consequences are will be decided in juvenile court. So your lawyer will be with you in front of a different judge in a different building. Have you been to juvenile court before?
Yes, sir.
Okay, you know the building. I don't know what judge will get the case. My guess is it's a random assignment. It may be a judge you met before, but a judge will then, will you handle it down there or it'll be your colleague?
No, it'll be colleagues of mine.
Okay, there'll be a different prosecutor. Your lawyer will be with you and you all will talk with the judge there about what ought to happen because you pled guilty to what you're charged with. Okay?
Yes, sir.
Great. Today, all we're going to do is take that plea. So Mr. Hiles is going to put you under oath in a minute. He's going to ask you a bunch of questions, which you need to answer. If at any time you're confused by what's being said, it's not clear, whatever it is, we'll take a timeout. You can talk to your lawyer, you can ask me, but I need to be comfortable that you are understanding what's going on. Will you tell me if you are ever not understanding what's going on?
Yes, sir.
Sounds like a plan. When you're ready, Mr. Hiles.
Okay, Your Honor, I'm just gonna outline the terms. So this is, he's charged with 7 counts of participation in street gang activity, 1 count of armed robbery, 1 count of ag assault, 1 count of possession of a firearm during the commission of a felony. All counts except for the armed robbery will be null pros, and the armed robbery will be reduced to robbery, which we are asking to transfer to juvenile court. The reasons for that are all fact-based, 100% fact-based, which I will highlight once I go over the factual basis. However, we were in discussions about first offender, and I did have a conversation with Mr. Warden. I think we're on the same page that a guilty plea is not considered final until final disposition has been entered. And because final disposition is going to be entered in juvenile court, it should show as an adjudication of delinquency. We're just going to be careful to make sure that the paperwork is filed correctly and not sent over to GCIC. That is why we're not going to be using first offender. So he does not burn a first offender.
Okay. I may not use the word delinquent each time, but the record I make here isn't the ultimate controlling record. It'll be whatever that disposition is in juvenile court.
Right.
Okay. To synthesize what you shared with me, It is a plea to count 8, which is being reduced to robbery. All other counts are being null prossed or dismissed.
Yes, and it is being transferred, if you agree, to juvenile court under OCGA 15-11-560 subsection F.
Okay,
Okay.
sounds like a plan.
All right, Mr. Brinkley, will you please raise your right hand to the best of your ability? You swear or affirm that testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth.
Yes, sir.
You put your hand down. Please state your true, correct, and legal name.
Antoine Travion Brinkley.
Okay, Mr. Brinkley, I'm going to tell you, this is being recorded by a court reporter who is on Zoom, and it is a little bit hard to understand you, so if you need to lower your mask for purposes of this plea, you can do so, all right? All right, will you please state your true, correct, and legal name one more time?
Antoine Travion Brinkley.
Okay.
Much better.
Are you at this time taking or under the influence of any alcohol, drugs, or medicines?
No, sir.
How old are you?
17.
How far have you gone in school?
9th grade.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you were charged with counts 1 through 7, violation of the Street Game Terrorism and Prevention Act, count 8, armed robbery, count 9, aggravated assault, and count 10, possession of a firearm during a commission of a felony?
Yes, sir.
And do you understand that counts 1 through 7 and counts 9 and 10 will be dismissed as you entering this guilty plea to a reduced count of robbery under count 8? Do you understand?
Yes, sir.
And you understand that as part of these negotiations, the state and your defense attorney are recommending to the judge that this case be transferred to juvenile court for final disposition after this guilty plea is taken. Do you understand?
Yes, sir.
Have you reviewed the waiver of rights form, also known as the guilty plea form, with your attorney, this form that the judge is holding?
Yes, sir.
Okay. And is that your, did you sign that form?
Yes, sir.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss this with your attorney?
No, sir.
Are you satisfied with your attorney's services?
Yes, sir.
Okay. Ms. Gordon, do you waive formal reading of this indictment?
Yes.
Ms. Gordon, do you waive any and all defects in this indictment, including any with respect to your client's name?
Yes.
Mr. Brinkley, are you aware of the maximum sentence for the charge of robbery for which you are pleading to?
Yes, sir.
Okay, do you understand that if it had been taken, if you had been sentenced in Superior Court, you would have been facing a potential sentence range of 1 to 20 years? Do you understand?
Yes, sir.
And do you understand in juvenile court, you will be facing a potential maximum sentence of 5 years of commitment to the Department of Juvenile Justice or until the age of 21, whichever is sooner. Do you understand that?
Yes, sir.
Do you understand that this is a negotiated plea of guilty with the terms that I have just told you? And that the court, however, the court does not have to accept this guilty plea. Do you understand?
Yes, sir.
And do you understand that the court can sentence you up to the maximum on the charge that you're pleading to? Do you understand?
Yes, sir.
Okay. Do you understand that by pleading guilty to this charge, you are going to be subject to the terms of any sentence issued by the juvenile court? Do you understand?
Yes, sir.
Do you understand that neither this court nor myself, the state, nor your attorney has control as to what those terms are going to be?
Yes, sir.
And do you understand that if you violate the terms of the sentence as determined or disposition as determined by the juvenile court, you will be subject to the jurisdiction of the juvenile court. Do you understand?
Yes, sir.
Do you understand that by pleading guilty, you waive any and all defenses, including any mental health offenses, by entering a guilty plea?
Yes, sir.
Do you understand that by pleading guilty, you're giving up the right to trial by jury?
Yes, sir.
Do you understand by pleading guilty, you're giving up the right to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you're giving up the right to confront witnesses against you?
Yes, sir.
Do you understand that by pleading guilty, you're giving up the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case? Do you understand?
Yes, sir.
However, I'm going to make one caveat to this, that your attorney, Ms. Gordon, will still represent you at your disposition hearing in juvenile court. Do you understand?
Yes, sir.
Do you understand that by pleading guilty, you're giving up the right to the presumption of innocence? Do you understand you're giving up your right to the presumption of innocence by entering a guilty plea?
All right, yes, sir.
And do you understand by pleading guilty, you're giving up the right to subpoena witnesses and compel the production of evidence?
Yes, sir.
Do you understand that you are giving up the right to testify at a, do you understand that you are giving up the right to testify on your own behalf and present other evidence at a jury trial of your case?
Yes, sir.
Do you understand that you're giving up the right to have the charges against you proved beyond a reasonable doubt?
Yes, sir.
Do you understand that by pleading guilty, you're giving up the right to appeal if convicted of these charges after trial?
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Say it again.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the singular charge of robbery?
Yes.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Read. Yeah, this is what I want to do.
This is what you want to do, okay. Do you understand that after entering this guilty plea, and if this case is transferred to the juvenile court, jurisdiction over this case in Superior Court will terminate? Do you understand?
Yes, sir.
And do you understand that you have only a limited right to appeal of this case?
Yes, sir.
Do you understand that you will have 4 years from today's date to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea? Do you understand?
Yes, sir.
Your Honor, were this case to go to trial, the facts would show that on July 23rd of 2022, officers responded to 2524 Martin Luther King Drive, City of Atlanta, Fulton County, in reference to a robbery. Officers spoke with the listed victim in this case, Mr. Alec Robinson, who stated that he picked up a male who was later identified as Antoine Brinkley from 2731 Marker Drive, and gave him a ride to the location 2524 Martin Luther King Drive. Mr. Robinson stated that when he arrived at the location, Brinkley tried to show him some clothing from his backpack, but when Robinson refused, Brinkley pointed a firearm at him and grabbed Robinson's firearm from the center console of Robinson's car while demanding money from Robinson. Mr. Robinson described that firearm as a silver and black firearm.
His own that was taken, or the one that Mr. Brinkley was pointing at him?
He only described the one that was taken as a silver and black firearm.
Okay.
While on scene, and he stated that he tried to flee Mr. Robinson stated he tried to flee the scene and get on a FedEx truck.
Like one that's rolling away and he's going to be a hobo and jump on it, or he tried to basically hijack a FedEx truck?
I will get there.
Okay.
That was that he tried to get on a FedEx truck and have them drive him away from the robbery.
The FedEx taxi.
Yes. However, while on scene for this robbery, police got a report of another robbery that occurred at the same location. Officers drove a few miles away to meet with Miss Alicia Thompson, who stated that she was an Amazon delivery driver who was parked at the location of 2524 MLK Drive, and that a black male wearing a blue hoodie, black pants, and black shoes with shoulder-length dreads jumped into her vehicle, putting a firearm into her ribs, telling her to drive the vehicle, and then trying to commandeer the vehicle. That was a description that fit the victim, Mr. Robinson, to a T. Later, Mrs. Robinson even described the gun that was put into her ribs as a black and silver handgun. Mr. Robinson was then arrested for the attempted armed robbery and attempted kidnapping of the Amazon driver, Mrs. Thompson. He did continue to give statements identifying Mr. Brinkley several days later after he was released on bond, identifying Mr. Brinkley by his Instagram records, for which the officers looked at the Instagram records, determining that Mr. Brinkley matched pictures on that Instagram account matched the other juvenile arrest records of Mr. Brinkley, who they were familiar with. Gone back and forth with Ms. Gordon on this. The state feels that though there is potentially enough for a conviction, that there is also a lot of room for reasonable doubt in this case, should this case proceed to a jury trial. And we feel that this is the most definite resolution as to whether or not Mr. Brinkley will be monitored after resolving this case, and felt that it was the best way to resolve this case, given the conflicting testimony of Robinson with what Ms. Thompson said.
So she described she described someone who fits Robinson's description as her kidnapper, carjacker.
And she later identified him as the person doing it.
That's the guy who did it. And yet Robinson's story is, hey, it was Brinkley who took my stuff, to include my gun. And then I saw him jump in a FedEx truck, which would be the Amazon truck.
Well, I think Mr. Robinson maintained that he was just trying to get into the Amazon truck and be driven away from the scene as he fled from the robbery.
Okay.
He
didn't say, I must have misunderstood you. He didn't say, hey, the guy who took my gun, Brinkley, is the one who jumped into the FedEx truck.
Yeah.
He says, I did.
Yes.
Oh, because now Brinkley has two guns and I have no guns.
Yes.
And I don't want to be on the short end of that. So I'm going to get away in FedEx/Amazon.
Yes.
Oh.
But there was, some discrepancies in that, and the fact that potentially the gun that he said was just stolen was also similar to the gun that was described by the Amazon driver.
Yep, that part I picked up. For some reason, the piece I missed is I thought that Mr. Robinson said, and the way my scenario ended, because I didn't want to buy his clothes, is he took my stuff, jumped out and hopped in, tried to commandeer the FedEx/Amazon truck. But Robinson said, no, I did that.
Yes.
But I didn't have a gun.
Yes.
Okay. And the driver Ms. Thompson describes his gun that he says Brinkley took.
Yes, the gun that would match that description.
Yeah. Okay. Got it. And as I understand 560F, having read it now, this is transferable because it's a plea to a lesser included of one of the enumerated offenses.
Yes.
Okay, got it. Thank you. Ms. Gordon?
Judge, yes, we are asking that you accept the plea today. Mr. Hile sort of spoke about this earlier. We are not going to use our first offender today. The reason for that being my understanding of the law is that a conviction, whether it be in Superior Court or somewhere else, is not a complete and valid conviction unless and until that person is sentenced. So my understanding of the law would be that even though we are entering a plea here in Superior Court, that would not be reflected as a felony conviction on Antoine's record once it reaches, if it reaches GCIC. My view, I think, would be that it shouldn't be reported at all to GCIC. I'm not entirely sure exactly how that would work, but
Nothing from here will be, because I don't know what it is I'm signing. I assume I'm assigning an order that transfers this matter for final disposition to juvenile court. What goes to GCIC is final dispositions. So it may well be that a finding of delinquency from juvenile court goes to GCIC. If it is, it stays in a hidden place, because I know it's always very, very difficult to learn about the juvenile history of someone who is coming into court saying, hey, I've never been in trouble before, because he's 17 in one day. And of course, his adult criminal history is vacant. But then we learn through some means other than running a GCIC that there was a robust history as a juvenile.
right. So I just wanted to put that on the record. But other than that, Judge, I would agree with Mr. Hile's recitation of the facts and the weaknesses in the state's case, the reasoning behind the plea and the reduction and the transfer. And we would just ask that you accept the plea.
Okay.
And the transfer to juvenile for disposition.
Mr. Hiles, would the evidence at a trial have shown that Mr. Brinkley and Mr. Robinson were in the same organization?
No, I do not believe it would. There was a cursory investigation into Mr. Brinkley's gang affiliation, which was based on his Instagram profile, just his profile, not a dump of his Instagram records. And so that evidence, I think, could have been sufficient, but it is not.
I mean, it must have been sufficient to someone, because the first 7 counts of the indictment are gang, 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 gang.
I understand that.
Okay. All right. Thank you. Mr. Brinkley, do you have any questions about anything we've talked about?
Yes, sir.
Okay. Well, Mr. Brinkley, I find there is a factual basis for your plea to 1 count reduced to robbery in connection with your interactions with Mr. Robinson. So I'll accept your plea. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this. You already told us you think this is the right way forward. And a knowing plea, just means that you've understood the things we talked about, either because you asked Ms. Gordon and she explained, and I watched her explain some things to you, or because you picked it up the first time. Do you have questions about any of the things we've been talking about?
No, sir.
Okay, then I'm accepting your plea to count 8 reduced to robbery, and assuming someone sends me a transfer order, I will sign an order that transfers your case from Superior Court to Juvenile Court in Fulton County pursuant to OCGA 1511-560 subsection F. That's 560 subsection F. Anything else you need me to say in connection with this, Mr. Hiles?
No, Your Honor.
Ms. Gordon?
I don't think so, Judge.
Ms. Singleton? All right. So Mr. Brinkley will stay in custody. Does he stay where he is, or does he now, maybe he is at a YDC? He's not the age where he should be at a YDC.
He is at the jail right now because he is 17. Once the transfer, the disposition transfer order to juvenile is filed, Ms. Singleton and I will work together to ensure that he then gets transferred back over to the custody of DJJ until disposition is in.
Okay. And the rest will happen in juvenile court.
Yes.
All right. Okay. Thank you, everyone.
Thank you, Judge. That's all I have today. May I be excused?
Yes, everyone who only is here for Mr. Brinkley is free to go. You bet. Tuitt, T-U-I-T-T. Yeah,
Okay, I'm just bring it to the door.
sure. So I gotta talk with Mr. Tuitt here at the door, and then Ms. Feely, we're gonna do Mr. Arnold. And is all we have after that, Mr. Davis, or did I miss anything?
I believe so, Your Honor.
We have more?
No, I believe
Oh.
it's just those.
Okay.
Hey, take this. Yeah, thank you.
You're sure?
Mr. Tuitt. I'm doing all right. I'm Judge McBurney. And I had a good conversation, would have been a couple hours ago. We've been working on some stuff with Mr. Melnick, your lawyer, and the prosecutor. Mr. Melnick helped me understand that the state has not yet produced a couple things that are important in your case. There's some DNA evidence that's being processed. And then we don't have the ballistics results yet either. That's not because Mr. Melnick hasn't asked. They're at the crime lab, the GBI crime lab, and they just haven't completed the testing yet. Apparently there's suggestion of contact DNA. I don't know if it's on the gun or what, but it's something that will make, in Mr. Melnick's mind, a pretty big difference in your case. If the person who was killed in this case, if his DNA is on whatever it is they're testing, it's a very different storyline than if it is your DNA that's on it. And Mr. Melnick understandably wants to get that because it makes it easier for him to negotiate on your behalf if it's the alleged victim's DNA on whatever it is. I'm assuming it's on the gun, but I don't know. And don't take my, I don't know what it was found on, but the law enforcement thinks they got some DNA. The crime lab needs to figure out, if it can, whose DNA is it. And I think they have DNA from the deceased, they have DNA from you. And so it'll be you, victim, or someone else. And if it is not you, that's helpful to you and Mr. Melnick. If it is the person who's deceased, it sounds like that's extra helpful to you and Mr. Melnick. He needs that information before he can finish trying to negotiate your case with the prosecutor. So that's what we talked about. We're keeping your case on the July trial calendar.
Excuse me, sir. I don't mean to cut you off, but I wasn't disputing that. The thing that I was disputing is when I came here in February and you seen me, I explained to you that I was stabbed over 20 times inside Fulton County. I almost died.
Okay.
And you told him yourself, you should go ahead and put in for emergency bond.
He did.
Okay, I'm trying to figure out, it's been 4 months.
So that, Mr. Melnick brought that up as well. I said, hey, we haven't had a bond hearing. And so I figured out, is this on for bond as well? Because the state needs to be given notice so that representatives of the deceased family can be heard as well. And I was told, nope, actually, it's just on for this discussion I described. But I told Mr. Melnick, you need to reach out to my staff so that we can get your case on for bond as well. And Mr. Melnick said he'd do that. So I will see you either on July 6th, because that's the calendar for the trial, or before then, because we figured out a way to get you in here to talk about bond. So that came up as well. Mr. Melnick said, hey, I've had this bond motion out there for a while. I said, thank you for reminding me, because
How long does it take to answer a bond motion? I thought it was 30 days.
So it's not answer it in writing. It is finding time on my calendar, finding time on Mr. Melnick's calendar to get everyone in the same place at the same time. So Mr. Melnick has reminded me and my staff that we need to calendar that, and we'll look at the calendar and see what we've got between now and July 6th. Worst case scenario, we'll talk about it on July 6th, but Mr. Melnick said he'd like to do it before then. Okay. All right. Now, if we could have Mr. Arnold, please. Arnold, yes.
Judge, may I be excused?
Yes, ma'am. Thanks for your help today.
Thank you.
Honor, since we're a little more slimmed down, can I stay here or still want me to?
You can be where you want as long as you're near a microphone and bend the microphone towards you. What we'll probably do if you're going to stay there, which is fine with me, is have Mr. Arnold stay seated so that people can see each other and he doesn't have to crane his neck.
Understood. And also, I think it's easier for the family to see me as well.
Sure. Hey, what's going on? No, that's okay. Everything all right? Oh, we're changing these codes. I heard. Okay.
Okay.
Take notes. One second. All right. This is position 10 on our final plea calendar, State versus Brian Arnold. Mr. Arnold is here along with his attorney, Ms. Feely. Mr. Peoples is representing the state. And as I understand it, Ms. Feely, this is going to be a plea.
That's correct.
All right, Mr. Arnold, I have heard a fair amount about some of the facts and circumstances surrounding your case because your co-defendant, Ms. Craig, entered a guilty plea a few weeks ago, may have been about a month ago. In a moment, I'm going to ask Mr. Peoples to put you under oath. You'll then need to answer questions that he has and I have about entering a guilty plea. If you have any questions, it's important that you let Ms. Feely or me know so that I'm comfortable finding that you understood the proceedings. I will also give members of Mr. Woodall's family an opportunity to be heard if they want to. I heard a great deal from them during Ms. Craig's plea. It shouldn't surprise you that they have all sorts of questions about how someone could let this happen. And they will not be questions for you. You don't interact with the family members at all, but you will hear what they have to say. And they may have a lot to say and you'll have a lot to listen to because this is a real sad case. Mr. Peoples, when you are ready.
Thank you, Arnold. Mr. Arnold, will you raise your right hand? You solemnly swear that the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth.
Yes, there are.
And you want to speak up as clearly and loudly as possible.
Yes, there are.
Thank you.
You can put your hand down.
Will you state your true, correct, and legal name?
Yes, my name is Brian Lee Arnold.
Can you spell it for the record?
BRIANLEEARNOLD.
Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No, I'm not.
How old are you?
I'm 42 years old.
Is there a medication that you normally take that you have not been given today?
No, there's not.
What is the highest level of education that you've completed?
9th grade.
I'm sorry.
9th grade.
Are you able to read, write? Do you have your GED?
Yes, I do.
Are you able to read, write, and fully understand the English language?
Yes, I can.
Do you understand that you're charged with the following offenses? Count 1, abandonment of a dead body with a sentence range of 1 to 3 years. Count 2, concealing the death of another with a sentence range of 1 to 10 years. Count 3, theft by receiving stolen property with a sentence range of 1 to 5 years. Count 4, entering an automobile with a sentence range of 1 to 5 years. And count 5, financial transaction card theft the sentence range of 1 to 5 years. Do you understand all of those charges?
Yes, I do.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, I do.
Do you understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
Yes, I understand.
Have you had enough time to speak with your attorney about all of the facts and the circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, I am.
Do you need any more time to discuss this case with your attorney?
No, I don't.
Are you satisfied with their services?
Yes, I am.
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
We do.
Mr. Arnold, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense will be, Your Honor, the recommendation is 5 serve 2, alcohol and drug evaluation and treatment, no alcohol or illegal drugs, a stay away from the co-defendant, Ms. Craig, as well as truthful to the best of his knowledge testimony about any perceived other party who may have been present at that time, which I will ask with the court's permission at the close of the colloquy.
Okay.
Do you understand that, Mr. Arnold?
Yes, I do.
Do you understand, however, that the court does not have to accept that recommendation? The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
I understand.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea, that you have a right to withdraw your plea of guilty?
Yes.
Do you understand that this plea may be used to enhance sentencing in other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, I understand.
Do you understand that if you're placed on probation of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess nor use a firearm while on probation?
I understand.
Are you a citizen of the United States?
No.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or the court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. You understand all of these rights?
Yes, I understand.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No, they have not.
How do you plead to the charge of count 1, abandonment of a dead body?
I plead guilty.
Count 2, concealing the death of another?
Yes.
Count 3, theft by receiving stolen property?
Yes.
Count 4. Oh, I apologize, Your Honor. He will be pleading to counts 1 and 2. Counts 3, 4, and 5 will be null pros.
Okay.
And the state's thoughts on that are that if this had proceeded to trial, I do not believe we would be able to overcome the burden of beyond a reasonable doubt for those specific charges because the deceased is not present or able to make certain statements. So therefore, counts 1 and 2, the state would be proceeding on.
Okay, that's consistent with the way your office handled Ms. Craig, the co-defendant's plea.
That is correct, Your Honor.
Okay.
Mr. Arnold, is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, yes, sir.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes, sir.
Do you understand that you have only 12 months from today for a misdemeanor charge and 4 years for felony to file a habeas corpus petition challenging the voluntariness of this guilty plea?
I understand.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea?
Mm-hmm.
Yes?
Yes, I understand.
Do you understand that in the filings that we've just discussed must be filed by your counsel unless you're representing yourself?
Yes.
Your Honor, if this had proceeded to trial, the state would expect to prove beyond a reasonable doubt that on August 4th of 2021, law enforcement responded to 410 North Avenue in Atlanta, Georgia, in Fulton County, in reference to a person non-responsive inside of a vehicle in the Dairy Queen parking lot. Upon arrival, officers observed a dark gray 2020 Toyota RAV4 with a white male who was identified as Mr. John Woodall leaning forward in the front passenger seat. Due to all four of the doors being locked, officers requested tow service to make entry into the vehicle. Additionally, at that same day, law enforcement also responded to 486 Ponce de Leon Avenue in Atlanta, Georgia, in Fulton County in reference to a missing person call. Officers spoke with Miss Dawn Gonzalez Woodall, Dawn, common spelling, Gonzalez, Gonzalez, who is the wife of the missing individual, Mr. John Woodall. And Ms. Woodall explained to officers that the last time she'd seen her husband was on August 3rd of 2021 at Grady High School, where they attended a parent-teacher meeting. Ms. Woodall explained that Mr. Woodall had texted his daughter at approximately 7:12 p.m. stating that the laptop that had been dropped off at a fix-it repair shop in Midtown. Ms. Woodall explained that this was the last correspondence anyone had received. On August 5th, detectives also met with Ms. Woodall at her residence, and Ms. Woodall advised of several transactions on Mr. Woodall's business and personal credit cards from August 3rd of 2021 to August 4th of 2021. And on August 4th of 2021, Mr. Woodall's vehicle was located on the license plate readers traveling southbound on Boulevard Northeast towards Ponce de Leon Avenue. It was spotted traveling northbound on Monroe Drive and Ponce de Leon Avenue. Using that time information from the license plate readers, detectives were able to locate footage. And on August 4th, Mr. Woodall's vehicle was seen pulling into a Shell gas station at 486 Ponce de Leon, where a black male is seen approaching the vehicle and place an unknown object in the left rear passenger side of the vehicle. Mr. Woodall's vehicle is then seen pulling into the Wendy's parking lot located at 660 Boulevard. Detectives were able to obtain surveillance footage from that Wendy's, and Mr. Woodall's vehicle is seen pulling into the Wendy's drive-through, circling around the building and parks. Mr. Woodall can clearly be seen slumped over and buckled into the passenger seat. The driver of the vehicle, who was later identified as Mr. Brian Arnold, is seen exiting the vehicle and walking away. A passenger from the front right rear seat, later identified as Miss Brittany Craig, is also seen exiting the vehicle. Arnold and Craig can be seen fumbling around the interior of the vehicle, and Craig is then seen leaning over and in direct contact with the body of Mr. Woodall, checking to see if the seatbelt is still secured. Mr. Craig can be seen engaged in a cellular phone conversation and doesn't check or attempt to render aid to Mr. Woodall. And Arnold and Craig are then seen walking away from Mr. Woodall's vehicle. Arnold and Craig and an unidentified male suspect are seen entering Mr. Woodall's vehicle, and the vehicle is then seen exiting the Wendy's parking lot and traveling east on North Avenue and pull into the Dairy Queen parking lot at 410 North Avenue. Miss Craig was located by law enforcement, and a field interview was conducted. She was read her Miranda rights, and she agreed to speak with detectives without a lawyer present and she admitted that she was in the vehicle with the victim. She stated at that time that she assumed that the victim was asleep or drunk. Atlanta Police Latent Print Unit confirmed and advised the fingerprints recovered from Mr. Woodall's vehicle belonged to Brittany Craig, Brian Arnold, and Oenfelo Robertson, Oenfelo Robertson, common spelling. Detective learned of several transactions where Mr. Woodall's credit card was used after it was apparent that Mr. Woodall was deceased. Ms. Craig was arrested by Atlanta Police Department and transported to Fulton County Jail. And on August 27th, Mr. Arnold was arrested and transported to the Atlanta Police Department. Arnold and Craig both provided statements that they received the victim's vehicle from each other. Counsel, do you stipulate there's a factual basis for this plea?
We do.
Your Honor, with the court's permission, before the state closes, if I may inquire of the defendant briefly, as the family is asking about the whereabouts or the identity of an unknown person, which is the
Sure.
truthful
If you
testimony.
don't, I asked Ms. Craig, so I'm going to ask Mr. Arnold who this other person is who got in the car with them.
Then I would yield to the court if the court is already going to inquire.
You're up.
Mr. Arnold, you are reminded that you're still under oath. Mr. Arnold, are you aware of the whereabouts of another individual who was with you on the night in question?
No, I don't, sir.
Do you?
So let me ask the question a different way. You may not know where anyone is right now because you've been in jail for a while. The night that when I say night, I don't remember the exact window. It may have been afternoon. It may have been morning. Let's not get hung up on the details. But there was a time when you and Ms. Craig were using Mr. Woodall's car. He was in it. He was in the front seat, but he was not in any way participating in what was going on. And it sounds like at some point a third person joined you in the car. It'd be a fourth person really, because Mr. Woodall is in it. There's Ms. Craig, there's you. Who else during the time you were using Mr. Woodall's car was in the car with you?
At one point, while we were at the Wendy's parking lot, there was a guy that came over to the car and he was looking in it, but he also got in the car. But I don't know his, let's say his first and last name. I just know a nickname of him, and that's it.
Well, let's start with that. What's the nickname by which you know that individual?
Booney, Booney.
Booney?
Yeah.
Okay. How long have you known Booney?
I mean, I only been in that area like a couple of years, so I'll say like a year of that time.
Okay, so this happened a while ago. It was a year and a half ago. And at that time, August of 21, you had known Booney for about a year.
Yeah, yes.
Okay, and you knew him in what context? You'd see him around, you guys would hang out?
Yeah, just see him around most of the time and just hanging out most of the time like that.
Okay, would you say Booney was older than you, younger than you? About the same?
He's older than me. Yeah.
Older guy.
Like maybe not by much though, maybe a year or two, something like that.
Okay. Were you closer to him or was Ms. Craig in terms of just like seeing him and knowing who he was?
Miss Craig, oh gosh, that's who he was talking to from when he first walked up.
Was Ms. Craig?
Yeah.
Okay. Was it your sense that they knew each other or that she was wondering, hey, who are you and why are you coming towards this car?
No, it was more of they knew each other and they was conversing about something.
Okay. Do you remember what they were talking about?
No, because I was doing something else at the time. I actually had walked off. And walked up the street for a minute.
Okay. But you knew Booney well enough that you recognized that that's who it was talking with Ms. Craig.
Yeah, that's it.
Okay. And you said he got in the car for a little bit. What was he doing in the car?
And then rummaging through it, but he was sitting in the back seat at that time.
Okay.
In the Windows parking lot.
Eventually you and Ms. Craig and Mr. Woodall left the Wendy's parking lot and ultimately ended up back at the Dairy Queen. Was Booney with you then, or he didn't ever ride with you?
No, he, after that, he got out of the car and whoever Miss Craig was on the phone with, and told me to drive around to Dairy Queen, and that was it.
Okay. And did you drive the car, or did Ms. Craig, or you took turns?
We took turns. I drove a little bit too. That's all I ever did was drove it around the corner. That's it, and got out.
Booney never drove it.
He never did.
Okay. All right. I didn't mean to jump in your space, Mr. Peoples.
Quite all right, Your Honor. It actually was very helpful. If you were to see Booney again, would you be able to identify him?
Yes, I will.
Okay. Do you know whereabouts he may reside or hang out?
Mostly in that area right there by Ponce and Boulevard area right now, and North Avenue.
And with law enforcement?
I just mostly see him hanging out most of the time. I run into him when I'm going to the store or something like that.
And if law enforcement was to contact you, would you be able to provide them with an identification?
Sure, yeah, I would be.
Thank you. That's all from the state, Your Honor.
Okay. Before I turn to Ms. Hardy to see what I can learn about Mr. Arnold's criminal history, is there anything that any of Mr. Woodall's family members wanted to share?
I believe, Your Honor, I spoke extensively last night with Ms. Dawn Gonzalez Woodall, and I also spoke with Ms. Melissa Woodall, and I believe that both are present, as well as I didn't speak with Ms. Linda Woodall, but I spoke extensively with Melissa and Dawn.
Okay, I've had the pleasure of speaking with them as well. In this setting, they were here in court when Ms. Craig entered her plea. But if any of those three, or if there's someone else who is affiliated, connected to Mr. Woodall and his family want to be heard, I'm happy to hear from them. They don't need to share again what they shared before. That is on the record, and I remember it. But that being said, this is a chance to open up about things that may be healthy. So if there are things that we ought to discuss again, I'm happy to do that. I don't think I did hear from Linda Woodall before, so there may be something she wants to add. But it's also okay if folks are done talking about this and are trying to move beyond the tragedy. So I'm going to leave it to you and Ms. Clark to navigate what we do next.
Yes, Your Honor.
Your Honor, may I please speak? This is Melissa Woodall.
Yes, ma'am.
Hi, I think that I'm a little bit confused about this case. I know that Ms. Craig was offered a plea bargain based upon her sharing information that might assist in this case. It doesn't appear that that's happened. And once Mr. Arnold accepts his plea, it sounds to me like this case is over. And it seems like it's been rushed. And it seems like, there are things that happened that aren't really being addressed. Like, help me understand.
So I can help you understand where we are right now. And there may be a discussion that you want to have with Ms. Clark, with Mr. Peoples, Mr. Jordan, who worked on the case before. Because I understand, I'm connecting with what you're saying. In some respects, this has moved too slowly. Mr. Woodall was found deceased in 2021, and here we are in 2023. In another respect, it seems like just a few days ago, we took Ms. Craig's plea, and it doesn't sound like she would have contributed a whole lot to yield Mr. Arnold's plea, but it's also not clear to me what it was that she would contribute. I haven't heard from Mr. Arnold much that is different from, inconsistent with what Ms. Craig had to say. But most of all, this is not an investigative setting. What you heard just a few moments ago was very atypical of the prosecutor examining a defendant during a plea, of me asking questions of the defendant, but this is not a typical case. And I think Mr. Peoples and I both, for different reasons, thought it was important to have Mr. Arnold share with us what he recalled about that situation. But this is not the forum for exploring why more wasn't done or too much was done or why didn't this happen. What I have before me is someone who is pleading guilty, and the state has, for reasons they can explain to you offline, decided that this is the right way to move forward for the state. They are dismissing the counts that relate to actually operating the vehicle, moving the vehicle around, and are focused on the counts that relate to Mr. Woodall and him being found deceased in the car and care not being rendered to him or for him. And that's where we are. So I don't say that to say, see, you should feel fine. You shouldn't feel fine because there may forever be unanswered questions. But I can't force Mr. Arnold to answer other questions. I've asked the questions that I had. It's not appropriate for me to let you or anyone else ask him questions directly. But there may be things that you share with the district attorney's office. And Mr. Arnold, as part of his plea, is agreeing to continue to talk with the state and provide truthful information about what he remembers about that situation. So I don't know how satisfactory that long answer was, but I want to acknowledge your concern, and concern tinged with frustration, but also to explain that this isn't the forum to say, now, wait a minute, district attorney's office, I'm confused or concerned or outraged or saddened or whatever collection of emotions might naturally be welling up.
Thank you. I guess these were the only two forums that I was allowed to participate in. So, it's kind of, I know it's been almost 2 years, but for me, it's been 2 years and now two hearings. But thank you. I appreciate it.
You're very welcome. And of course, these are the only hearings I've been able to participate in as well. There's a lot of work that goes on outside the courtroom. And I will encourage you again, you and your family members, to reach out to whoever the victim witness advocate is that you've been working with. I've been mentioning Ms. Clark's name only because she's the one who was on the screen. I don't know that I see her anymore, but you may have been working with someone else. That is the right point of contact to direct your questions, and then they can connect you with either the prosecutor handling the case or on up the chain of command if that's where you and your family want to go.
I was never given any information about a victim's advocate. This is the first thing I've heard of that.
Okay, and it may not have gone to you. It may have gone to Don Gonzalez Woodall. That would be a more direct conduit because
so let me stop everyone, because unfortunately the advocate services that were provided to me in the very beginning were not explained in that manner. They were more explained as support and guidance to get through this. It was never a situation where the advocacy team would funnel information up to the prosecutor, because at that time we didn't even have a prosecutor on the case. It was just a homicide investigation. So the explanation wasn't clear. So I just want to say that, because that makes a big difference in how to utilize a resource when you are given information that you can utilize them and how to utilize them, right? Then you take advantage of something. So that wasn't utilized in that manner.
okay, and no one else yet. That was Don Gonzalez Woodall. Ms. Rivers is trying to take all this down, and if people suddenly chime in and don't identify themselves, it's real hard for the court reporter. So that was Don Gonzalez Woodall, sharing an important perspective. I'm going to wind this conversation down because an important and meaningful critique of how this may have been handled from the victim advocate perspective, that is very salient. It's not going to change what we need to do today. I'm going to encourage you again, if you have a point of, if it's someone other than Mr. Peoples, and I'm not trying to protect Mr. Peoples, reach out to him. He will connect you with someone.
I am available, Your Honor.
Great.
For whatever.
Do they know how to reach you? Saying you're available and knowing how to reach you are two different things.
Yes, they should still have my numbers from when we spoke yesterday.
Fantastic. So my suggestion is whether it's Don Gonzalez Woodall or Melissa or Linda Woodall or anyone else, is reach out to Mr. Peoples and share your questions and concerns. If he doesn't answer them or doesn't connect you with the resources you're looking for, you can always let me know. I just as soon stay out of the mix because that's not my ideal role. But Mr. Peoples has a supervisor, and that supervisor has a supervisor, and everyone on planet Earth knows DA Willis. So there'll be someone you can go to if you feel like your questions aren't being answered. And I don't present it that way to suggest Mr. Peoples has done anything inadequate. I do, and I think you all appreciate this. He is coming in very, very late in the process, working with what was handed to him. That's not meant to make you all feel better because you've bounced from prosecutor to prosecutor. But I do want you to manage your expectations. If you press Mr. Peoples on something and he says, I'm sorry, I just don't know that. That's not because he is an unknowing person, but he's climbing a learning curve on this case. My time with him tells me that if he doesn't know the answer, he'll get you the answer, either by finding it out himself or connecting you with a person who has that answer. And so I'm not in any way trying to discourage you from pushing back with the district attorney's office saying, well, why not X? Why not Y? What's next? Have those conversations. Today, the focus is, am I accepting Mr. Arnold's plea? And if so, what is the sentence that he's going to get? So having said that, is there anything else that anyone else who is a family member or loved one of Mr. Woodall wants to share with me? And if so, identify yourself. Thank you. All right. I'm going to ask Ms. Hardy then from Pretrial Services to share with me information she has about Mr. Arnold's criminal history.
The defendant has 31 arrest cycles in Georgia beginning in 1997. Probation violations from 1999, parole violation in 2012, probation violations 2013, 2014, and 2021. Does Your Honor want to hear the felony convictions that are older than 10 years?
Hold on one second and let me see if sometimes there's a recidivist notice filed and I can just look at that and that saves a lot. No, I don't see one either. Why don't, if you give me a total number of felony convictions and then the specifics as in year and crime and jurisdiction of those that are less than 10 years old, that would be great.
Okay, bear with me one moment. Okay, so there are a total of 8 felony convictions. For the one that took place within within the last 10 years, that one was robbery in Fulton, out of Fulton County.
Okay, and when was that conviction?
2016.
Got it. All the 7 other convictions are all 10 years or older.
Yes, Your Honor.
Okay, thank you. Ms. Tucson, is Mr. Arnold on probation now for that robbery conviction?
No, Judge, it looks like she was, for mentioning that there's nothing on here. These are from like 1998. So there's nothing else that I see any sooner. They're like a Z docket number and a Y docket number.
Got it. Okay, those are very old. Anything with a Z, holy smokes. Okay, thank you. Ms. Feely, as long as you make sure that microphone is trained towards you.
So we do not want to minimize how upsetting and unsettling this is for the family, and they have nothing but our sympathy. When looking at this case from—
Hold on one second.
Sorry.
Is it working for you? They changed it.
I just texted.
He just texted it to you. Yeah, that's all right. Yeah, we got new codes. Thank you, Stanley.
When looking at this from a defense attorney perspective, trying to see what a trial would look like and what the state could prove in this case is something completely different. I'm not sure that the state could prove that Mr. Arnold was even with the decedent when he was deceased. I think the timeline is unclear.
It is a case, and I didn't quite distill it this way with Ms. Craig, that is morally offensive, but I don't know how criminally offensive it is. It's one of those of how could you, but in Georgia and in many states, there's not a duty of care in the sense that if you are walking down the street and there's someone who's having a seizure or is bleeding, you can walk by. Now, you can't drive their car around, but that's not what upsets folks, that a car was borrowed or misused. It's that someone was dying and nothing was done about that. But I understand you're looking at it through the lens of your profession, which is you're defending Mr. Arnold. And I think that's partly what's frustrating about this case for, I don't deign to speak for the Woodalls, but it's how I felt about it, that this person was allowed to die, and a call to 911 probably would have saved his life. And instead, people went to Wendy's. There's nothing good to say about that. But I don't know that that's a crime. That's something that is hard to reconcile when you die and meet your maker. But the Georgia Criminal Code, I mean, we had to go outside the criminal code. I'd never heard of the offense of abandonment of a dead body. To your point, I don't know that the evidence was that Mr. Woodall was deceased at the time Mr. Arnold and Ms. Craig were done with their free ride.
And I will tell you that Mr. Arnold feels the same way you do. And despite my trying to explain to him the lack of evidence in certain ways, he just does not want to put the family through anything else. And so even kind of over my legal analysis and advice, he has chosen to avail himself of this plea. And I am his attorney and respect his decision, and I understand exactly where he's coming from. As the court heard, he's 42 years old. He has struggled with drug addiction. In 2017, he completed rehab and was clean for until about 2019, he relapsed. In 2020, his mother died, and then he relapsed harder. And that's what led him to be in a position in his life to get in this situation. And he has nothing but sympathy and remorse for from what he's told me, I don't think that he was with these people very long, for as long as Ms. Craig was, but that be that as it may, and be that he wishes to accept responsibility for his part.
Mr. Arnold, were you using drugs at the time? And let me be more specific. Not were you taking drugs that same week, but that window of time when you and Ms. Craig were driving around in Mr. Woodall's car. Ms. Craig has already told us about what she was doing in terms of using drugs actively during that window. And she even shared some information about whether Mr. Woodall had been using drugs or not. My question is whether you were, and I don't ask this to say, oh, it's even worse. It's to also just put another piece of the puzzle together. Were you, whether it was smoking or shooting up or snorting or whatever, were you using drugs in the car, around the car, during the time that you and Miss Craig were using the car?
Right before she arrived at Domino's on Ponce de Leon, I had used some beforehand, but once I got with her, I didn't use none at that time during the duration of time. But yes, I had used right before she came.
So you got high just before. When you say came, meaning Miss Craig showed up in this car.
She showed up and pulled in the parking lot.
At Domino's.
At Domino's, the guys in the car, I guess slumped over in the car. She got out.
So Miss Craig is driving.
She was driving at that time.
Okay. Anyone else in the car or just Miss Craig and the guy you don't know who slumped over in the front seat?
At that time, it was just Miss Craig and Mr. Woodall at that time.
Okay. And what does she say to you?
I told her that I needed a ride to go where I was going to go and get some stuff and take it to another friend of mine.
Stuff meaning get some drugs, get some soap, get a book.
No, I wanted to go and do some shoplifting, as a matter of fact, to support my habit at the time.
Okay.
And I'll go and get some stuff and go and sell it to the dude. But when we were going around, it's like at that time of morning, it was like the stores were like closed or something, like 5 in the morning, and stuff like that. About 4:35 in the morning. So I never did get to do anything like that. So I went back and we ended up stopping at the windows. I was getting out. I got out and rummaged around a little bit more, trying to figure out how I can get me some more drugs, but that never happened. So she was on the phone at that time, and whoever she was talking to, she told me to get in the car and go and drive around to Dairy Queen, and that was it. When we got around to Dairy Queen, I got out the car and just started walking off. I just started walking off at that time.
So you were not mixed up with that car for very long. It sounds like you've described the whole, I mean, it's more than just the time it took you to describe it, but it was minutes, not hours.
Not that long, not even a full hour, not even a full hour.
Okay. And it was Miss Craig who pulled up driving the car when you were at Domino's.
Yes.
And why did she want you? Oh, you needed a ride. She didn't say, hey, get in the car. You said, could you take me somewhere for the reasons you've described?
Because by the way, she actually told me, she said something to the notion of the guys in there drunk and sleep. So I actually believed her. Crazy as it may sound, that I actually believed her. And
Okay. And I guess there was no space in the front, so you would have always been in the back, or did you say you drove a little bit?
I did.
What part did you drive?
Just at that part, just around. I just went around because as it states, it says it picked up the car on the reader at the stoplight. So I just went around to like a couple of stores in the area.
Oh, this is when you were looking to do some shoplifting and you were trying to see what was open.
Yeah, that was it. That's all I did. Just drove around and stopped. And then after we came back, I got out and I left. That was it.
Was Miss Craig in the car with you when you were doing that?
Yes, she was there the whole time.
Okay. All right. Thank you.
Yes, Sean.
Ms. Feely, anything else?
No, Your Honor, other than just his credit, which we can get on the record.
Sure. Mr. Arnold, what's the longest you've ever been in jail or prison?
No longer than 2 years. The longest sentence I ever had was 2 years. That was it.
Did you serve the full 2 or you were paroled?
I served the full 2 years and that was it.
Okay. Well, Mr. Arnold, I think that your lawyer has done an excellent job of representing you and describing how this has worked for you in terms of you not appreciating really what was happening, other than that clearly Mr. Woodall was not doing well. You're not a medical doctor, but it sounds like from some of the things Ms. Craig described, Mr. Woodall was not doing well. And now we know the results of all that, the tragic results. And I think you can understand the frustration of the family members you've heard from. I certainly do. I do find that there's a factual basis for your plea, so I will accept it. I also find that your plea is knowing and voluntary, meaning you've understood the things we've talked about and no one is forcing you to enter this plea. Is that correct?
Yes, Your Honor.
All right. Mr. Arnold, do you authorize someone from my legal team to sign the indictment indicating that you're pleading guilty?
Yeah.
Ms. Feely?
Yes, Your Honor.
And Mr. Peoples?
Yes, Your Honor.
All right. Mr. Arnold, I'm sentencing you pursuant to the Probation Options Management Act. And that simply means that while you're on probation, if you have a minor violation, you and probation will resolve that. But if it's more significant, meaning you're arrested, arrest on up, anything serious enough for you to get arrested, even if it's jaywalking, that comes to me and we'll work through the consequences.
All right.
I am going to sentence you on count 1 to 2 years to serve and on count 2 to 3 years probation, which will run consecutive to count 1. So it's a total sentence of 5 years to serve 2 with the balance on probation. A special condition of your probation is no contact with Ms. Craig. Obviously, no contact with the Woodall family. I think that'll be easier because you don't know them and you guys won't be around each other. But if you're out, you need to stay away from Ms. Craig. Ms. Feely, I am focused right now on some rehabilitation for Mr. Arnold. And I worry that a drug and alcohol evaluation in any treatment that's recommended will be about as effective as it usually is. And I'm wondering if what I ought to do is have as a condition, a special condition of probation that he be evaluated for admission into drug court. Obviously, if he's not accepted, that isn't a violation of probation, but if drug court accepts him at the conclusion of his custodial sentence, then it would be a condition of his probation that he enter into and complete that drug court. That's nothing that we've discussed as a group. You can't veto it, but you can counsel that that's a bad idea because or what.
So it would just be required that he be interviewed to see if he's appropriate?
Correct. And I don't know that drug court would accept him, not because of his criminal history and his current life situation. He's an ideal candidate for drug court. I just don't know how they would handle this case. Involves someone dying, not at Mr. Arnold's hands, but there's a deceased as a result of this. And so this could be one where they say, no, thank you. That's their prerogative. But that wouldn't mean that Mr. Arnold had violated his probation. Then we would revert to, okay, then evaluation and treatment as recommended.
And that's fine. And in the meantime, I can see if Ms. Patterson can go see him and see if there's housing or any other support he may need and rehab, obviously.
Sure. Well, drug court will provide housing initially. That's a nice part of it, so that he can get some treatment for the kinds of things that have gotten him mixed up in sad situations like this. Okay. I will talk with drug court about how that might be worded. So I may not sign the final disposition right away. It's not going to change things because while Mr. Arnold gets credit for the 468 days he's been in, that's not 2 years. So he'll be in custody for a while longer. Mr. Peoples, anything else in this matter?
Just, Your Honor, that to remind the.
There's another condition of your probation, and that's that you continue to provide truthful statements to law enforcement, including the district attorney's office. It may be that Mr. Peoples and an officer show up to talk to you about this situation. For example, they may have a picture of someone they think is Booney. You will need to meet with them and say, yep, that's Booney, or no, it's not, or they show you a photo lineup or whatever it is. You don't get to say, I'm done with this. I already pled guilty. It's a condition of your sentence to continue to truthfully cooperate. Now, let me give you one caveat. If you are somehow nervous that now I'm getting into an area, I don't want to get in more trouble, you can always say time out and we'll get Ms. Feely involved so she can hear what the questions are, because she might say, he'll answer that, but he needs some immunity because it gets into the fact that Booney brought drugs into the car, or I'm making it up. But I encourage you just to be open with the folks should people come talk to you about this situation. But if it's something that is making you nervous in that direction, then let them know that, and we'd pause and we'd figure out a way to get Ms. Feely to be with you when those questions are being asked. I don't think it would head in that direction because it's more of facts and who is Booney. And it's most of all closure for the Woodall family. They're going to have their own perspective about what happened, but I'll share with you that it's not my sense that you killed Mr. Woodall. That's not what this is about. But you and Ms. Craig both didn't take real simple steps. And we know Ms. Craig had a phone, 3 digits, 911, and we'd be dealing with a very different case.
Yeah.
So lessons learned there. All right, so that's the other condition of probation, is that you continue to cooperate with, which includes truthful statements to the district attorney's office and law enforcement in connection with the investigation into the death of Mr. Woodall. Okay?
Yes, sir.
All right, anything else, Mr. Peoples?
No, Your Honor, thank you.
All right. Ms. Feely?
No, Your Honor.
That's it? Okay.
And if we may just take a brief 5-minute
Yes,
before the last plea.
sure.
Thank you.
Oh, hold on 1 second. Yeah, Ms. Tucson, do you need to, Mr. Arnold's going to be in custody for a while longer. And do you have a place to go, or were you unhoused at the time this happened?
My brother, we over the duration of time, he putting a plan together. He lives out in Fairburn, and we will try to get their probation and stuff transferred over there and stuff. And he has a house out there where I'll be living at.
In Fairburn, Georgia?
Yeah.
Okay, but that's Fulton County, so nothing has to be transferred.
Yeah.
Ms. Tucson, do you need to give any reporting instructions to Mr. Arnold?
If it is in Fulton County, he will need to be, he'll need to report to Fulton. Would I be able to take down the address, Mr. Arnold, where he lives?
Do you have that address in Fairburn?
I don't have it on.
He doesn't have that with him.
Okay,
To get it to,
it's okay. I will just indicate on here that once released from sentencing, that you will report to probation. They'll give you information within the facility as well.
all right.
All right, thank you, Ms. Tucson.
We have one final thing. Ms. Nelson was asking about the credit, and it's my understanding he would get credit from August 28th of 2021 because he was revoked and transferred to the Department of Corrections, but he never posted bond.
Correct.
Not just the 2 blocks of time he was on Rice Street.
If he has been in continuous custody as a result of his arrest in this case, he gets credit from the date he first went into custody.
Okay, that would be August 28th, 2021.
8/28/21. Okay.
And is this a state sentence? Will I be sent to prison, or will I be released from Fulton County?
It depends how much time remains. The sheriff can decide, if I'm making the numbers up, but if there's 1 month left, probably don't get transferred. If there's 6 months left, you'll go to diagnostic.
All right. Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
All right, we're going to take a quick break. I recognize everyone has been a long day. It's almost 5 o'clock, but we do have pleas to take in Mr. Davis's case, and I promise I'll give everyone tomorrow off. I don't have any criminal stuff tomorrow, so we'll reconvene in 3 or 4 minutes. Is that all right?
Yes, Your Honor, I just want to make a quick call to the family and then I'll be ready to pick this up.
Okay.
Judge, yes, you do have something tomorrow. You have a plea.
Oh, that's right. So I'm not giving everyone, who has the Stillwell case? I think it's private counsel.
Private counsel, and I do believe Miss Willingham.
Okay. Miss Willingham never gets a day off.
I'll reach out to her. I think she's preparing, and if needed, then I'll step in, but.
Okay, I think she knows about it. I mean, it's been on the calendar for, I just forgot. I knew the morning was low key, but at 1 o'clock, we do have a plea.
Okay, thank you, Your Honor.
All right, 2 minutes. So what was Tuitt getting fussy about?
Because Mr. Melvin came in the back and when he wanted to just join him and her today.
Oh,
But you don't look like that.
but I want it.
I speak to the judge about it.
Okay.
He was better, I ain't kidding the code.
Oh. I guess my understanding of what it means to be stabbed is different from what stabbings are at the jail, because almost everyone, it's 20 or more. And I envision like, you get stabbed twice, you're dead. And these victims, like 23 times, 22 times. And so apparently it's not like a butcher knife in your heart 22 times.
So they shave it on the floor, so it's not really like 20 tips. We just get.
I mean, I wouldn't want one, but when I hear the 22, I'd like, your limbs are all attached and you got both your eyeballs. Like with like in the movies, it's like 1, 2, and
Most of the time it's not effective.
so it could be 22 and you're like, ow, that hurt, but it's not, you're not down for the count. Okay. Which sounds very dramatic.
Most of the time, most just want to get from Rush Street.
Right. It was interesting to hear from Ms. Brown that AC/DC is nicer than Union City.
I heard it was fixing Union City.
Yeah. The sheriff has said, I think it's Union City, where if you mess up, that's where you go. Yeah, so fixing up may mean like beds made out of like barbed wire and whatnot, but that's where you don't want to go.
I think that's the plan.
Yeah,
All the local heads would be.
yeah. That's smart. I mean, it's an empty facility right now. It's just the question is staffing. Ms. Feely, the Davis pleas are negotiated?
Yes.
What was the offer you got before? Because you jaw them, clunk, what? Wrong case.
It was to do 5.
To
And
do
I had already
5.
told him, yeah.
Holy moly. It switched.
That's why I thought that there was a mistake.
Yeah, there's a typo here.
Judge,
Yes, ma'am.
Ms. Beely, is she bringing the clothes for her client for Monday?
Yes, I actually was gonna ask Deputy Gordon about that. So his mom is getting him to my investigator who can get him here tomorrow. But what time?
What? We'll have a deputy here at 1. We're taking a criminal plea at 1.
1. The other thing, if that doesn't work out, is he can leave it on 5 and I can bring it early Monday. I know that's not as ideal, but
Well, he's the only one we've got on Monday. Dill is all that's left. So that's easier for you. Are you coming back?
Yes.
Okay. So, but having them in advance is good because when he makes landfall down below, they can get him dressed out and bring him on up. So ideally you get him here tomorrow. And the plea, it sounds like it'll take a little while. So between 1 and 2, someone they could even buzz back there, and someone could come get them.
so somebody's got to let us in there to put the clothes there, or where do they go?
Does our jury room key do that? Or if
As long as they're here on Monday morning, it should be good.
okay. I'll be back. I can be back to work early again. So I will see you Monday morning. As long as we get them from the investigator, I can put them in my office. It doesn't really matter where they are. I just connect with you and say, here are his clothes, and you get them decked out. Okay.
So I should tell him to come up here and just buzz and see who.
Yeah, I mean, ideally just walk into AD. If it's 1-ish, we'll be taking this plea. If it can't be, then I think someone's supposed to be here I won't be in until late morning tomorrow. But I think the office is staffed tomorrow. And so anyone could receive them.
Okay.
Yeah.
Were you able to print the?
Yes.
Okay, perfect.
All right, are we ready, Mr. Davis?
Yes, Your Honor, I just have a quick question on how the court does. I've not done one of these types of pleas before. Is it the court's pleasure that we read the sex offender probationary terms into the record, or is that something that is done.
You don't need to do that. Mr. Davis needs to sign a document that lists all the terms.
Right.
And that's how we get them into the record.
Okay. Okay, then I just referenced that he has signed and understands it on the record. Then.
And
Okay.
we've gone over them. He hasn't signed because there were a few that we wanted to discuss.
Okay, did something happen?
He's using the rest of it.
Oh, Mr. Davis. Okay, bad timing, but that's all right. Let's let him finish. So there will not be anyone here tomorrow except for me. I just learned. So in the morning, I don't think the courtroom will be open. So don't have them bring it over in the morning.
Okay. I'll tell him.
Someone will open it up before 1, so we can take the plea.
I don't have to go pick up the baby.
Yeah.
Just come home and do the play thing.
How old? How old is he?
He's 1. He'll be 2 in
Wow.
September.
Cool.
So I just like to show up and do the fun stuff, you know. Okay, so let me pull this up, and then we'll talk about Ms. Dyson whenever you get a chance to reach out to Rockdale.
Okay.
And kind of let me know.
Mhm.
I mean, like we said, it's left open because I know it may take you a while to.
We'll see if you're ready.
Where are we?
You ready?
You can come over here.
What's this right here? I can't even do it. Okay.
Ms. Hardy, while we're waiting on this, if you want to share with me Mr. Davis's criminal history, we can get you out of here.
Okay, I sure can. The defendant has 21 arrest cycles in Georgia beginning in 1993. Felony conviction in 2010 for possession of a Schedule I controlled substance. He received first offender treatment and it was sealed in 2017. And then another 2010 possession of cocaine, felony conviction. FTAs in 97, 99, and 2015. And that's all the history I have to report.
So two conviction, well, one was a first offender and then right after it, a conviction for cocaine.
Yes, sir.
Great. Thank you so much. Thank you
That
for
makes
all your time today. We will see you around.
Thank you. Y'all have a good day.
You too. All right, Mr. Peoples, you ready?
Yes, Your Honor.
And Ms. Feely.
Yes, Your Honor.
Let's go on the record with Mr. Davis's two cases. Mr. Davis is here in court with his lawyer. It's 14 SC, that's right, 14 SC 131703 and 23 SC 185766. Mr. Davis, in a moment, Mr. Peoples is going to put you under oath. Once you are under oath, please answer his questions and mine truthfully and completely. And please ask me or Ms. Feely any questions you have. If you don't understand what we're talking about or things are going different than you thought they were going to go, I need you to call a timeout and say, wait, I don't get this. Will you do that?
Yes, sir.
Okay, Mr. Peoples.
Yes, Your Honor. Mr. Davis, will you raise your right hand as best you can? You solemnly swear that the testimony you'll give in the proceedings before you today will be the truth, the whole truth, and nothing but the truth? Yes, sir. Thank you. Will you state your name, your true, correct, and legal name for the record? I didn't hear you say it again. Will you state your true, correct, and legal name for the record?
Ms. Feely, can you move the microphone towards your client, please?
John Fitzgerald Davis.
Can you spell it, please?
JOHN, Fitzgerald, FITZ, GERALD, Davis, DAVIS.
Thank you. Are you at this time taking or under the influence of any drugs, medication, or alcohol?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you?
58.
And what is the highest level of education that you've completed?
12th grade, sir.
You graduated from high school?
Yes, sir.
Okay. So you're able to read, write, and fully understand the English language?
Yes, sir.
Do you understand that you're charged with the following offenses in 14 SC 131703, count 1 of child molestation with a sentence range of 5 to 20 years, count 2 of enticing a child for indecent purposes with a sentence range of 10 to 30 years, and sexual battery with a sentence range of 1 to 5 years. And in 23 SC 185766, count 1, possession of a firearm by a convicted felon with a sentence range of 1 to 5 years. Count 2, driving while license suspended, which is a misdemeanor, 1 day up to 12 months. Count 3, DUI, driving under the influence of alcohol, less safe, from 1 day to 12 months. Count 4, possession of open alcohol container with a sentence range of 1 day up to 12 months. Count 5, failure to maintain insurance with a sentence range of 1 day up to 12 months. Count 6, knowingly driving a motor vehicle on a suspended or canceled or revoked registration, 1 day up to 12 months. And count 7, headlights not turned on as required with a sentence range of 1 day up to 12 months. Do you understand all of those charges?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, sir.
Do you understand that if you plead not guilty or remain silent and enter no plea at all, that you may receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, including in these indictments, including any potential defenses?
Yes, sir.
Do you need any more time to discuss this case with your attorney?
No, sir, I don't think so.
Are you satisfied with their services?
Yes, sir, very satisfied.
Counsel, do you waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment, including any with respect to your client's name?
We do.
Mr. Davis, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court will be a sentence of, Your Honor, in 14 SC 131703, the state would be moving to null pros counts 1 and 2. And he would plead to count 3. And the recommended sentence is 5 years probation. 1 second, Your Honor. 5 years probation, no further contact with the victim who will be named. He must register as a sex offender and follow all conditions of the sex offender registration. And in count 2, in 23 SC 185766, he will be pleading to count 1, 5 years probation to run concurrent with the 14 SC case, and counts 2 through 7 would be null pros, Your Honor. And
Okay.
I would include, I did not mention this to defense counsel, but I'd ask for a weapons forfeiture as well. Okay. You understand, however, that the court does not have to accept that recommendation, but the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes, sir, I understand.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea, that you have a right to withdraw your plea of guilty?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes, sir.
Do you understand that if you are placed on parole of any kind, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess nor use a firearm while on probation?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
There are certain rights that you give up by entering a plea of guilty, which include the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena the witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand all these rights?
Yes, sir.
Has anyone used any force, threats, or promises which has caused you to enter this guilty plea against your will?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charge in 14 SC 131703 to the charge of sexual battery?
I'm guilty.
I'm sorry? Guilty. And in 23 SC 185766 to count 1, possession of a firearm by a convicted felon.
Guilty.
Is this guilty plea given freely and voluntarily with full knowledge of the charges against you?
Yes, sir.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
You understand that unless counsel is substituted or permitted to withdraw, the defense counsel will represent you until either the end of the current term of court or 30 days from today's date, whichever is later.
Yes, sir.
I'm sorry?
Yes, sir.
You understand that you have only 12 months from today for a misdemeanor charge and four years for felonies to file a habeas corpus petition challenging the voluntariness of this guilty plea.
Yes, sir.
You understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea.
Yes, sir.
Do you understand that any of the filings that we've just discussed must be filed by your counsel unless you're representing yourself?
Yes, sir.
Have you had an opportunity to review the sex offender probation terms?
Yes, sir, I have.
With your counsel?
Yes, I have.
Have you signed them?
Not yet. We had a couple that we wanted to discuss before we sign, and my intern's going to grab another copy.
Okay. In the interim, Your Honor, I'll provide the factual basis.
You said when I'm ready or?
Oh, I said in the interim.
Oh, let's do that. Great.
I'll provide the factual basis.
Please.
Your Honor, if this had proceeded to trial, the state would expect to prove beyond a reasonable doubt that on June 6th of 2013, law enforcement were dispatched to 3015 Jonesboro Road Southeast at the Pure gas station on a suspicious person call. When they arrived, they met with the victim, Miss Sky, Skyy Parker Tate, Parker common spelling, dash Tate common spelling, who reported that after a fight with her mother, she left her residence in Forest Park, Georgia, was walking in the area of Jonesboro Road when she was approached by an unknown Black male in a red Mustang, later identified as the defendant, Mr. John Fitzgerald Davis. He asked if she wanted to go with him to get something to eat because she looked down. The victim accepted a ride from the defendant, who took her to get some food and then to a clothing store, the Rainbow store located at 2685 Metropolitan Parkway. He then stated that he needed to get something from his house at 438 Holly Street, and the defendant took the victim into his room where he felt her breasts and vagina over her clothing. He gave her soap and a towel and asked her to come take a shower. She declined, and while the defendant showered, the victim left the home and ran south on Jonesboro Road. When the victim reached the gas station located at 3015 Jonesboro Road, the defendant again pulled his car alongside her and told her to get in. The defendant then grabbed her by the arm, attempted to force her into his vehicle. She ran inside the gas station, and bystanders contacted and intervened, and the victim was able to call 911. Officers attempted to question the defendant at the scene, who stated that he, quote, did not mess with the victim and called her, quote, jailbait. The defendant corroborated all the details of the victim's statement, but stated he entered the shower alone. And when he got out, he realized that the victim had left the residence. Witness statements were obtained from the individuals and other bystanders on the scene. And that's all from the state, Your Honor. That's all.
How old was Ms. Parker Tate at the time? You may have said that, but I didn't get that.
At this time, Your Honor.
Not today, but in June 2013.
Of 2013. She was 13 years old at that time, Your Honor.
Thank you.
And while additionally, while this is not my case, I know that this is Attorney Shapiro's case, Your Honor, and knowing his ultra preparedness, I'm sure that he has spoken with the victim in this case, and I am confident that this recommendation is one that they would want and that he has worked very diligently on.
Okay. I'm not, are you going to give the factual basis for the other case, or?
I'm so sorry, Your Honor.
That's okay. Or do we want to pause and talk about the conditions of probation?
I think that shouldn't take very long. Can I approach with?
Okay, sure.
So he went ahead and signed it, and there's just we want to discuss.
Okay, so I'm holding the special conditions of probation form. Mr. Davis is, can you guys do it again? This is for the wrong docket. This is the 23 SC.
Got it.
Or if you don't mind, I could strike through it and write the 14 SC on it. Actually, he didn't check any of them. Should I go through and check the ones that should apply, and we can discuss the conditions that don't?
Yes, the only ones were number 9, the 900 numbers, number 15, alcohol, and number 18, driving while.
Okay. Hold on one second. So you said 9, 15,
And 18.
and 18. Okay, I'm gonna check all the others. I don't have an issue with excluding no alcohol at all. In other words, that's not a condition. I don't know that there are still 1-900 numbers, but that's not the issue here. So if that's your thing, you can call 1-900 numbers and use a post office box, and you do not need to keep a driving log.
Okay,
Okay.
yes, sir. Thank you.
All right, let's talk about the factual basis for the 23 SC case, please.
Yes, Your Honor. On October 28th of 2022, law enforcement was on patrol in the area of 121 Cleveland Avenue, in Fulton County, while traveling southbound on Brownsville Road. They observed a gray two-door vehicle stop in the roadway with the vehicle side door open. They pulled behind the vehicle and it then began to drive away without any lights on. They attempted to perform a traffic stop. The vehicle, it was a 2005 Honda Civic. It did not immediately stop and rolled approximately 25 feet. While the vehicle was moving, law enforcement could observe movement within the vehicle. Once it did stop, they exited their patrol vehicle and approached the motorist from the passenger side. They encountered the driver, was identified as Mr. John Fitzgerald Davis, and he stated that he did not have a driver's license. He was detained. His gait was unsteady, and when he spoke, his breath emitted the odor of alcoholic beverage. He admitted to consuming an alcoholic beverage prior to driving the vehicle. During the investigation, they discovered that he did not have a driver's license due to several failures to appear. He was given the opportunity to participate in a field sobriety test, which he declined. When the vehicle registration plate was checked, the vehicle was found to have no proof of insurance and the vehicle registration was canceled. Prior to the vehicle being impounded, it was inventoried, and during an inventory of the vehicle, a loaded Smith & Wesson handgun was found underneath the driver's seat. Counsel, do you stipulate there's a factual basis for the plea in both of these cases?
We do.
Thank you. Ms. Salton State.
Okay, and I got the criminal history. So Ms. Feely.
Thank you, Your Honor. This, Mr. Davis is 58 years old. The first case that was talked about is very old, and there's no physical evidence. There were no allegations there was anything more than touching outside the clothes. This is one that it usually takes us getting this far before we all kind of realize that this would be a difficult case for the state to prove at trial. And I think Mr. Shapiro did realize that, and that is shown in what the offer ended up ultimately being with the case with this age and these types of allegations. But Mr. Davis is 58 years old. He's a high school grad. He kind of in Florida. He was kind of from Florida and Georgia, both his parents. He does industrial coating and blasting and has done that for quite some time for different companies. He's a lead of a team that does that, sandblasting and coating of tanks and barges and water towers. He is single. He's got 3 children, 1 grown daughter in Florida, and then a 14 and a 16-year-old. So we are asking the court to accept the state's recommendation.
Okay, Mr. Davis, anything you want to add?
No, sir. I think she covered everything.
Well, we'll cover where home is in a minute because you'll talk with Ms. Tucson from probation about where you'll be living when you get out. But is that in still the metro Atlanta area?
Yes, sir.
Okay. All right. Well, Mr. Davis, I find there's a factual basis for both your pleas and that your pleas are knowing and voluntary. Voluntary meaning no one's forcing you to do this. You've decided to do this of your own free will.
Yes, sir.
And knowing meaning you've understood everything we've talked about. Also true?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. All that means is that while you're on probation, which you will be for 5 years, if you have a minor or technical violation, you'll work that out with probation. But if it's more serious, you get arrested again, or you violate a special condition, that comes back to me.
Yes, sir.
Mr. Davis, may someone from my court staff sign the indictment on your behalf, the indictments on your behalf indicating your guilty pleas?
Yes, sir.
Ms. Feely?
Yes, Your Honor.
And Mr. Peoples?
Yes, Your Honor.
Great. Mr. Davis, you understand that as a result of your plea in the older case, you'll be required to register as a sex offender.
Yes, sir.
That will limit where you can live. You cannot live too close to a school or a park or a church. But as long as you're far enough away from one of those places, you can live where you want. It will also limit the kind of work you can do. It will not affect someone who does industrial coating and sandblasting. But if you decided you wanted to run a nursery school, you could not run a nursery
Yes,
school.
sir.
Understand?
Yes, sir.
Okay. In 14 SC 131703, the state has dismissed the first two counts. I will sentence you to 5 years on count 3, sexual battery. I will probate that. A special condition of your probation is no contact with Ms. Parker Tate. My guess is you haven't seen her for over 10 years, but if you know who she is and where she is, stay away from her.
Yes, sir.
And you'll also need to register as a sex offender and comply with all the special conditions of probation for sex offenders that we talked about, minus conditions 9, 15, and 18. And I spelled that out on the form. In the case of 23 SC 185766, count 1, I'm sentencing you to 5 years to serve for possessing the gun as a convicted felon. I will probate that. I will run that at the same time as your probation in the other case. All other counts are dismissed. 2 special conditions in the 23 SC case. 1, you forfeit the Smith & Wesson firearm. It's gone. It's not for you anymore. Can't have it anyway. And 2, you will submit to a drug and alcohol abuse evaluation. And a professional will talk to you about that. If that person recommends any treatment, AA meetings, or who knows what, that treatment becomes a part of your probation.
Okay.
Mr. Peoples, anything else in Mr. Davis's 2 cases?
No, Your Honor.
Ms. Feely?
No, no.
All right, Ms. Tucson, you are all that stands between us and the end of the day. What do you need to get from Mr. Davis? He will be getting out in the next couple days.
Hi, Judge.
Hi there.
Since this is SPS, he will have to report right away, which would be Wednesday.
Wednesday of next week.
That is correct.
Okay, so the 14th.
The 14th, yes. And that is at 8 a.m. And I also, Ms. Feely, if you could send me the police report for this case, because I have to send these cases to the field office in a different format.
Yes.
Do we have the police report from 2013?
Scan it and send it to her, yes.
Okay, great. We will get that heading your way.
Okay, sounds good. And Mr. Davis, where will you be living?
At the 438 Holly address.
438
Holly Drive.
Holley.
HOLLYDR Drive.
No E.
Okay. City and state?
Atlanta, Georgia. 30354.
And a good phone number for you?
Probably be my sister's number for right now until I get a phone.
That's fine. What's her name?
Dorothy Reynolds.
Dorothy Reynolds. Okay, and her number?
404-951.
Okay.
4321.
4321. Okay, make sure you make that appointment on Wednesday at 8 a.m. if you're released this weekend. Okay. If
Yes,
you're not, I'm sure Miss Feely will reach out, but you will need to report that if it's before Wednesday, if it's not before Wednesday and it's after Wednesday, you're gonna still need to come up to 276 because we are open Monday through Friday. They'll show you checked in and then they'll have you come in the next Wednesday.
Okay.
Is that it?
That is it.
All right, Ms. Tucson, thank you for the long day.
No problem.
Ms. Rivers and Ms. Nelson, thank you both. Ms. Nelson, you and I will do some work tomorrow on all these outstanding final dispositions. And I will see or hear Ms. Nelson and Ms. Rivers tomorrow at 1. Thank you, everyone.
Thank you, Your Honor.
And this is the Memorial Drive
Thank you.
location.
Have a good